voice from there, Mr. Katz. And switch it on, please.
On behalf of the African Transformation Movement, the second applicant, I appear, my name is Katz, together with Mr. Mahambi and Mr. Piramal Sami on the instructions of Asheson's attorneys, Mr. Jared Kay in particular. Thank you, Chief Justice.
Thank you,
and other
Mr.
justices.
I please the court. Together with Mr. Tofi, I appear for the first and second respondents.
The Speaker and the National Assembly.
Yes, Chief Justice.
Thank you, Mr. Breitenbach.
Chief Justice and members of the court, I appear on behalf of the President, the third respondent, who is my learned friend, Mr. Lutuli.
Thank you, Mr. Patleng.
May it please you, Chief Justice, and the members of the court, Ms. Sigalala, Ms. Casey, and Mr. Kwabe, and I appear for the ANC.
Thank you, Mr. Ngaitwa. I count a number of condonation applications with each party having one under his belt. The ATM's submissions were late by a day, but nonetheless late. The President's answering affidavit was late. The ANC's answering affidavit was late. The Speaker and National Assembly's affidavits were late. And the EFF filed its reply to the ANC's answering affidavits late. As I understand it, none of these condonation applications are opposed.
Chief Justice, that is my understanding as well, subject to anything that my learned friends say.
Okay. They are granted.
On behalf of all of the parties, we are indebted, Chief Justice.
All right. You may proceed, Mr. Premier.
Thank you, Chief Justice. Chief Justice, members of the court, what we're really here about today is something actually very simple. The EFF submits that over 10 million rand hidden in a couch is as problematic and controversial for a president as benefiting from unlawful upgrades to his residence in northern KwaZulu-Natal. And so, having regard to this court's judgment in EFF 2, the submission is really simple before the court, with all due respect. The first one, and these are the broad overarching submissions we say the court needs to concern itself as we go through the various issues that will be contested between the parties. The first one is this. It's whether or not the reasons offered by the National Assembly when it voted down the independent panel's report withstands legal scrutiny. Now, what has happened in this matter is there have been two bundles of reasons that have been advanced before this court. The first bundle of reasons are those reasons that were given at the time by then Minister of Justice, Minister Lamola, in the House and is recorded in Hansard. That is, can be found at EFF Annexure 6, which runs on to 2 volumes, if I'm not mistaken, and I'll take the court there in due course. And effectively what Minister Lamola's reasons are is that the panel misconstrued the threshold it had to apply. And he, and developed by our learned friends for the ANC in argument, seek to draw this distinction between sufficient information, and prima facie evidence for the purposes of an impeachment motion. And what we will submit to you, and when the court considers this argument, is that insofar as that is a reason as to vote down the report, it's not a legally cognizable reason. And it's not a legally cognizable reason. I see the acting Deputy Chief Justice raises his eyebrows at me. It's not a legally cognizable reason, ADCJ, for this simple fact. And that is that there is binding authority which tells you that prima facie evidence exists on a spectrum, and that the objective to find prima facie evidence for the purpose of a motion is not to subject the initial sifting mechanism done by the panel to the same threshold as actual guilt. It's something lower than that. And to the extent that the panel engaged with sufficient information and prima facie evidence, the panel discharged its responsibility accordingly. And that's why that reason, insofar as that is the principal reason in front of you is concerned, that's no reason at all. There are some reasons which have been introduced, particularly by the President and the ANC in this matter, where they've talked about various things being, which I am loosely going to say, they characterize as the report being fundamentally flawed. They actually use that phrase in their pleadings and in their heads of argument at various points. And the argument, as we understand it, seems to be that never mind the sufficient information versus prima facie evidence issue, which I've already addressed in passing, is that this report was so fundamentally flawed that it had to be voted down because of how nonsensical or misconstrued or misapplied it was. And what we say is that it's trite that those reasons which find their way before this court, not in Mr. Lamola's words when given in the House, but under Mr. Figile Mbalula, the Secretary General of the ANC's answering affidavit filed in this court, that that's an ex post facto justification and that's too little too late. And in any event, even if those reasons were competently in front of the court, which they aren't, because the court will know that none of the respondents seek a collateral challenge of the report in any way whatsoever, that those reasons cannot be relied on the court to justify the National Assembly's reasons for voting in the way it did at the time that it did so. So that's the issue of whether or not the reasons are sufficient in the context of that debate, and that implicates all sorts of other underlying issues like rationality of the decision and so on, and I'll develop those in a short period of time. The second overarching consideration that we say is important for this court to bear in mind is this. jurisdiction, issue 1. I can't remember what the next one was according to the ConCourt's tweets yesterday about the 6 issues that the court is facing, but I don't take that as binding. So the second one I'm going to move on to is the issue of declaratory relief. Can I just say this about declaratory relief? Because how the debate has unfolded before the court is in this way. On the one hand, what we say on behalf of the EFF is this is a declaratory application. It's a classic 1721A, 1721B type of application, which this court will know from Rail Action Commuters Group, I beg your pardon, is a flexible remedy that has the ability to apply to a wide variety of situations, including ones where a review may be competent. But just because there might be some overlap between a declarator application and a review application doesn't mean that a litigant is forced necessarily to choose one or the other. And particularly in circumstances here where there's no subsidiarity issue, such as Paja standing in our way, then we say that that distinction is even less cogent in the context of this debate because of the way in which the court has already understood declarator applications to apply. And may I just make this point about declarator applications? The court will know that we rely on the Naptosa judgment, which, if I'm not mistaken, is a full court judgment from the Western Cape High Court. And what the full court there says about this review declarator distinction is it says the following. It says that in matters like this one we would submit, where a record is not necessary, then a declarator can play the role of a review. But what we would submit is the opposite is not true, and that you cannot then magically manifest a review into a declarator. So why I'm saying all of this is because to the extent that our learned friends think that there's some magic in this distinction and that they can non-suit us because we chose a declarator as opposed to a review, we say with all due respect that's neither here nor there, that distinction is a false one. And to the extent that they advance that, there's no cogent argument which suggests that this somehow falls outside the scope of what a declarator is interested in. The court will very well know from Cordian trading what the two-part test is for a declarator application. The first one is the decision regarding the contest of rights and future and contingent rights. We say we tick that box. And then the second leg is whether or not the court should grant the remedy in its discretion. We say we tick that box as well for the reasons that exist on the papers. So insofar as this argument is overly emphatic about the modality is concerned, modality of declarator versus review, we say that that's really not the end of the debate. In fact, it's not the true debate at all. And to the extent that the debate needs to be answered, the answer is that this is perfectly competent for a declarator application to do. Let me then go to my next topic in oral argument. And perhaps what is an appropriate thing to say to the court now is that as I'm developing my oral argument, I'm obviously emphasizing some issues over others. That's not to say I abandon any of my written submissions, and when the court, when the floodgates open for the court to ask questions, I will obviously have to defend everything that's on paper and not just what I said in my oral argument. But let's just talk about the rule, about the rules, because this speaks to the lawfulness of the decision. It's an important thing that I need to clarify for the court right at the very outset, because what the respondents variously do is they overemphasize our case, the case against us. What they say we're asking this court to do is we're asking this court to sit as the impeachment body. And we're inviting the court to make findings that will make its judgment equivalent to the impeachment body. That's absolutely not what we're doing. The National Assembly, in terms of Section 89 of the Constitution, is the body that will ultimately impeach the president. That is not contentious, and the EFF is not asking for anything different. Instead, what we have to bear in mind is, following on from EFF 2, the National Assembly chose to create a mechanism that gave expression to its accountability obligation. And there are 3 levels to that rule. The first one is the referral of the complaint to the independent panel, and the independent panel doesn't have an open discretion to consider oral evidence and the like. It only considers written evidence. And when it considers the written evidence, it answers only one question. Is there a prima facie case to answer? Now, why that's relevant is because before you can go to the second level of the National Assembly's rule, which is a referral to the impeachment committee, the National Assembly itself has not retained some kind of overarching discretion that allows it to engage the panel's report beyond the content of the panel's report. And indeed, what we would suggest is that the ANC in particular, and the President's attempts to sneak in what we will call traditional review grounds into their answering affidavit to try and evidence how bad this report was, violates or misunderstands and therefore violates the role to be played by the National Assembly at the point of when prima facie evidence is considered. Because the National Assembly, by electing to adopt that rule, fettered its otherwise very wide discretion to do whatever it wanted to, and limited itself only to consider whether there is prima facie evidence or there isn't prima facie evidence. So all the other reasons that are in front of you in terms of the rule are incompetent reasons, because they're not reasons at all, and to the extent that the only reason in front of the court is this alleged distinction between sufficient and prima facie, we say is no reason at all for the reasons I've already given you. So to the extent we are now in the world of questioning whether or not the National Assembly has given effect to its obligation or hasn't given effect to its obligation, that's what the court must bear in mind. At the preliminary stage of the investigation, all the National Assembly is asked to do is to vote yea or nay, does prima facie evidence exist? And we say that for the reason that the National Assembly chose, they chose the wrong reason, and the consequence is that the vote to vote down the panel's report is an unlawful outcome because of the misapplication. And can I just say, whilst I'm on this subject and noting the time ticks quite quickly, this is not something new. Some of the members of the court may be familiar with the DA versus SABC litigation in the time of the public protector, before this court confirmed that the public protector's reports are binding. You will remember that in the High Court in that matter, Justice Skippers, when he was in the High Court, effectively said that a recipient of a public protector's report would be entitled to depart from it if they had rational or reasonable grounds to do so. So in Justice Skipper's construction, there is no binding effect, and the reposit or the recipient of the report could depart from that if they had other rational or reasonable grounds to do so. In English law, those are called the Wednesbury rules, which comes from the judgment of Bradley in the Court of Appeal. That being said, though, what the SCA did is the SCA said, no, that's not how public law works in our constitutional dispensation. The repository of public power is only entitled to do what the enabling instrument tells them to do. So on the specifics of that case, the SCA overturned Justice Skippers and said the public protector's report is binding, you have to effect it. But critically, if you want to depart from the public protector's report, you have to review it and set it aside. And that's what applies here. It's not open to the National Assembly to look at the panel's report, which says there is prima facie evidence, there's a case to answer, and for the National Assembly in its wisdom to say, oh, well, you didn't meet your mandate, you didn't follow your mandate, you didn't have oral evidence, you considered hearsay evidence, and all those kinds of reasons to rubbish the report. In circumstances where the reasons to rubbish those report misidentify what the panel was entitled to do at the time it did it, and consequently what the National Assembly was entitled to do when it received the panel's report. And so we would say that what we're asking for in this matter here is nothing too dissimilar from what the court has already done in matters like DA versus SABC, and understanding the interplay between a repository of public power and what they can and cannot do vis-a-vis the enabling statute. Can we just also say this then, regarding the rule and the reasons and what has come through? What we would just identify for the court is the following, and it's an interesting debate that has opened up between the EFF and the ANC, surprise, surprise. But the interesting debate is about what is the role of politics and political instruction in the context of the debate. Now, I have to answer this in a bifurcated way, because you'll remember At the time the vote was taken on the floor of the House, politics didn't have a role to play. It was only the sufficient information versus prima facie issue, which I've dealt with already. But what we know in terms of the ANC's answering affidavit is there's a myriad of averments made about how the ANC internally consulted, how they took legal opinions, how that legal opinion told them that there were various flaws in the rule, that they should stop the investigation pending the outcome of other investigations, and so on. And those were all from a political basis, because you'll remember they also say President Ramaphosa recused himself from the NEC discussion, the NWC discussion, and all those other discussions. Well, that's all fine and well. The short point is this, is that if there is a space in which the ANC's arguments that political instruction in a matter like this is permissible, then the ANC is confronted by what this court said in UDM, and that is that in an instance of a clash between an individual MP's political allegiance to their party and their constitutional obligation in terms of their oath of office, it is their oath that must succeed. And we'll say on the application of that UDM principle to these facts, not only has the ANC told you that they took the reasons for they took the reasons that they did for political reasons, which is in conflict with UDM, it's also that to the extent that the ANC then relies on those reasons have already been found to be unlawful, having regard to what the court has said in EFF 2 and the potential of political abuse under the abuse of a numerical majority. So we would say that when the court comes to consider this question and reads UDM and EFF 2 together, that is what fundamentally undermines the argument that the reason and the conclusion reached is a justifiable one. And to the list of authorities, UDM as well as EFF2, we'd also add the two other parliament cases about the rules and numerical abuse, which is Mazibuko and Oriani Ambrosini, which this court is aware of. The principle that was vindicated in both of those matters is that where rights of MPs are subject to the will of the majority, the potential outcome is an unlawful one because the majority can rely on its numerical strength to undermine the role to be played by MPs. In Mazibuko, it was about the tabling of the motion of no confidence. In Oriani Ambrosini, it was about how a private member's bill comes out of committee onto the floor of the House. And the court there was emphatic that where those internal rules of Parliament seek to undermine the role to be played by MPs and Parliament itself, in terms of the Constitution, those rules are to be regarded with a high degree of skepticism because they threaten unlawfulness. And we say that that logic applies here in these proceedings. May I just refer the court to two sources of authority. The first one is that even though the Rule 129 at various points interchangeably uses sufficient information and prima facie evidence, we would say that that interchange is not objectionable. And the reason it's not objectionable is because of the Magwakwa authority that we've referred the court to. If the court has our heads of argument to hand, it's at internal page 31, para 114 of the EFF heads of argument, which says, there are varying degrees of prima facie evidence. It can consist of incomplete evidence, for example, a single piece of circumstantial evidence. On the other hand, it may be strong prima facie evidence. Prima facie evidence at its weakest is sufficient evidence to institute a prosecution. So to the extent that there's this distinction between sufficient information and prima facie evidence, we say that it's not a distinction because these things exist on a spectrum. And to the extent that that argument is pushed at, we say, well, the Magwakwa authority is the fullest of answers. Can I also say this regarding the role of politics and political reasons that were involved in decision making? Now, there's some dispute regarding Minister Mantashe and his capacity as the ANC chairman, and did he threaten or didn't he threaten, and is the EFF being speculative about these things, and if so, can the court have any regard to that? All we'll say on this subject is we're doing no more than what Justice Justice Moseneke apologies, and Justice Cameron said at paragraph 234 of their Glenister judgment, where they said sometimes the harm that can be accrued in rule of law harms is too little too late to be vindicated by means of judicial review. And instead, what is the appropriate course of conduct is by a litigant insisting that the structure that is in place is lawful ab initio, because the correct lawful structure acts as a fettering mechanism on the abuse of an overly wide discretion, particularly where political reasons may be relied upon. And so we say, even if, as a matter of evidence, this question about what Mr. Mantashe said or didn't say is an issue in front of the court doesn't have to go that far, because you've already got the authority from Glenister, which tells you that it's the structure that counts more, or often counts more than anything else. So we'd say that to the extent that political reasons are on the table, that's the answer to there. Which leads me on to the next subject, which is the need for the amendment. And with less than 3 minutes to spare. The need for the amendment we deal with on the papers. I'm not going to advance that at any given length. The short point about the need for the amendment is this. If Parliament is given an unfettered discretion in the way that it currently is, then cases like this, which we say are deserving cases, will be voted down. And either it will be voted down for spurious reasons, the distinction issue which I've dealt with already, or political reasons, which we learnt about through the ANC's affidavit. And unless that discretion is therefore constrained, and you know that in terms of the relief we seek two alternative amendment relief. It's either that the first stage becomes automatic, so in other words, where a panel says prima facie case box ticked, then that must automatically go to the committee, and the committee decides innocence or guilt. Or we say that Parliament must go and amend the rule to include factors, because those factors will then appropriately fetter the discretion that Parliament brings to bear when it makes this decision. So that's the amendment, really, in a nutshell. And then if I may just talk about remedy in the last few minutes that I have remaining, the court will know that there are, again, two alternative effective pieces of relief that we seek in the context of this report, resolution, and decision. The one, which is perhaps the slightly more controversial one, is the substitution relief. And there, the argument against us, I see Justice Matopo is smiling, where the argument against us is that this is an unlawful breach of the separation of powers. We say that that's not correct. All the court is doing is it's using the same kind of substitution parameters that exist in other matters where the court substitutes in order to reach that particular outcome. But of course, if the court is not minded then to grant the substitution relief because of the separation of powers concern, which we say with respect is no concern at all, then we ask that the matter be referred for a de novo decision. And insofar as there might be any alleged problem with both of those issues are concerned, we've already addressed that on the papers to say that when the decision like that is set aside, the status quo ex ante is what is restored, which means that the 7th Parliament is in as good as a position to determine the motion as the 6th one, because it's not the identity of the decision maker that matters, it's the decision maker themselves being in the same position to make that determination. And then lastly, on the issue of costs, we ask Biowatch. Chief Justice, those are my submissions.
Mr. Premier, when I'm not speaking, and in order to make sure that you won't try to read my facial expressions, I will look down.
I'm entirely in Justice Madlanga's hands.
Mr. Premier, I've understood the EFF's case, and you'll correct me if I'm wrong, to mean that the National Assembly's involvement should only be at the stage where the impeachment committee comes to it, that is to the National Assembly, with a recommendation. Otherwise, before that, there should be no participation at all. or not?
May I respond, Justice Madla? Insofar as we ask for the relief about the amendment of the rule is concerned, the automatic referral from the panel to the committee, Justice Madlanga is entirely correct. That's right. And the reason we say that is because the panel plays the sifting mechanism. It's premature to allow the National Assembly to either up or down that vote at that stage, and that the National Assembly still retains its full rights to determine the President's innocence or guilt, both at the committee level and then at the final resolution level.
And how does that square up with what this court said at paragraph 180 of EFF 2?
Will you bear with me?
Let me just read.
Yes, please, Justice Madlanga.
Therefore, any process for removing the President from office must be preceded by a preliminary inquiry during which the Assembly, that is the National Assembly, determines that a listed ground exists. The form which this preliminary inquiry may take depends entirely upon the Assembly. It may be an investigation or some other form of inquiry. It is also up to the Assembly to decide whether the President must be afforded a hearing at the preliminary stage. Surely, if it only comes at the stage when there is a recommendation that says impeach, there will be no preliminary involvement by the National Assembly whatsoever.
No, Justice Madlanga, I don't read paragraph 80 in quite the same way, with all due respect. The National Assembly is still involved because, remember, the panel doesn't have an independent existence. It's not a separate Chapter 9 body, for example. The National Assembly's involvement is the adoption of the rule, which in part delegates that sifting function to the panel. So we would say, to the extent the National Assembly, in terms of paragraph 180, needs to be involved at the preliminary stage, the fact that it chooses the mechanism that it did ticks that box. What we are saying in the context of the relief that we seek, particularly the amendment relief, is that if, however, you allow that involvement to descend into the merits at the prima facie stage in the way we've articulated it in the papers, that's where the danger that is identified in EFF 2 arises, because of the preemptive strike, effectively, that the majority could take against a panel report that says there's a prima facie case to answer. And I apologize if this answer is a bit long, but it's important to distinguish these things. We are saying that the National Assembly's involvement from a mechanistic perspective is not ipso facto bad, but there has to be the presence of some or other constraint on an otherwise unfettered discretion, because if you don't constrain that discretion, you get the outcome that you have here. And the National Assembly then obviously still maintains its involvement in the matter, both at the committee stage and then at the plenary stage when the resolution is voted on, as I've mentioned before.
But I would have understood that the National Assembly is the full National Assembly. And if reference is made to some preliminary stage at which the National Assembly is involved, the National Assembly, qua National Assembly, not some committee of it, should be involved. I would have thought so.
Yes,
unless you want to say a committee of the National Assembly is exactly the same thing as the National Assembly.
I think I now understand the ADCJ's question to me, and I ask for forgiveness if I misconstrued it. I think where we are at odds, ADCJ, is that at paragraph 180, the court was not being prescriptive. What the court was saying is that these are the considerations that the Assembly must take into consideration when it designs whatever its mechanism is. And that's why we have the Rule 129 in the way in which we have it. What we are saying is that that rule perpetuates the very same problem that was identified in EFF 2, with the consequence that even though the mechanism exists as it does, that may in and of itself be problematic for the reasons that we've identified. So we are saying that where the National Assembly chooses itself, qua assembly, to delegate that power to the panel, that's the National Assembly still being involved. Yes, the panel is exercising its independent right to determine the outcome, but the source of its authority is not something free-floating in the air. The source of its authority is the Assembly itself. And so where we are debating is whether or not the mechanism chosen enhances the principles of EFF2 or retards it. And we would say that the current design of the mechanism retards the accountability function because it allows the Assembly to have the preemptive strike in the way I've described it.
Now let's test your argument on the political shenanigans that you say a majority party would engage in to protect its leader.
Yes.
Why can't that, or why won't that happen even at the late stage that you advocate, the last stage that you advocate?
Yeah,
it will still happen.
No,
So what's the difference?
No, I fully agree. But may I answer this in two ways? Insofar as the mechanism that is chosen is concerned, we would simply say that there is, on a proper reading, a degree of fettering, but to counteract the potential of interference, the rule needs to be more explicit in terms of how it counteracts that potential for political interference. So either that it's the automatic referral from the panel to the committee, or when the National Assembly decides on the panel's report, its decision is not one framed in the widest possible terms as a discretion, but is specified in terms of factors that the Assembly itself chooses, which would limit the ability to exercise that discretion. So that's the first point. The second point then is, as this decision, as this report makes its way through the decision-making chain, what that means is the ability for the National Assembly to rely on these political reasons to vote down a report or vote down a resolution or a recommendation at the end stage is concomitantly lowered because of the proper filtering mechanism that is being played by both the panel and the committee on the proper operation of the rule. Now, I suppose in the worst case scenario, Justice Madlanga, the difficulty I have is this, is let's just say the panel did its job, it found a prima facie case to answer. By some miracle, the majority in the National Assembly said, yes, okay, send it to the committee. The committee then has a full hearing where it tests hearsay evidence, it cross-examines, it does all of those wonderful fair trial rights that it's supposed to do. And the committee itself then says, yes, we think that this president needs to be impeached. And then it goes to the National Assembly, and the National Assembly says, no, this is absolute rubbish. We are going to not impeach this president. That has no ouster effect on this court's ability to test the lawfulness of those reasons. So even if my limited application, if I call it that, is aimed only at that first leg, what happens at the panel report, if the National Assembly were to take an adverse or an opposite reason, and it was evident that there was some or other concern regarding the lawfulness of those reasons, then that would be justiciable in front of this court, as this court has repeatedly done in EFF2 and EFF1 and in a myriad of other matters where it's invalidated conduct on the basis that it's conflicted with constitutional principles. So I think it's important to disaggregate the decision as it goes up the chain to understand the fullness then of the argument that we're making. I don't know if that satisfies you, Justice Madlanga, but I'm willing to go again.
Lastly, Mr. Prem, in oral argument, unless there's something I did not hear,
yes.
In oral argument, you use very soft language that talks about an amendment or the need for an amendment.
Yes.
I'm not altogether sure whether that's an amendment that flows from a declaration of unconstitutionality of the rule or what?
Yes, it does. That we'd say is the 1721B relief that the court is entitled to give.
That's the relief flowing from the declaration of unconstitutionality.
Correct.
And just for clarity, against what constitutional provision do you measure the unconstitutionality?
Justice Madlanga, could I ask for clarity?
Against what constitutional provision do you measure the unconstitutionality? What I mean is, if you say this conduct is unconstitutional,
yes.
You will, for example, say,
yes, because
it breaches Section
yes.
9 of the Constitution
I'm with you.
For ABCD reasons. So against which constitutional provision?
So Let's start at the beginning, I think, Justice Madlanga, and that is from Section 1, particularly 1C of the Constitution, which talks about rule of law, the rule of law obligations. And then in our notice of motion at prayer 3, you would have seen that we've identified other sections of the Constitution which speak to the duty of accountability. Accountability in and of itself is not contained in a single provision in the Constitution. I fully accept that. But what we say is, like the court has done in other matters like Glenister, where it relied on Section 7 sub 2 in order to incorporate the international treaty obligations into giving a meaning of independence, we are asking this court to do the same thing, considering it's already done so in EFF 2. All we're asking the court to do is to extend its logic in EFF 2 to what we say is the logical conclusion. So there's no single provision, but it's all of these accountability factors as has been interpreted and expounded upon by the court.
Thank you, Mr. Prime Minister.
Thank you, Justice
Thank you,
Madlanga.
CJ.
Mr. Premier.
Mr. Premier,
Oh, sorry. Go first.
Mr. Premier,
Justice Chiefly.
I was still checking your surname so that I pronounce it correctly.
I've been called worse, Justice Chiefly. It's fine.
Can I first make a follow-up
Yes.
on your engagement with my brother Madlanga? You were debating paragraph 180
180 of the EFF
of
2 judgment.
EFF 2.
Yes, yes, Judge.
Let's go back to 179 of EFF 2.
$179.
Yes. The paragraph before that.
Yes, Judge, I'm there.
The first sentence,
Yes,
does it not say for the impeachment process to commence?
yes,
The assembly must
Yes.
have determined that one of the listed grounds exists. So if we adopt the approach or your invitation, or if we accept your invitation, then we would have to say we were wrong in paragraph 179.
No, with all due respect, Justice Chikli, I'm not certain I read it the same way for the reason I suggested to Justice Madlanga, which is that even though the words obviously say the Assembly must have determined, what it doesn't say is that the Assembly is not permitted to outsource some of that power, and in this case to the panel to make that assessment for it, because that's the entire basis upon which the new Rule 129 comes about, because that speaks to the sifting mechanism played by a panel that is an extension of the Assembly, because that's the delegated body that exercises that power.
I thought that your submission was that once the report is from the panel,
Yes,
it should not go to the National Assembly, but it should go rather
to the committee.
to the committee for
Yes.
impeachment.
Yeah.
And that's why I thought that your submission then invites us to skip the step that we said
Yeah.
it must go through
No.
in paragraph 179.
I take the point that Justice Chikli makes, and I think that again reverts to what I said in the discussion with Justice Madlanga, that I don't read 179 and 180 as prescriptively, perhaps, as Justice Chikli is suggesting to me in the context of what is meant by the Assembly itself. Because if that were the case, it invites the necessary question about whether or not the role played by the panel is a competent role in the first place, or whether or not it's only the Assembly who can undertake all of these activities. And what we would say is that EFF2 is authority for the proposition that some of that power can be outsourced to other bodies, provided that it's an outsourcing from the Assembly to it, and not the Assembly to some other entity that's outside its control. So we would say in the current design of the mechanism, that still falls within what 179 and 180 talks to, with due respect.
Okay. Let's I'm battling with what you submit concerning the meaning of prima facie information and sufficient evidence. And I thought perhaps the way we could do it is to do it step by step. Let's look at the text. Let's look at the words that are used
Yes.
in 129.
Yes.
My understanding is that 129 says that it envisages that there should be a substantive motion, and that if on the basis of that substantive motion there is a substantive reason, there is a prima facie case to be met, because it uses prima facie, then a panel should be appointed. But when it comes to the powers of the the panel, it does not use prima facie. It uses sufficient.
Yes.
And it doesn't just use sufficient, it also says evidence.
Yes.
And perhaps I am stuck in that, because I would have thought that if something uses sufficient evidence that shows, that is a higher threshold than when it says prima facie. So if you can just assist me
Yes.
there, to try and show me that there is really no difference. You've submitted there's no difference, but I'm still struggling with it.
I'm getting all sorts of notes, so I'm going to try and give you a sensible answer, Justice Chikri. Let me start here, please. I'm going to refer to the Magwakwa judgment, which I referred to a short while ago. And the Magwakwa judgment says the following, in relevant part, which is on internal page 16 of that judgment. It says, a prima facie case or prima facie evidence against a person encapsulates the notion of sufficient evidence to warrant a prosecution. So even though perhaps in the languaging and the context of the rule, the first use of prima facie applies as against the motion, and then subsequently it talks about the panel needing to find sufficient evidence, we say that sufficient information, we say that that is a species of the same prima facie evidence which runs throughout the entire rule. And that's what the panel ultimately reached in terms of its conclusion.
So are you saying that we should disregard the use of prima facie in another part of the rule and the use of sufficient evidence in the other part of the rule?
For the Magwakwa reasons.
No, I'm asking yes or no. Are you saying that we should disregard
Yes.
the fact that at a certain stage, what the rule says is that there should be prima facie, and at a different stage,
Yes.
it says sufficient evidence to show?
Yes.
So are you saying that we should ignore that?
Yes, because on the Magwakwa reasoning, they mean the same thing. They're all bundled into the establishment of prima facie evidence. That's my submission.
And you are saying we should disregard it because there's no difference?
Well, yes, and on the facts of this case, the disregarding of that, nothing turns on that, because what we know is the panel established that there was a prima facie case to answer.
Then my question then, when I was reflecting on your submissions, because that submission of yours is in your heads,
Yes.
I was wondering, what is the point then of this process? Because it seems to me then that there's a duplication. If what the panel has to determine is whether there's a prima facie information,
Yes.
and yet the motion also has to determine that, what is the point of appointing a panel?
Well, that's a fair question, but the...
Because they are both
Yeah.
both looking
Yes.
at the same thing.
Yes, but that with respect is the same point. Well, let me start here, is that
Your point is different. Your point
Yeah.
is your point is saying you should skip the National Assembly. I'm not sure, as I'm sitting here, that I agree with that.
No,
But I'm talking now about the panel and the motion, because remember, the National Assembly has received a motion from a member of the National Assembly. And that motion, what the duty on it is that it must show prima facie that there is information.
yes,
But then you are saying that when the panel is appointed as well, all that it has to look for is whether there's prima facie information.
Justice Chitri, may I ask if you can, I don't know if you have it in front of you, but supplementary volume 1 of 2, at page 631 of that bundle, of that volume,
Page?
631. What I want to draw the court's attention to is the following. Firstly, towards the bottom of that page, around line 20, under the heading Initiation of Section 89 Inquiry. The obligation when one has regard to prima facie evidence there is at 129, bracket 1, bracket small a, which says that the motion must be limited to a clearly formulated and substantiated charge on the grounds specified in 89, and which must prima facie show the President does one of the following things.
Yes, I've looked
Yeah.
at them. I've looked at them.
Yeah.
Yes.
I'm
Yes.
sorry, Justice.
Okay.
I'm-
Sorry, I interrupted you.
Sorry, I'm coming to answer your question about what's the point of the panel then. If you turn over the page, once you have a prima facie motion that evidences the things in 129A, look at what happens in terms of 129B and 129C. The Speaker, all the Speaker does is that the Speaker says, must check, and this is at page 632 at 129B, the Speaker must check whether the motion is compliant with the criteria set out in 129A. So in order to get through the Speaker's criteria, you have to, at first instance, when you present the motion, there must be some or other prima facie demonstration of a violation of Section 89. Once you tick the box in Section 129 of the rule, the motion then immediately gets referred to the panel. This is in terms of 129C. And then when the panel considers the rule or considers the motion and the charge, that's when the panel itself starts applying its mind. That's the first time anyone applies its mind to the content of the motion, and that's why we say that where the panel then comes to consider sufficient evidence, and this is now I'm reading at 633, page 633 in that supplementary bundle, at 129G, bracket B, must consider any preliminary inquiry relating to a motion referred to it by the Speaker, and must make a recommendation to the Speaker whether sufficient evidence exists to show the President. And the mechanism that it does so is spelt out in the rule. It then does an evaluative exercise. So in the context of the panel applying its mind and undertaking an evaluative exercise, there is a role to be played by the panel, because that's different to what the Speaker does. The Speaker ticks the boxes, the panel applies its mind. And then in the context of sufficient evidence being used there, we would say that that use of sufficient evidence is not different to prima facie evidence if that was used as alternative wording for the Magwakwa reasons that I've just indicated. They're all part of the same species. May I also just round out this answer, Justice Chitwe, by giving you one more reference, and that is in Volume 1, Annexure EFF 1, which is the report of the Section 89 panel, at paragraph 90. sorry, at page 90, paragraph 74 and 75. The panel says the panel answers this exact question by telling you how, with respect, they construe the meaning of sufficient evidence to be consonant with prima facie in the way that we understand it. So, I suppose to sum up that very long answer in 2 points. The first one is that the panel does have a separate role to play, and that just because there's a prima facie obligation when the motion is presented is not tantamount to the same level of sufficient evidence or prima facie evidence that has to be established by the panel when it receives the motion. That's point one. And point two, that the attempt to then carve out and distinguish sufficient evidence from prima facie evidence is not a distinction at all given what is said in Magwakwa. So those are my answers to your question.
Who takes the decision to appoint a panel?
If that
Your
would be,
reading of the rules.
that would be in terms of the rule, that's the assembly.
So they would have to have had a look at the motion, or am I wrong?
Sorry, I apologize. It's the speaker. The speaker appoints the panel. That's at 129E in that supplementary bundle of yours, Justice Chikri, at page 632.
All right, let's move on. Justice Madlanga asked you a question. I might not say it in the exact manner which he asked you. And I'm interested in knowing this rule, 129G,
Yes.
from which provision of the Constitution is it crafted?
I assume it must be Section 57, because Section 57 is the general entitlement of the the National Assembly to determine its own rules and procedures.
Well, I'm looking at Section 89.
Yes, I would say it's 57 read with 89. I would accept
89
that.
of the Constitution.
Yes.
And I think my problem is that when I look at it, it seems to embody some of the wording that is in Section 89
Yes.
of the Constitution.
Yes.
And you said that the only way in which you say we must tamper with it is for the National Assembly to be skipped.
No, Justice Chikri, that's not what we're saying with respect.
After. I heard you to be saying that after the panel.
Yes, there we are agreed.
Exactly,
there we are
after
agreed.
the panel is considered this.
Yes, there we are agreed.
And you say that that submission is consistent with Section 89.
Yes, because what the panel does is it does the sifting mechanism, sorting out the bad cases from the potentially good ones. The committee then does the actual, so the panel does the fact-finding mission, which results in its report about is there a case to answer. The panel, the committee conducts the trial, where all of the evidential issues and everything else are tested and it reaches a conclusion. And then following the committee's recommendation, that then goes back to the National Assembly in plenary to take a decision on Section 89. So how we read EFF2 is that EFF2 was the enablement of the National Assembly to not do everything itself, that it could delegate some of that ultimate power in terms of fact-finding and the trial to a panel and the committee as it did, but the National Assembly is still the body that ultimately takes the vote on whether or not the president should be impeached or not impeached. So we read that consistently with EFF2 and Rule 129 and Section 57 and Section 89.
Thanks. Let's move to a different topic altogether. the order that you are seeking.
Yes.
I wonder whether we would not be breaching the doctrine of separation of powers if we did what you ask us to do.
Well, which bit, I would ask Justice Chikri, is it in your construction of the separation of powers, is it the entire order or is it specific elements of the order? I would need that clarity in order to respond.
How do you understand it?
Well, that's important, because insofar as what we would say about prayers 1, 2, and 3, which is the alternative prayer, and prayer 4, those don't breach the separation of powers, because those engage the court's classic power under Section 172 to invalidate and declare unconstitutional. Insofar as prayer 5.1 is concerned, I could accept that there's a separation of powers concern there because of substitution, but our argument in response to that is that's also a classic doctrine that has been developed by the court to substitute for decisions in certain circumstances, which we say we meet. But if we were to talk about 5.2, for example, I would respectfully submit that that doesn't breach the separation of powers, because in the alternative it would order a referral to the National Assembly to consider de novo, which the National Assembly would then do. And that also is not breaching separation of powers, because that kind of invalidation and reconsideration happens in constitutional litigation all the time.
Are you not, I'm sorry to interrupt
Sorry,
you.
Justice Chikwi.
Are you not asking us to say that the National Assembly should not have voted not to accept the panel report?
No, I don't think we see our case quite so broadly, because that would be an interesting debate about the separation of powers. The reason we impugn the National Assembly's decision here is because we say, insofar as the only reason that exists, it's this division of sufficient information and prima facie evidence, which I've addressed already. And because in our construction of the case, that's not a cogent reason, that's not a good reason, it results in an unlawful outcome, and that's why the court can step in. It's not a generic attack to say that whenever the National Assembly votes not to impeach, that's automatically unlawful. It's asking the court specifically to interrogate the reasons that were relied upon by the National Assembly in reaching that conclusion. And we say if that reason is unlawful, then this court can intervene. So with all due respect, I don't think we don't submit our case quite so broadly as the way in which it's being posited to me.
Thank you. Sujay?
Thank you. Do you need to take a note?
I have no idea what it is, so I'm going to try and listen to you, Justice Majid, and then cast my eye downwards.
You can have a look at it first.
Thank you. I'm most indebted. Yes, I'm indebted, actually. What I would say, Justice Chikwi, going back to the debate that we had, apologies, Justice Majid, is that obviously we can accept that the substitution relief per se might create a separation of powers anxiety, but that if the alternative relief was granted, which is to specify or enumerate factors that have to be taken into consideration when that decision is reached by the National Assembly, that would be sufficient for us, because that in some way goes towards fettering and limiting a potentially unfettered discretion which has the capacity of introducing political interference into the debate.
Thank you. I have a number of problems with the applicant's case. Some of the ground has been covered, but there are more, I regret to say. And you know, in Greek mythology, there's the Hydra with the multiple heads.
Yes.
And the myth is that once you chop off a head, it regrows 2 others.
Yes.
I hope it doesn't happen in this case, but let's start with, at the beginning, with delay.
I suppose 2 heads are better than none, Justice Majid. Or 6 in the case of my team.
Unless you're the one trying to chop them off like Hercules was.
Yes, no, absolutely.
But let's start at the beginning about the delay in this case.
Yes.
Now, as I understand your case, and please correct me if I'm wrong, your case is this. You say this debate about declaratory relief and review is just kicking up dust. You say it doesn't matter because in declaratory relief you can claim more, or you could claim the same relief as in a review, and you're not bound to a decision. That's your case.
Yes.
So what you are saying is, I think if I read between the lines, that if it's a review, then delay comes glaringly to the fore. It would be a legality review, not so.
Yes, but it would hit more as to remedy, not as to the declaration. So it would hit more as to the 1721B inquiry, not the 1721A, because there's no doctrine of delay that will oust the court making a decision on the merits, but it may be that that is taken into consideration in the determination of the remedy. So yes, I accept that.
I must tell you, I don't follow that. I'm not going to try and understand it. I'm simply going to debate the matter on your case. Your case is declaratory relief.
Yes.
Now, you quoted Naptosa, and I looked in Naptosa for the silver bullet, and I couldn't find any. The silver bullet seems to be against you. Can we just go to the case, please?
Yes.
Do you have it in front of you, Naptosa?
It's coming.
Now, unfortunately, you would know that this is a 2001 decision of Judge Conradi in the Western Cape.
Yes.
So it doesn't have paragraphs.
Yes.
It's pre-paragraph judgment writing time.
Yes. And the version I have in front of me doesn't even have the internal numbering, so I apologize for that.
But let's go to, let's go to the paragraph that talks about the flexibility, which is the one you rely on.
Flexibility.
Yeah, you know where it is more or less.
Yes, and if I can ask one of my juniors to just search that judgment electronically, because then that will bring us closer to...
Yeah, they can do a word search. Search and
exactly.
just look for flexible.
Yes, exactly.
But let me read what the problem is for you.
Yes.
Your argument is that based on Naptosa, declaratory relief can subsume review relief, so it doesn't matter. Well, it does. And that's also always how I understood the law, that declaratory relief entails a sense of exercise of discretion when it comes to remedy.
Absolutely.
And their delay is one of the factors to be taken into
in the
account.
Context of remedy, absolutely.
Because here the judge says, I consider that the substantial delay in bringing these proceedings, which was for declaratory, is another reason for exercising our discretion against the grant of a declaratory order. It says it is well-established law that undue delay may be taken into account in exercising a discretion as whether to grant an interdict or a mandamus, or to grant relief in review proceedings. And then he makes the point that you say it's a flexible remedy.
Mm-hmm.
But the point I'm making simply is this: can you and I agree that delay features even for your declaratory relief that you seek? Are you prepared to concede that?
For remedy, yes.
Yes.
And that has not been, we've not suggested otherwise. What we have contended, though, unlike in reviews, delay can speak to whether or not the review should be adjudicated in the first place, which is not a remedy question. We accept that the delay might be factored in the context of remedy, but it doesn't allow the court to, what we would say, sidestep the merits issue, which is the 1721A point.
Yeah. Well, I don't understand that answer, because if you say it's about remedy, doesn't it mean that you're not entitled to a remedy if you've delayed unreasonably? And let me immediately add why I'm saying this. It's not only delay. This seems to be a classical Van Wyk versus Unitas Hospital case. Because here you have a delay, and please, I'm putting the case as I see it,
yes.
Mr. Premier, please feel free to correct me where I go astray.
I'm indebted.
You have a 14-month delay
yes.
on the papers.
Yes.
Undisputed.
Yes.
There is no explanation for the delay.
Yes.
And third, most importantly, there's an argument, which I'd like to hear you on, because you didn't address it at all in your uninterrupted time, that once the 6th Parliament has dissolved,
yes.
Section 49 and Rule 351 of the NA rule says, Parliament, 6th Parliament, your life is over. Delay, and that is the problem that I have with the case, a la Unitas versus, Van Wyk versus Unitas Hospital.
May I take both of those questions in turn, Justice Majid? Let me start with the issue of delay. I fully accept what you say to me, but what we know about the discretion to be exercised in terms of the remedy is delay is but one factor. So if the court is going to consider the unreasonable delay, that's fine, but then the court also has to counterbalance that delay versus the public interest in the matter, the ongoing effect of the court's judgment and the relief that it will grant, and then the court must bring an evaluative assessment as to whether or not the complaint of delay in and of itself is of such severity that it outweighs all of those other factors. And we would submit that it doesn't in this case for the reasons that we've addressed in the papers, including public interest, including the fact this is about the president who has special obligations to uphold the rule of law, and so on. So on the subject of delay, I accept what you say to me, subject to what I've just added about the factor and the evaluation that you have to make. That's the delay point. Insofar as the second point is concerned, and how I will try and answer the question is as follows. In the first instance, the court's declaration, if the court is with me, will invalidate everything that happened after the motion was tabled and restore, after the motion was tabled and after the panel gave its report, and restore that report. The status quo ex ante would be restored. That's the first point that I would make. So what the question then becomes, I suppose, is it competent for the 7th Parliament to adjudicate this report? Is it competent for the 7th Parliament to adjudicate this report which started in the 6th Parliament? And we would say yes, it is, because when you restore the status quo ex ante, it's the National Assembly, not time-bound National Assembly in terms of the rule, but in terms of Rule 129, but the Assembly itself, which is must then take the next step. So even though there's the issue of lapsing business, and we know that lapsing business is not absolute because there are instances where business is rolled over from one parliament to the next parliament, so it's not an absolute rule.
Well, that would be the revival of a bill, for example.
For example, yes.
But could you place it on the same footing as this matter? That's I looked at the revival of a bill. I understand that. But can you do this with a panel appointed under the previous Parliament that has done its work?
Yes, agreed. It's done its work.
And gone to Parliament.
Yes.
Parliament has decided. Now we've got a new Parliament, a new mandate from the electorate.
But Justice Majid, this is not something uncontroversial. It's something that happens all the time. For example, like we know when a court invalidates a tender, for example, and when it invalidates the tender and sends the tender decision back to the decision maker, oftentimes there's a change of personnel. It might be a new Director General, or it might be a new minister. The obligation does not attach to the individual occupant of the office. It attaches to the obligation to discharge the accountability function here to the Assembly itself. So we would say that in terms of what we are asking the court to do is nothing novel, and in fact only serves to emphasize the Assembly's obligation to discharge its accountability function. I know in the heads we refer to it as the ex-tunc versus ex-nunc debate. That's the way in which we see it, is the effect of the court's order would be ex-tunc in nature, and so the Assembly, however constituted and whenever constituted, would have to afresh then consider itself vis-a-vis the report. I understand the arguments that Justice Majid has posited against me. Those are as far as I can take it on that particular point.
I must just correct you. I'm not arguing the case. I'm
yes.
trying to figure it out.
Positing the arguments, I should say.
Well, I want to tell you that we must compare apples with apples. It's one thing to talk of a tender which has been set aside and goes to another differently constituted adjudication committee. But here we're talking about the highest office in the land.
Correct.
Facing impeachment. And impeachment is not just, the end of a career. It means that you lose all your benefits.
Correct.
And it's a very serious matter, and that is why in this court, EFF 2 said there need to be procedures in place.
Correct.
And they need to be complied with properly. And the National Assembly has the last say. That's the most important.
Correct.
Yeah. So I just want to get that out of the way. Now, I want to move on just to something else. And just to interpose and in brackets say that, I've listened to the debate between you and my brother Madlanga and my sister Tsiki, and I read Makwakwa, Makwakwa are the people who fled from Lesotho after the coup d'etat, and then there was an
Yes.
application for extradition.
Yes.
The magistrate granted the extradition.
Yes.
And one of the things he had to consider was the prima facie grounds on which
Yes.
to grant the extradition.
Yes.
And in that context, Judge Musi, with whom Judge van der Merwe concurred, said, well, prima facie evidence means there's sufficient evidence for the warrant, for the extradition to be done back to Lesotho for them to be charged. Now, I mean, no disrespect to those judges, but in the context of that case, it's an understandable thing to say, well, prima facie evidence means sufficient evidence. Here, it's different. There are phases. The first phase we know is the member of the ATM comes to Parliament, says, here's a motion, and I contend there's prima facie evidence of these serious gross violations. Speaker looks at it. Speaker says, I agree with you, there's prima facie evidence. But now when it goes to the impeachment panel, this is a full-blown inquiry. It's headed by a former Chief Justice Noha, prominent senior counsel, well-respected retired judge. If I may say so, and I say mean no disrespect, it's a heavyweight panel.
Yes.
But the panel now gets told, you must look for sufficient evidence. The threshold is higher, Mr. Premier, as I understand it, because it's no longer a question of whether we should set in motion the proceedings of an impeachment, of an inquiry into impeachment. It's now whether there is basis now for Parliament to decide on impeachment, which is a far more serious thing than to say to the police, investigate if there's enough evidence to arrest, and then the prosecutor must decide whether to prosecute. It's almost those two phases.
Yes.
So it's almost like the police.
Yes.
The complainant comes to the police station. The leader of the ATM comes to Parliament, lays a complaint. Police look at this and says, well, there's prima facie evidence, there's enough here to arrest. But when the prosecutor must decide whether to prosecute, it is prima facie, but it is a different threshold. So isn't there two different thresholds? And that is why the legislature in its rules calculatedly use these two different terms, prima facie and sufficient evidence. I can't understand how it means the same thing.
So may I just pick up on the example that Justice Majid uses? That's exactly correct. And that's why we say that the way in which Parliament voted down the report ultimately is premature and constitutes a preemptive strike, because it didn't consider the correct question in front of the panel, which was about the existence of this prima facie evidence. So we agree on a proper interplay between what the Speaker does, what the panel does, what the committee does, and what the National Assembly ultimately does. The analogy of a police complaint prosecutor is exactly right. That's what it's concerned with. Is there a case to answer? So insofar as the analogy is concerned, I adopt it, because with all due respect, we submit it makes our case. On the specifics, though, of what the panel had to consider, may I give a reference, if I could? I'm looking at volume 1, page 34 of the founding affidavit, paragraph 109.2.5. The panel wasn't blind to this issue. And what the panel said, and I'll read it out if it's of assistance to the court, it says, in the context of the scheme for the removal of the president from office, we construe the phrase whether sufficient evidence exists to mean whether, based on the information received, the president has a case to answer. Put differently, we construe the phrase to require the panel to determine whether there is a prima facie case against the president. So on the panel's own wording, it says we have cognition of what sufficient evidence constitutes. We interpret that to be no different to the prima facie standard, which is the Magwakwa reasons that we had articulated earlier. And it goes on to say it is not the function of the panel to inquire into whether the president is guilty of a serious violation of the Constitution or the law or serious misconduct. That is the function of the committee, which is empowered to investigate the matter fully, including summoning persons to give evidence before it or to produce documents and hold public hearings. So as against Justice Majid's understanding of sufficient information or sufficient evidence, there must be something more to answer in respect of the case. The panel on the facts ticked that box for themselves and reached the conclusions that they did. And then what happens in front of the National Assembly is that that is latched onto, with all due respect, by Minister Lamola, and the attempt to split out sufficient evidence and prima facie information arises, but which is no distinction at all, not only in the panel's words, but because of the Magwakwa reasons. So that's how we see it as having played out on the facts of the case.
I want to leave that topic there because that kind of language, case to answer, is typical of a civil trial. That if you have prima facie evidence adduced by a plaintiff and you leave that unanswered as a defendant, you may find problems on the preponderance.
Correct.
Same with an accused.
Yes.
If he or she leaves that evidence of the state unanswered, may get past 174,
Yes.
but may get convicted. But let's leave that there. I want to go to another.
Justice Majid, may I say
Yes.
that in terms of what you've just said to me, I agree with you, and where the testing of that evidence happens is in front of the committee. That's the way in which the rule envisages it to happen. So in our construction of the case, the panel draws the charge sheet, and then it goes to the committee where the competence or merits or otherwise of the underlying charges drawn by the panel is tested in front of the committee. And that's the point at which the president who is being investigated has their full fair trial rights available to them to mount whatever defense they want to mount.
Yes, thank you.
Thank you.
There's an argument of prematurity. What has happened with this new motion before the 7th Parliament now, which was brought on the
It died.
7th of July 2024?
It died. On the 24th of, we've raised this in chambers with the Chief Justice. There was a letter that was sent by the Speaker to the erstwhile MP, who was our client's MP at the time, to say that your motion, the second motion, did not tick the box of the 129A requirement, and therefore your motion is not compliant and won't be processed further.
It means then that you were, in layperson's parlance, you were chucked out on a technicality. You could conceivably bring that application back in proper form.
Yep.
Yeah.
I could, but that doesn't, and taking that point to what I say its logical conclusion, we would respectfully submit that the second motion stands on its own footing and engages something different. Just because there was an unlawful, let me put it this way, again in layman's terms if I may. Let's just assume for the moment that the reasons for the National Assembly's outcome when it voted down the report was unlawful. And then the second motion came about and somehow, through a miracle, it was accepted and it was ultimately approved and the president was impeached. That subsequent impeachment may factually lead to an impeachment, but legally it has very little to do with the unlawfulness or otherwise of the first impeachment motion and the reasons it would have been voted down. So to the extent that there's and this is spoken to about prematurity, ripeness, mootness, all those technical defenses that respondents love raising when they get the chance to, not sure what to make of that with all due respect, because apart from the fact that that second motion died, that first motion and its outcome is its own inquiry as to lawfulness and doesn't get altered by something that comes subsequently.
Can I just ask you a last question then on remedy? Let's say that this court is with you on alternative relief and remit the matter.
Yes.
What does that remittal mean? Does it mean that Parliament must now work with this report of the independent panel of Chief Justice Ngobo? A, could you just maybe answer that one because there's a B coming?
Yes. May I just get the supplementary authority bundle again so that I can look at the actual rule? So if I understand Justice Majid's question correctly, it's assuming you're with us, you invalidate the decision, what happens to the report? We would say the report then goes back to the Assembly for the determination, the consideration of the report. 635. So that's the stage at which we would, no, I apologize, I'm inadvertently misleading the court. It's 129I at 633.
633, yeah.
The other one that I gave you the reference to was the committee outcome.
All right. That's your answer?
Yes, so it's 129I.
What happens then with the vote of the 6th Parliament? Those votes, what happened to them? We just strike a pen through them?
Yes.
Or press delete on the computer?
Beg your pardon?
We press delete on the computer
Yes.
for that vote. Seems to me quite drastic for a court to do.
It's what the Constitution enables you to do when you are confronted with unlawfulness, even if it emanates from another organ of state.
I have no further questions, just to say that the good news is, in the end, Hercules does slay the Hydra.
Rather Hercules than Sisyphus, I'm afraid, but be that as it may.
Mr. Premier, can I
Justice Turan.
just touch on jurisdiction, please? The applicant relies on exclusive jurisdiction. Is that right? Yes?
Yes, Justice Turan.
And in the second prayer of your notice of motion, you ask, the applicant asks for an order that this court declare that the panel's report was irrational.
Yes.
Does irrationality come into play with in an exclusive jurisdiction application matter? Is that not trying to bring a review in through the back door?
Only if one presupposes that irrationality cannot be vindicated through a declaration of unlawfulness, and that irrationality as a species of unlawfulness is unique to judicial review.
Is there any precedent of this court for that, for what you're asking this court to do?
Hopefully this judgment, Justice Turan.
No, is there any, by precedent I mean, is there anything that comes before this case
No.
that this court can look to for guidance, where that has been done?
You have the cases that we've relied on in our construction of our declaratory relief being competent, starting with rail action.
My question, Mr. Premier, is there any precedent for what you're asking this court to do in this matter?
In terms of that prayer too? Yes. Not necessarily framed as a declarator application, but having consideration to rationality as a standard. The DA versus the President, the old 2013 Simelane case, is an instance where rationality was founded to invalidate the appointment of the then NDPP, Mr. Menzi Simelane. But I say that subject to the caveat that I'm not certain that that was crafted as a declarator. I accept it might have been crafted as a review. And it was an exclusive jurisdiction. I accept that too.
Now, in this matter, the applicant does not plead direct access in the notice of motion.
Sorry, Justice Turan.
Yeah, the applicant does not plead direct access in the notice of motion.
Correct.
It's not dealt with in the founding affidavit.
Correct.
And it pleads this for the first time in the consolidated replying affidavit,
Yes.
which we find at volume 6, page 566, paragraph 21.
Yes.
And if you look at paragraph 22 of that replying affidavit,
Sorry, Justice Turan, did you say P566?
page 566.
I'm with you.
Yes. It starts, the pleading in respect of direct access starts at paragraph 21. If we look at paragraph 22, this is what the applicant says. In line with the SCA authority in Fisher, this court is permitted to find that the EFF's case warrants direct access, even if it is not specifically pleaded for, if the facts that underpin such finding are pleading. Now, how does Fisher help the first applicant in this matter?
Remember, what's happening in this replying affidavit is we're shadow boxing, in effect, a case that's made against us to say that this is a case for direct access. So the starting point is to say, no, this is not a case for direct access. This is a case for exclusive jurisdiction. However, to the extent that direct access may be an issue on the pleadings as an alternative to exclusive jurisdiction, the reference to Fisher and Ramatlele is to say that the scope of the dispute is obviously defined by the pleadings. And what we know from this court's judgment, for example, in the McBride decision of 2016 at footnote 25, relying on the old Mphahlele decision against the Electoral Commission, is that this court takes the attitude that it can raise any legal issue if the facta probanda are there on the pleadings. And so all the purpose of paragraph 22 is to say is we don't adopt direct access, but if we're made to say or engage with direct access, we can nonetheless come home on direct access because the facts to justify an order of direct access are pleaded.
If, as you say, you don't come home on direct access, can this court consider the constitutionality challenge against the rules? Because that is not an exclusive jurisdiction matter.
Well, the way in which this case is constructed is that on our case, it would be...
Please answer my question, Mr. Premier. If the applicants do not, as you say, come home on direct access, can this court consider the constitutionality challenge?
On the rule 129? I would say it could, but the hoops that the court would have to jump to get there are not...
No, let's... On what basis could it? If we don't have direct access in this matter, or if the applicant doesn't establish direct access, how do we get to the constitutional...
It's on the same basis that I've answered...
How do we get to the constitutionality challenge?
It's on the same basis that I've answered previously. It's about the reference to the McBride and the Mphahlele judgment that the facta probanda are present to enable the court to give that order if it chooses. But I think the difficulty with respect, Justice Theron, is I'm now engaging a case on direct access which was never ours to start with. And I think the difficulty that arises from the replying affidavit is we're responding to a case on direct access that was imposed on us from the respondents rather than engaging exclusive jurisdiction on terms.
So the applicant is not relying on direct access?
Yes, we've repeatedly said that.
Might be problematic for the applicant.
Sorry, Justice Theron, I didn't hear you.
Might be problematic for the applicant.
No, I accept that.
If
we're down on exclusive jurisdiction, and then if I've nailed our colors to the mast in the way that I have, then direct access ipso facto becomes a problem. I don't run away from that.
Is the applicant's case that the National Assembly has failed to fulfill a constitutional obligation?
Yes.
And what is the obligation that
to hold the president accountable?
They have failed. And are we talking now about the 7th administration?
No, we're talking about the vote down of the report that happened during the 6th, which has continuing legal effect, which is why we're in front of the court today.
In EFF 2,
yes,
this court had to decide whether the National Assembly...
I'm sorry, Justice, I'm getting the authority passed behind me.
Yes. Yes, in EFF 2, this court had to decide whether the National Assembly had failed to fulfill some of its constitutional obligations, but the question there rested on the parliamentary mechanisms for holding the president accountable.
Yes.
Following that decision, the National Assembly has in fact enacted mechanisms.
Yes.
So why do you say that it has still failed?
Because the sufficient...
When it has responded to what the court said in EFF 2.
Because it's the sufficiency of the mechanism adopted. That's the earlier reference I made to Glenister. It's the interplay between what is seen as the first judgment, which sets out the principle, and then the second judgment in Glenister, which is what the amendment was, and it was evaluated as against the principle. We say that the same logic applies here in respect of EFF 2. EFF 2 enumerated the principle, and this case now asks the court to test the mechanism chosen against those principles to determine if they're sufficient.
Please, can you repeat for me? Why do you say they're not sufficient?
Those are three overarching reasons. One is that the ability of the National Assembly to exercise a wide discretion at the point of the panel producing the report opens the door to political abuse. And so that existence of that wide discretion, where it's either the National Assembly has a role to play, or if it does have a role to play and it's not subject to factors, perpetuates the concern that was espoused in EFF 2. That's point number one.
So before you continue, why is the wide discretion problematic?
Sorry, Justice Turan, I'm just making a note. The wide discretion is problematic exactly on the facts as we would say arise in this case. Because remember, even though when Minister Lamola was giving his address in Parliament, it was seemed to be linked to a narrow evidential issue, what the affidavits reveal is that there were all sorts of political considerations and decision-making that was happening in parallel. And so in the absence of in the absence of the National Assembly not playing a role when the panel produces its report, or in the absence of factors to be considered for the purpose of that decision, to fetter its discretion, that's where the potential for abuse arises, and that's where we say the structure of the rule needs to be tested for its sufficiency.
And that's where the potential for breach of separation of powers comes into play, as my sister Justice Chikwi was debating with you. Exactly there.
Yes, and I repeat the answer then given to Justice Chikwi in that regard, that at the broadest level, the separation of powers is not as much of a concern for us in the way in which we've constructed the case, and that the two alternatives that have been sought in this court are recognized alternatives that are used as remedies in this court in public law disputes all the time. So we would suggest that the separation of powers concern is not as acute as that.
Yes, the question of delay has been dealt with by Justice Majid, and I won't delve into it, but it does concern me that there is no explanation for the delay.
Yes.
What is the first applicant saying as to how it regards this court when it comes here 14 months late and it does not give this court an explanation for the delay? I think it's just too glib to say, well, there are other factors that the court can consider in the interests of justice. Why is there no explanation for the delay?
Maybe it emanates from incorrect legal advice that the delay doesn't have to be addressed because of the declaratory order as chosen. But to the extent that there's a criticism that delay is inadequately addressed in the affidavits, that criticism is perhaps well-founded. I don't think Justice Turan is inviting me to now give that explanation.
I'm definitely not.
Exactly.
I'm voicing the concern
exactly
that the court has about that.
And I hear the concern.
And I'm giving you the opportunity to answer how we can address that concern. I'm not giving you the opportunity to give any evidence, Mr. Premier.
No, that's entirely right, and it would be inappropriate if the invitation was extended. The point is that the court has, in other circumstances, and I will address this more fully in reply, and I'll make a note to do so, has dealt with other cases where there have been substantial delays, and
But now it seems that the court is creating problems for itself where it attempts to assist litigants. And perhaps the court should not be doing that. So litigants should know when there is a delay, there's a duty upon them to provide an explanation to the court.
Yes. Now, I hear the criticism and I hear the concern, and I quite frankly agree. But stare decisis is as stare decisis does, and if the court has exercised its discretion in the interest of justice in other matters where delays may have been insufficiently explained, that's the sum total of the explanation, I guess.
The applicant filed a consolidated replying affidavit in this matter. And in that affidavit, it raised certain new issues, one of which I had covered with you.
Yes.
There was a further opportunity to deal with the delay. And this is after the respondents, in their opposing papers, had already criticized the applicant for not providing a reason for the delay. So despite that, despite being made aware of the fact that there was no explanation, the applicant still did not at that stage consider it necessary to tender an explanation.
And I mean, I must accept the criticism. One's also caught between a rock and a hard place in that instance, because then if one strays into an explanation on a so-called new issue not addressed in the founding affidavit, the immediate response is you're then making out a case and reply. So in an imperfect circumstance where delay is raised as a respondent as an issue that is relevant for the matter at hand, it is somewhat difficult for an applicant who finds themselves in that situation to then deal fully with an explanation on delay, particularly where, and again, this is subject to correction by this court, obviously, it chooses a modality of relief that delay does not play as much a part as it would if it were a review, for example. But I hear what Justice Turon says, and the issue is as it is on the papers.
My last concern, which has been touched upon, is that of doctrine of breaching the doctrine of separation of powers. Now, once again, is there any precedent that you can point me to from this court where substitution has been ordered in a case like this? Where substitution has been ordered by this court, where there's a danger of breaching separation of powers?
No. Other than, on similar facts to this case, I would say no. Obviously, the separation of powers issue in substitution.
On any facts, doesn't have to be similar to this case, but where there's a danger of breaching separation of powers, has this court ever ordered substitution?
And are we limiting the engagement only to issues of exclusive jurisdiction, or are we saying generally? Because there is a case, and TRENCON is the leading authority on the substitution point, where the separation of powers was foreshadowed by the court. And the court's answer in TRENCON is that separation of powers is actually not really a concern, because the court ultimately is the one that enforces the Constitution. And if the repository of the public power exercises that power incorrectly or achieves an unlawful outcome, then the court, if it is well placed enough to make that same decision, can, despite the separation of powers concerns, because all of the exercise of public power stems from the Constitution, of which the court is the upper guardian. So
I'm only going to remind you of the opening sentence of the minority judgment.
The minority judgment, yes, Justice Turon.
Are you relying on the minority judgment?
No,
yes. I'm going to remind you only of the opening sentence of the minority judgment. In I think it was, it was the secret ballot. Yes,
My vote
UDM,
counts.
the UDM matter.
Oh, UDM, yes.
Yes, where the minority judgment started with, this is a classical example of judicial overreach. So separation of powers is always a concern, Mr. Premier.
Yes.
Yes, but I leave it at that.
Justice
and we shouldn't downplay it.
No, Justice Turon, may I say, as a conservative constitutional lawyer, I completely agree with you and endorse your sentiment, but the reality is that the court's precedents are what they are. And unless any respondent in this matter or this court itself is willing to impugn its prior decision, stare decisis applies. And Justice Brunt, if I'm not mistaken, when he was an acting judge of this court in Camps Bay, made that abundantly clear at para 28. Precedent not only applies vertically, it applies in respect of the court and its prior decisions. So in as much as the separation of powers concerns are what they are, the majorities in these judgments have broken the other way, and therefore they're justiciable principles which a litigant can rely on.
Yes.
But I share your concern.
I'm not going to engage in a debate, Mr. Premier, about whether this court has in cases breached separation of powers or has gone too far. I'm not going to engage that debate. I've raised the concerns and I leave the matter there. Thank you, Mr. Premier.
Thank you, Justice Turon. May I Justice Turon, before I face questions from someone else, there was the question that was asked specifically about examples in this case, and I see lots of a flurry of activity from my teammates suggesting that the answer is EFF 2 at para 46. I think I have. No, I apologize. It's not EFF2. The issue of substitution was Trencon at para 46. That's the reference I wanted to give. My apologies.
Yes, thank you.
Mr. Premier,
Justice Colopin.
you relied on DA versus SABC. I just want to get some clarity whether you seek to invoke it with regard to what a future scenario might look like, rather than what the present scenario is. Let me be specific. In DA versus SABC, the court concluded that the report of the public protector was binding,
Yes.
unless it was reviewed and set aside.
Yes.
That's not the case here when this
Correct.
report served before Parliament, correct?
Correct.
So whether we ever reach that stage is debatable, because the independent panel is quite different from a Chapter 9 institution. Chapter 9 institution gathers evidence, tests the evidence,
Yes.
subjects it to cross-examination, etc.
Yes.
And therefore, for court to conclude that that report is binding is underpinned by a number of jurisdictional facts which doesn't exist
Absolutely.
yet.
Absolutely.
So having set that aside, would you then accept that if the report was not binding on Parliament, Parliament was at liberty to consider the report and to consider it critically?
Yes, but
not to have the wide discretion that you say it did.
we're at EDM.
Fine. Now, even if it had to use a narrower discretion, it's calling into question of whether the panel misconceived its role in setting the standard at that of a prima facie case. And we've had the long debate with my other colleagues, would not appear to be unreasonable. Certainly it was a valid point to raise and would fall within its narrow discretion.
Justice Colopin, subject to if I've misunderstood your question, the issue for us is not, the inclusion of factors is not applicable as against the panel. The inclusion of the factors is as against the narrowing of that wide discretion that otherwise vests in the National Assembly. And the reason that we say that those factors, which is the alternative to the automatic referral issue we've debated, need to be present is because, like the court identified in EFF2, and it decided similarly in Oriane Ambrosini and Mazibuko before that, is that these rules, in as much as they are presented as neutral.
Sorry to interrupt.
Sorry, Justice Colopin.
You're postulating what the ideal situation should be. I'm really wanting to get to what was before the National Assembly and whether they were, absent any amendment to the rules, entitled to critique the report, certainly on the basis that the panel got it wrong on the law with regard to the test.
Yes.
If that is so, then surely that can't survive a rationality challenge. And secondly, surely in that regard, Parliament would have discharged its obligations to hold the President accountable. Because to hold the President accountable doesn't automatically mean that you have to establish an impeachment committee.
I fully accept that last.
Entitled to say, well, we've got this report that requires a level of sufficiency.
Yes.
The panel misconstrued its role by lowering that standard to one of a prima facie standard, and on that basis, we're entitled not to adopt this report.
But that only survives constitutional scrutiny if the reason relied upon by the National Assembly to vote down the report on that basis is itself a lawful reason. And if it's a mistake as to fact or a mistake as to law in terms of what the different thresholds means, from Hurton Carter and ATM versus the Speaker, which are recent SCA judgments, if that is material to the outcome because of what the court previously said in Orpe, then that vitiates the decision with unlawfulness. So I wouldn't be willing to say it survives a rationality challenge, because that invites the question about whether or not the reason relied upon was an actual fact a good reason.
Well, it may well be then.
Yes.
On the basis.
Yes. But I hope I've answered that rationality point, Justice
Oh, you've responded, thank you. And just finally, there's a principle, and I can't remember the case, where the lawmaker uses the same term in legislation, then it must be given the same consistent meaning wherever it appears.
Yes.
And the corollary of that must be that when the lawmaker uses different language, then it must be intended to give it a different meaning. And I simply ask this question in the context that it was open to the rule makers to use prima facie consistently, if it intended that to apply in respect of a motion and intended it to apply in respect of a report. Is it incumbent upon us to go beyond that and to say, well, it must have meant prima facie, and therefore it doesn't really matter what the panel's interpretation of it was. We have to give effect to what does the rule mean, and did the panel understand the rule correctly?
Yes.
If it got it wrong, it got it wrong, irrespective of how eminent the panel may be.
Yes, and as eminent as they may be. No, so 3 very brief responses, if I may, Justice Colopin. In the first instance, we would say that that distinction is no distinction at all. You've heard me on that already. So in the panel applying its mind and equating those two things, there's nothing wrong with that, because those are all within the same species of prima facie. That's the first point. The second point is that...
I just want to intervene by saying that if that was its case, then there would have been no need for it to place anything before the President, not so. Because prima facie is what is presented to it by those who complained.
Yes.
By making the information available to the President and the supplementary information and giving the President an opportunity to respond, surely that took it to a different level than the original motion.
Yes.
And therefore, sufficiency under those circumstances must automatically lend itself to a different and a higher standard.
Yes, which we said the panel met here. Because
whether it met it factually is another matter. But it characterized the standard. You could argue that if you look at the report in its entirety, it may have met a standard beyond sufficiency.
Yes.
But that's not the question we must answer. The question we must answer is the panel decided that the standard it had to meet was one of a prima facie case.
And you've heard me on why it's doing so is competent. So that was my first set of answers. My second set of answers is that the nomenclature difference need not necessarily arise in a different standard if applying the rules of interpretation results in a sensible outcome. Obviously, the debate is whether the sensible outcome is the higher standard or the lower one, vis-a-vis the panel report and the motion, but we say that that's the consistency that is evident throughout the rule. And the last response is that the panel here doesn't do something akin to what the SEA did in the Moyo and Sonti matter, where in seeking to save, I think it was the Intimidation Act, if I'm not mistaken, or maybe it was the Incitement Act, I speak subject to correction. What the SEA did is it read in a whole number of qualifiers in order to rescue the provision overall in terms of its constitutionality. What the panel did, to the extent that it applied its mind and said that sufficient and prima facie is the same, is not in that territory at all. So to the extent that there has been a difference in the nomenclature and it's been interpreted in a particular way by the panel, then that's fine in our construction, because it's not actually a reviewable error that they've committed. They've adopted a standard of evidence which is defensible in law. Thank you.
Mr. Premier? I'm here.
Sorry, Justice Matopa. May I just give one last reference to Justice Colopin, if you don't mind? And on the facts, Justice Colopin, the reference I would give you is in page 90, volume 1, paragraph 76, from line 22 onward. And the panel in its own words says the following: it is a momentous act justified only when sufficient evidence exists. Remember, sufficient evidence is what it's used in the rule. Sufficient evidence exists to show the President has a case to answer for his conduct. The panel therefore functions as a filter to ensure that only a motion which establishes prima facie that the President has a case to answer is considered by the impeachment committee. So assuming, Justice Colopin, that there is the distinction between prima facie and sufficient evidence, what the panel is doing here is it says that that's that higher threshold that we're meeting all the time. We're just calling it prima facie evidence.
Well, I think this creates further difficulty for me, because what it says is the panel therefore functions as a filter to ensure that only a motion which establishes prima facie that the President has a case to is considered. But that's precisely what the Speaker has done now, sir. The Speaker has satisfied herself that the motion satisfies the requirement of prima facie evidence, and therefore the Speaker has no discretion. The Speaker is obliged to appoint the panel.
Yes, but the Speaker's assessment of that is measured as against the 129A provision, whereas the panel considering that sufficient evidence threshold is as against 129G. And and again, I think it takes me back to the debate I was having with Justice Cheekley earlier about the duplication. Then what's the purpose of the panel? It's that the Speaker doesn't play as intensive a role as the panel does. And so even though the Speaker considers whether or not there's the prima facie evidence, that's only in terms of the tick box exercise for the competency of the motion, not the underlying charges. That's the role to be played by the panel. So when the panel talks about the motion, it's a motion that passes the Speaker's hurdle, but on its terms as a charge sheet, if I can call it that, is competent to make the prima facie threshold.
Okay. I think we've
yes,
probably been... thank you.
Thank you, Justice Colopin. Justice Matopo.
Just to follow up on that last part.
Yes.
If you look at volume 2.
Yes.
At page 143.
I'm with you.
There's been the report of the panel. This is what they say. Viewed as a whole, the information presented to the panel, it's not them, prima facie establishes that there was a deliberate intention. So the word prima facie has been used throughout by the panel.
It has. But the earlier portion that I read to Justice Colopin is an earlier paragraph where they're explaining what they understand by that.
Now let's look at that.
Yes.
You and I as lawyers. If the panel uses the word prima facie and sufficient evidence interchangeably as if these were synonyms, that is wrong. Forget about what Makwakwa said. My brother Majid has taken you through what Makwakwa said.
Yes.
That is wrong. And if a wrong test has been applied, it invariably would lead to a wrong conclusion.
Yes.
So isn't the case here that the report has to be impugned because it is based on a wrong test? The panel conflated the two tests as if it's one and the same thing. You and I know that it is not. We have to search through the report to find the word sufficient evidence to save it. This is a report by 3 eminent lawyers. Do you have an answer to that?
I'm not going to repeat my submissions that you've heard already on the issue of the threshold. But I think in the way you've constructed it to me, I accept what you say, Justice Matopo, subject to that caveat.
Just to remind you, this court in State versus Tuta, a judgment written by Acting Judge Unterholter, in which my brother Colopin also wrote a minority judgment. There was a misunderstanding or a misapplication of the test. And as a result of that incorrect application of the test by the trial court, it came to this court, the conviction and sentence was set aside.
Yes.
And if that's the case, then Tuta is against you, number one. 2, you know the tests in criminal law, it's proof beyond reasonable doubt. If a court convicts on a balance of probabilities, the test has been incorrectly applied. The examples are myriad. So even in this case, the fundamental or the fundament of the report by the panel is just wrong. It must be called for what it is.
Sorry, Justice Matopo. May
Do
I
you
respond?
agree or you don't?
I disagree on the basis of what I read out earlier, because the risk inherent in what Justice Matopo is positing to me is what I would respectfully say is a form of a substance error potentially. Because what the panel says is the panel in its mind, and based on that earlier paragraph that I read out, which if I can get it, it will be helpful. But based on the earlier paragraph that I read out, it's not that they were thinking about two separate things. Even though they might have used prima facie evidence subsequently in the report, what they continuously tell you insofar as how they understood the meaning of that is that's related directly to the evidence of justified only when sufficient evidence exists.
But look at the conclusion that I've drawn your attention to when I first started my
Yes.
question. It says, viewed as a whole. In other words, in conclusion. That's what they're saying. They've nailed their colors to the mast.
But
That's what they're saying. Forget about how they took the journey or they undertook the journey.
Well, I think that puts me in a difficult bind because it asks me only to consider what they say in the conclusion despite what they give earlier, which adds color to that conclusion, which is the paragraph that I just read out. I mean, if I have to ignore that, then the way in which Justice Matopo presents it to me is unanswerable, but I would say that that is at the risk of the form over substance issue because of what they say here at para 76.
Are you prepared?
75?
Are you prepared?
No, it's 76.
Are you prepared to accept that at the initiation of the complaint, there has to be a prima facie evidence?
Are you talking about, Justice Matopo, when it goes to the speaker?
Just at the beginning, initiation.
I accept that.
And are you prepared to accept that when the panel conclusion has to be based on sufficient evidence or both, or it doesn't matter?
Well, based on what I read out, it doesn't matter because they've equated it to the same thing. Substantively, even though they're calling it prima facie evidence, that the test and the threshold which they themselves are seeking to answer is as set out in that paragraph, which is sufficient evidence exists for the president to answer a case.
Okay, let me wrap up and move on to something else different briefly. What I don't understand is why the applicant did not directly and frontally challenge the rules. One, the relief that has been sought, the resolution that was taken in December, and everything that goes with it. The ship has left, has sailed out. If the EFF had challenged the rules and asked for an amendment before the National Assembly, wouldn't that have been a prudent move to do? Short of lumping the whole thing with what it has done now?
No.
I'm bringing into question the issue of delay, mootness,
I hear
immaturity.
No, I hear you. That would only be competent vis-a-vis the attack on the rule, but then it would still leave the substantive outcome of the National Assembly's decision and what is to be made with that. So the EFF is in the court because it says that's the exclusive jurisdiction issue, and because the decision that was made and which is being impugned is in terms of Rule 129, that invites it and this court then to consider the competency of the rule as it is now constitutionally challenged in front of this court. The EFF's case is not only about the rule. If it was only about the rule, then I think Justice Matopo's observation is correct. Maybe it should have gone in the High Court and started there and attacked the rule or whatever else.
Yeah, but how good is the EFF's case in respect of the other prayers? I mean, let's look at it practically. What is it seeking to do?
It's seeking to get...
I mean, if it goes to the rules, it's something else. It might have a case to sustain. But all the other reliefs, I don't know. Hasn't it misconceived its position? Just think about it. Move away from the issues and look at the practicalities. And take a step backwards and look at the issues. what is it that the EFF seeks to achieve? The EFF seeks an amendment to the rules. Its complaint is not what happened, because the boat has sailed. Its complaint is the rules as it is now gives us a problem. That's where the problem is. No other problem. All of these things are just lumped up to create an atmosphere. Just, do you agree with me or you don't?
I disagree, and I disagree for the following reason.
Mr. Premier, would you mind giving us the reasons after the tea adjournment?
Of course.
We'll come back at 11:30.
Justice Matopo. I had indicated before the tea break that I disagreed with the way in which you had framed the EFF's case to me. And there are two reasons for that disagreement. The first one is, as I had indicated earlier, that the EFF's case is not solely concerned with the rule. It's also concerned with the National Assembly making a lawful decision vis-à-vis the panel and the report. So to the extent that it might be characterized as just being added on for the sake of atmosphere, we would respectfully disagree, because we say that there's a substantive and justiciable issue that the court needs to consider regarding those reasons for the decision ultimately taken. And because there's an interrelationship between that decision and the extant rule is why both those challenges are framed in the court in the way that it is here. Because I suppose we could ask the question the other way. If we had only sought to come to this court to invalidate the rule, then the opposite question could be posited, well, why didn't you attack the underlying decision? And because of the interconnectedness and on the facts between that decision and the rule, that's why we're here in the way that we are. The second reason for the disagreement, with all due respect, Justice Matopo, is this, is that these type of cases tend to invite extreme responses because of the way in which the court has constructed things like political interference in parliamentary decision-making and so on, like in UDM, for example. But the point here is this. There are two competing constitutional principles which are taken into consideration. And that is, you could either have what I'm going to call a perfect outcome that entirely excludes Parliament, or you have a political outcome that involves Parliament but is open to abuse. Obviously, neither of those extremes are viable, and that's why in EFF2 in particular, the court sought to craft a remedy that guided Parliament as to what the correct rule should be in balancing those competing interests. On one hand, that a quasi-legal inquiry of the kind contemplated in a Section 89 inquiry is done for lawful reasons as opposed to political interference, balanced, on the other hand, the democratic legitimacy of that outcome, bearing in mind that the disciplinary proceeding to be brought against the President emanates in the political sphere. And so we say that EFF strikes the appropriate balance between those competing interests, and what we then seek in front of the court today is to build on the EFF2 principles.
Well, finally, let's explore the votes at the National Assembly. Prior to the 7th Parliament, the ANC was the majority party.
Yes.
Hence, it amassed enough votes to vote down the panel's report.
Potentially, if the Government of National Unity, which represents a majority coalition with the ANC as a senior partner in that coalition, can whip the votes to vote down the report now.
What I don't understand or fail to appreciate is the suggestion that the MPs, when they voted against the report, they were influenced. In other words, it was unlawfully dictated upon them, i.e., they did not vote according to their conscience.
Yes.
Where do we find on the papers the facts that demonstrate that suggestion? You have, in your oral argument, said what the national chairperson of the ANC, Mantashe, said.
Yes, yeah.
If that's the reference that you think it is, it's neither here nor there.
Well,
in other words, you would have to say the members did not bring their independent mind to bear when they voted when they voted against the report. I don't want to put it as high as that, but it would seem to me that, let me just say the way it is. You may be insulting their intelligence to say they were just told, go and vote this way. Don't even exercise your discretion. That can't be right. I don't know where can one find that. But if this court were to be attracted to that invitation, it's a difficult path to follow. And this court would be entering into the terrain of political rights, number one. Number two, the MPs are in parliament because of the confidence the electorates have on them. That vote for yea or nay represents, or it's a mandate that is carried from the electorates. So in other words, you would invite us as the court to look at the issues de novo and say, you may have voted the way you did. We don't think you voted correctly. We think this is the correct way to vote, or you go and vote again. I don't think we can do that. I don't think we're competent to do that. This is the will of the people. The people at that time were the ANC, which had the majority vote. I'm not sure we can do that. And I'm also not sure whether there is any evidence except the pronouncement made by Chairman Mantashe when he says, ask or check what Makosi caused.
Yes.
But that's
Justice Matopo, may I just start with the second argument, the second proposition first, which was about democratic will, and that the court must have some restraint in engaging that where there's an expression of democratic will. You'll remember that that argument was tested in the SCA in the DeLille matter, which was one of the first matters where parliamentary proceedings were subject to constitutional control. And one of the arguments that was raised by and I speak subject to correction, but by Ms. DeLille, was that if she was subjected to disciplinary measures inside the House, that which would have the consequence of her being excluded from participating and sitting as an MP, that would have a political consequence for her voters because it means they would effectively be unrepresented. And that's the other side to the coin of the way in which you've constructed democratic will for me. And that argument was rejected in terms because the SCA said that even though that consequence may be whatever that consequence is, i.e. that an MP elected by certain voters might not be sitting in the House, that does not change or derogate from the court's obligation to make sure that when Parliament engages whatever it does, be it a disciplinary measure or an internal procedure, that it does so for lawful reasons. So we would say that the response to the political will argument is the lawfulness of the reasons relied upon to take that particular decision. And if unlawfulness can be founded, then that's sufficient for the court to intervene and invalidate.
But let's not lose sight of the fact that the vote was underpinned by a report which the members of the majority of the members of the National Assembly thought it was fundamentally flawed.
Yes.
They exercise a proper discretion, according to them, to say, we are not being dictated upon. We have seen, we have read the report, we think the report conflates, and they listen to their parliamentary leader former Minister of Justice who explained to them what the report was in essence saying. And they said, okay, we agree. And it's not like they just followed that mechanically. They exercise their mind. It's different from the Delile scenario. I think Mr. Katz must have appeared in Delile.
That's right. I think that's right. Now, with all due respect, I would disagree.
You can disagree.
Yes, and I think you know the contours of my disagreement, which is that the principle that was upheld in Delile is that unlawful conduct by Parliament, even if it results in individual MPs being prejudiced, with the further consequence that that individual MP's voters may be prejudiced, is a result that is acceptable in our Constitution because Parliament must be held to a standard of legality. So where there is unlawfulness, and in here we say for the substantive reasons and the distinction issue which you've heard me about this morning, and if that's found to be a bad reason, then the court is entitled to invalidate. So those are that's the nature of my disagreement on the will of the majority argument. Because if that were the case, every constitutional challenge brought as against a piece of legislation could be thrown out on the basis that that act is an expression of the majority, however constituted. But the court doesn't just simply end the inquiry there. The court looks at, yes, sure, that's a legitimate exercise of democratic power, but what are the constitutional consequences of that piece of legislation? And if it's unconstitutional, then the court has no regard to the fact that it might have had a huge majority. It's unlawful, you must strike it down.
But that's a different inquiry. Let's not borrow and import something that is not here. Let's zoom in and bring something and localize it here. Here it's a report, and you contend that the report, there was nothing wrong with it, and you contend that the majority party that voted against that report, their conduct is unlawful. They say it's not. It's a finding that we have to make.
Yes.
And in the absence of any evidence directing us to the unlawfulness on their part, the report would stand. And if the report stands with its flaws, it's a problem. If the report cannot stand, your first prayers must fail.
I accept,
you accept it.
I accept the way in which you construct the case, but you understand my disagreement with that conclusion.
Yeah.
Because obviously that invites the court to interrogate those reasons, and you've heard me earlier today about why those reasons are not good. But may I just answer this question, because I think what's happening is that there's potentially an evidentiary burden that is sneaking in perhaps that my client bears in terms of demonstrating the evidence around this political reasons and political dictation. And you've already mentioned EFF2, you know what we say about EFF2 and that article. The other factual record reference I'll give you is from EFF6, which is at page, I don't know how this works. What page number is this? Oh, thanks. Is at page 257 of the record. Page 257 of the record, if I'm right, that should be volume 3. And what we draw attention to here is look at what the individual ANC MP says. And I'm not hooking the entire submission on this, I'm just saying here's another indication of the reality of how politics operates in the House. Is Ms. T. Mohammed Phala. Yes, Mohammed
She wanted
Phala.
correction of her votes, whether it should be yes
Correct.
or no.
So that's it. But even if we didn't have that evidence on the record, the debate goes back to that earlier Glenister point that I made, which is that it's not wrong for a litigant to say that the structure adopted in decision-making lends itself towards unlawfulness, and that the basis of the attack which is being launched, and which my clients have launched, is to remedy that potential unlawfulness which stems from the structure as it exists. And so we would say, never mind the evidence, there's also the Glenister line of arguments which allows us...
Sorry, before you leave this point, doesn't that interchange or reference to Mrs. Mohammed Phala indicates that she looked and realized that her vote was wrongly captured she wanted a correction of that, and that in itself would mean that she exercised her mind.
No.
Or we should read into it that she had been influenced.
But look at her actual words, because that's important then. Because what the actual words say is, it says, "It came to my attention that my vote for party line is captured incorrectly. Vote for party line is no." And then she goes on to say, "It came to my attention, interjections, that it was recorded as a yes. I vote no, thank you." So what she herself tells you is that it's not a separate application of her mind, it's that she was responding to her party line. And remember, there's a distinction here about the party line. I think, based on UDM at least, if it was a nakedly political party line, so in other words, Minister Lamola said, whatever this report says, as an ANC MP, you vote against it, come hell or high water. That would be a clear violation of UDM. But in this particular context, there's a clash here between a party line which is constructed on what we say is an incorrect evidential threshold, which is then dictated to party MPs to vote it in a particular way. And when her vote is accidentally recorded as going one way, she stands up and she says, "I'm sorry, my vote according to the party line should go the other way." And that takes us back to the UDM territory of the clash between political direction and constitutional obligation in terms of the oath of office. And we say that that's the territory we are in.
But we all live in South Africa. And we know how...
Last time I checked, yes.
Yeah, we all live in South Africa.
Yes.
What's wrong with voting according to party lines?
No, but
it's happening all the time.
No, but may I suggest this, that argument...
All political parties
yes.
vote according to party lines.
That's perfectly correct, but what UDM foreshadows is the clash between those party lines and constitutional obligation. But if we step away from that UDM clash point, and let me accept for the moment what you say, that party lines are perfectly legitimate, then what that invites is the party line given and relied upon, and whether that line is a lawful reason. And that takes you to the first example I sketched out.
It's something else.
Yeah, so I think, yes, that's what I would say.
All right, let me conclude.
Sorry, there was a second response I owed you, okay. I think. The first one was about the will of the people. Judge, I'm in your hands.
Let me conclude.
Okay.
The difficulty that I have, which has been shared with you by all my colleagues, it's the hurdle that you have, for a lack of better word, carefully sidestepped, the one relating to the delay. You haven't told us why. You had an opportunity, my sister Tyrone took you through your affidavits, your replying affidavit when there was an opportunity to do that, and you elected, wisely or unwisely, not to frontally deal with the question of delay, on the basis that you're seeking a declaratory order, you can bring it any time, you're not hit by the review. I don't think you're right. And I don't think that argument is sustainable. And if I'm correct, will it be appropriate for this court to dismiss the application purely on that basis alone?
No.
But why should we deal with other issues? You've got a delay of about 14 months, which is unexplained.
Well, may I give two references? Both are judgments of this court. The first one is Khumalo, which Justice Matopo will be familiar with. And at paragraph 52, in response to this particular argument, this is the response to be made. It says, the majority in Quetta held that delay cannot be evaluated in a vacuum, but must be assessed with reference to its potential prejudice, to the affected parties, and having regard to possible consequences of setting aside the impugned decision. And then, that's paragraph 52 of Khumalo. And then in Tasima, at paragraph 163, where that court in Tasima referenced Khumalo, at para 163, the court said, this court emphasized that an important consideration in assessing whether a delay should be overlooked is the nature of the decision. This was said to require analyzing the impugned decision within the legal challenge made against it and considering the merits of that decision. So insofar as delay is an obstacle that stands in my way, so to speak, I am willing to accept that delay may be relevant for the purposes of the remedy that the court ultimately grants. But it is not an ouster to the court to consider the merits, because that is the question of right which is linked to 1721A. And that's the rights issue, the merits of the challenge. Ultimately, you might conclude that the merits of the challenge are good, but because of the delay under 1721B, you're not giving me any effective relief. That would be competent for you to do. But delay on its own with respect is not an ouster to the court's ability to adjudicate the merits of the matter. And the court doesn't have, with respect, a discretion to elevate a factor that should be considered in the second leg of a discretionary order test, which is, do you get the relief you're asking for, and elevate that and import it into the first leg of the test so as to not engage the first leg of the test at all, because that, with respect, would be a misapplication of the test from Cordian Trading and the cases that followed, Minister of Finance versus Oak Bay and others, which this court has approved of.
But is that not a bridge too far?
No, with due respect, it isn't, because what we also know, for example, in moot matters, where the court considers moot matters, in some instances, even though the relief may be moot, like if you consider the al-Bashir case, for example, after he left the territory of the Republic, any order that was granted by the court could not have been effected against him because he wouldn't have been able to be arrested. But notwithstanding that, the court pronounced upon the meaning of Section 4 of the Implementation Act, and it did so under the interests of justice. So even if, the point is, I suppose, even if delay is as bad as it is, and that's a factor that I can't run away from, it might be that it colors the remedy of the court, ultimately, but not as to the merits of the challenge.
So in other words, we have to deal with it to get to the report and find out whether the report is correct or not.
Yes. Whilst I'm dealing with that, Justice Matopo, I think in our earlier debate there were, and also I think perhaps with Justice Colopin, there was reference made to the Tuta judgment. I can't remember if...
I did.
It was...
It's me.
It is Justice Matopo.
Justice you want to debate it with me?
Pardon?
You want to debate it?
I just want to give two references. I don't know that I necessarily want to debate it with you. The first one is that I would respectfully submit that you'll recall what I read out earlier about how the panel construed sufficient evidence and how it used prima facie and sufficient interchangeably. You'll recall I read that out for the record. It's that para 75 from page 90 of volume 1. And what we would submit is that conflation of the terminology, if we accept it's a conflation of the terminology, is not a conflation of the substance and the threshold that the panel satisfied itself with. Because what Justice Unterhalter says at paragraph 51 of Tuta is he illustrates where that kind of conflation would be an issue in respect of the ultimate outcome. He says the following, and I apologize, I'm reading from my phone. It says, perhaps in contemplation of this difficulty, applicant's counsel in oral submissions before us extended the remit of the applicant's appeal. Counsel submitted that the trial court had, in addition, failed to formulate the correct test for putative private defense and then applied the wrong test to the evidence. That, of course, is an error of law. It carries the risk of unsound conviction and unfair trial and does engage our jurisdiction. And what we would say is that's not the territory that the panel is in. Because in that paragraph 75, even though they subsequently use the phrase prima facie evidence, what they are at pains to say is that their understanding of prima facie evidence is the same as meeting the sufficient evidence threshold. That's the first reference, if I may. The second reference that I will give in respect of that is paragraph 153 of that judgment, which I understand comes from the minority judgment of Justice Colopin, and what that says.
What paragraph is that? 153?
153, yes, Justice Matopo. I think it's on internal page 49.
153.
What Justice Colopin says here is, first, and if I can find it, firstly, there simply cannot be any ambiguity. In the ex tempore judgment, the test is correctly formulated as subjective. There is the labeling of the test as being objective, which I have sought to demonstrate could have only been a patent error if indeed it was a term used by the judge. This, coupled with the recognition in the first judgment that the words objectively considered may have been benignly intended, must reduce the scope for ambiguity. Again, the phrase objectively considered cannot be viewed in isolation. And we would say that's the correct approach with respect to take here.
But you know that my brother Colopin was in the minority.
Oh, I'm not disagreeing. All I'm saying is that that's the exact facts that we find ourselves in here, because remember the majority judgment and para 53, or 51, which I just relied on, I say with the greatest of respect supports my contention and doesn't detract from it. So the way in which I read this judgment with respect is that it's supportive, both the majority and the minority is supportive of what the panel did.
Thank you, Mr. President.
Thank you, Justice Matopo.
Mr. Premier, just with regard to the principle of the separation of powers.
Yes, Justice Eagleman.
How far should this court go in telling Parliament how to do its work? Or can it?
It can. That's how constitutional supremacy works. But the point at which the line is drawn, with all due respect, must be determined on a fact-by-fact basis. If it's something that is patently unlawful, it would be a bit odd under our system of constitutional supremacy that a patently unlawful decision, however you define the unlawfulness in the hypothetical example I'm giving, could stand purely on the basis of separation. That becomes justiciable because of the unlawful consequence. In this particular case, the debate is a little bit narrower than that, because what we're saying is that it may be open to argument. It might not be patently unlawful, but what we're dealing with here is we're dealing with a situation where the ostensible reason given by the majority might, if the court drills down on it to interrogate the sufficiency of that reason and the consequences which flow from that decision, results in an unlawful outcome which the court must remedy. So I can't posit it in a hard and fast rule, but that's the way in which a basic structure of our state works in terms of constitutional supremacy, is that the court does actually have, under its enforcement of the constitution powers, quite invasive powers against another organ of state. And what we're suggesting is we're not asking the court to eliminate Parliament entirely. We're asking the court to preserve Parliament's participation. But where it does so appropriately so as to counteract any potential abuse that arises from the majoritarian nature of our political system, which is what EFF2 tried to do. So that's as far as I can take it with respect, Justice Eagleman.
Thank you, Mr. Premier.
Chief Justice, there needs to be a little musical chairs so that our learned friend, Mr. Katz, can come forward.
We'll wait.
Do we have your leave to rearrange?
Yes.
I'm indebted. Thank you, and thank you to the members of the court.
Chief Justice, I think the chairs have been rearranged. I hope I'm not on the Titanic, in the sense that I intend in my half an hour to try to assist the court in understanding the African transformation movement's understanding of the debate that has just happened in the last 2.5 hours, and to explain why the ATM suggests the relief that I'm going to suggest at the end of my presentation. And may I take the court to page 1, where there are a number of prayers that the EFF ask for. There are 8 substantive prayers, and we're going to submit that prayer 1 is the exclusive jurisdiction prayer, and that goes without saying, should be granted if the court's of the mind that exclusive jurisdiction is present. We submit that prayer 2 should be granted on the basis of the evidence presented, as well as, importantly, the arguments presented by the President, the Speaker, and the ANC to this court. Because that's what I'm going to focus my address on. What are the arguments by the President, the ANC, and the Speaker? And we submit that the relief that is sought by the EFF and by the ATM should be granted on those arguments. Prayer 3 and prayer 4 we do not ask for. We do not think it's necessary if the court gives prayer 2. Prayer 5 is the substitution prayer. We do not submit a case as appropriate. This case is inappropriate for a substitution case. Prayer 6, we submit that 6.1 ought to be granted in perhaps a slightly different form to the way it's currently crafted, but I'll come back to that. Prayer 6.2 is not necessary. Prayer 7 may or may not be necessary, but it's probably not, but we'll come to that. So the court will understand that the ATM submits that 1, the rule is bad. And once that's the case, if we are right, that the rule doesn't give effect to EFF 2, read with Section 89 of the Constitution, there are a number of consequences. The first consequence is that the applicants, that both the EFF and the ATM, are entitled to a declaratory order that the rule is unconstitutional as a matter of law. The second consequence is that when the National Assembly voted in terms of the rule to let's call it strike down the report or avoid the report, whatever words one might use, it then acted unlawfully because it was acting in terms of an unlawful rule. So that's the primary argument that we make. The rule is bad. We don't submit in the alternative that the resolution was bad, but we submit that the resolution was bad on the basis of that which the President and the ANC, not the Speaker, on that which the President and the ANC tell this court about how that vote took place. So the ANC, if I may just jump to their heads, they tell the court what was going on here. And they say in their heads of argument, the easiest place to find it in paragraphs 4 and 5, they explain in paragraph 4 the correct facts. And let me just start in paragraph 4.5. The ANC say in their heads of argument that prior to the determination of whether there should be an impeachment committee, there had to be a valid report of an independent panel. The existence of a valid report was a jurisdictional requirement. Absent a valid report, there could be no lawful inquiry. And then in the next paragraph is the key. They tell the court why the panel report was invalid. And they say in paragraph 5, given the fact that the panel's report was riddled with legal and factual errors, and then there's another important point, which I add to it, in addition to other pending procedures such as investigations by the Hawks, the ANC took the view to be unconstitutional to proceed. Now I ask this court, what have the Hawks got to do with this case? What has the Reserve Bank got to do with this case? What has SARS got to do with this case? What has the Public Protector got to do with this case? Nothing. They are not involved in impeachment. They are involved in criminal investigations into the President's conduct, whether he violated the foreign exchange control regulations, whether he violated the VAT Act. Nothing to do with impeachment. There's only one body that can deal with impeachment, the National Assembly. So how can the National Assembly, because, well, not ANC, how can the ANC come along and say, we're not voting for this report because there are other pending procedures with nothing to do with the National Assembly? So I start off by saying the ANC's primary reasoning in paragraph 5, and I'll come to how it fits in with the reasoning of the problem with the report. They say they didn't have, and it's in the report itself, the court will see, that the evidence hadn't been complete by these other bodies. Well, what could the ANC have done rationally? They could have said to Parliament, let's wait, let's postpone the vote. But how can they vote down a resolution on the basis of other pending proceedings in other bodies, other state institutions? And we say that in and of itself is the height of irrationality. Even if one accepts the debate that we've had this morning concerning the question of whether the panel got it right on prima facie and the question of sufficiency. But by the way, the ATM says the panel's report is perfect. It's inch perfect. And any suggestion that it was riddled with legal and factual difficulties is wrong, and I'll come to that. But at first instance, there are two reasons. If one of those reasons is bad, we win. That's this court's jurisprudence, Westinghouse, etc. If there is a decision maker, such as Parliament, egged on by the ANC, and one of the reasons by the ANC which eggs on Parliament, one of those reasons is bad, the decision is bad. Can't save it by saying, oh, well, there's a good reason because the report was riddled with inaccuracies. Now we turn to why was the report riddled with inaccuracies? Well, the report was riddled with inaccuracies because of what is stated in paragraph 30 of the ANC's heads and what is stated in the President's heads. Perhaps the President's heads do it in perhaps a neater way, and that is in paragraph 52. They start with 3 reasons. This is the panel report. So this is why the President says the panel was bad. And they give 3 reasons. The first reason, the panel misunderstood its mandate. That's the sufficiency of evidence prima facie issue. And there are 4 paragraphs dealing with it, 52, 3 and 4, 54. Then the next problem that the President says was a problem with the report is, this is above the paragraph 55 of the President's heads, the panel equated evidence with information. It's another problem with the report, the President says. And the third one is, above paragraph 58, no inquiry into bad faith. 3 reasons why the report is bad. That's what the President and the ANC rely on. The ANC in paragraph 30 sort of develops it in some kind of a nuanced fashion, but ultimately that's what it's about. Let's start off with the third one, bad faith. The court has to do one thing to find that that reason is what I'm going to call in Cape Town terms a rubbish reason. Paragraphs 58 to 63 of the panel report, it's pages 86 to 87. There, the panel deals with bad faith. It explains what it understands by bad faith in detail. So when the President says to Parliament, so when the President says to this court, and the ANC says to Parliament, the panel got it wrong because it didn't deal with bad faith. Of course it did. Look what it said. If one turns to paragraph 63 on page 86, the paragraphs start a bit earlier. And bad faith is peppered through paragraphs 58, 59, 60, 61, dealing with what the Chief Justice Mufweng said in the Public Protector of the South African Reserve Bank case. 63, they conclude, and they go to the dictionary definition of bad faith. Paragraph 63, we think that bad faith can be inferred from the nature and the circumstances surrounding the violation of the Constitution of the law, Constitution or the law and misconduct. An example of bad faith comes to mind where President dismisses a Director General because he wants to appoint in his place his relative. And then it explains where the president gets it wrong. He acts unlawfully, but not in bad faith. He's given advice by a lawyer, and the president makes a mistake. He brings the Pharmaceuticals Act into operation. It wasn't in bad faith. He made a mistake. He acted irrationally. Bad faith is when he wants to appoint his relative to the Director General, or he gives a criminal a pardon because the criminal paid him to do so. That's bad faith. And the question arises, we've been in democracy for 30 years. How long will we wait for a president to come to a panel and say, yes, I acted in bad faith? Never. It'll never happen. Every president will come to the panel and say, I acted in good faith, I made a mistake. So the bad faith argument by the ANC, the one of the three pillars, falls. The panel did look at bad faith, and it said, we're going to look at what happened. The couch, the reporting to General Roda without going to a proper policeman, all of those things. And the panel says that that's bad faith, wrongly or rightly. But you cannot criticize the panel for not inquiring into bad faith. They did. The second, let's go going backwards, the second problem that the president identifies. The president equated evidence with information. Well, let's look at what the rule actually says. The rule says what the panel can do to come to its decision on sufficiency of evidence. It's in 129G and 129G. 129G, paragraph 1, paragraph C. It says, in considering the matter, the panel may, in its sole discretion, afford any member an opportunity to place written or relevant written or recorded information before it with a specific time frame. Must provide the president immediately with copies of all information. Must provide the president with a reasonable opportunity to respond in writing, etc. 4. Must not hold an oral hearing and must limit its inquiry to the relevant written and recorded information placed before it by its members, and must in its report include any findings, including the reasons for such findings. And now what the ANC and the president do is they say, there's a heading, they say, when the panel looked at the information, it was a flawed consideration because it could only look at admitted evidence as per a court of law. Wrong. It's information that will give rise to sufficient evidence or may give rise to sufficient evidence. How can the admissibility of information from the president, who may only write, they can't hold hearings, how can that ever be equated to the requirement of admissible evidence in a court of law, an affidavit or a person who swears on oral oath, and you can't even have an oral hearing? That would be counter to common sense. So the ANC's and the president's criticism of the report on that leg also fails. So 2 out of 3 were knocked out. We don't need to go to the third one, Justice Matopo, etc., on the question of the distinction between prima facie evidence and sufficient prima facie case. Not prima facie evidence, there's prima facie case, and sufficiency evidence. The Makwakwa case raised in the debate with Justice Majid is an interesting one. And it's for this reason. In South African law, under Section 10 of the Extradition Act, 10.1 and 10.2, court will look at that. The question arises as to whether in the foreign state who sends an extradition request to South Africa, Justice Roy, there is sufficient evidence to warrant the prosecution in that state. And what happened in Makwakwa, so sufficiency of evidence to warrant a prosecution, that's the term of art in South African law. And I'll come to a broader argument about that term of art, sufficiency of evidence. It's 1962 piece of legislation, which was amended, I think it's the early 2000s, to include that section, sufficiency of evidence. I think in 1962 it was prima facie evidence, but it's not relevant, I'll come to why it's. And what happens is Section 10.2 says, when the foreign state requests extradition for determining the sufficiency, whether the foreign state has sufficient evidence to prosecute, a certificate from the foreign prosecutor suffices. What happened in that case? The foreign prosecutor in Lesotho says, we don't know, he didn't say it, it's what actually happened. He issued a certificate, and the certificate said, we, the prosecutor, have prima facie evidence to prosecute the man. And the defense in South Africa said, the certificate says they've got prima facie evidence, but he's got to show it's got to be sufficient evidence, a la Section 10.1, and read with Section 10.2. Therefore, I win my extradition, because the certificate is bad. The High Court said no. And if one reads paragraph 40 of the High Court judgment, the point is very neatly made as to why the notion that this court has been debating about this big difference between prima facie case and sufficiency of evidence is really a red herring. And let me be the first to say, I know the debate, I think it was with Justice Majid and Mr. Premid, touched my heart on the question of, if in a criminal matter, if the trial judge gets it wrong, of course the conviction must fall. And in the case of ATM in the Supreme Court of Appeal, when Mr. Premid acted for the Speaker, I acted for the ATM. And I lost in the High Court, and I came to the SC and I said, hey, the Speaker got the test wrong. The UDM case had given a blank slate, and the Speaker said there's a default position. You can't have a default position if there's a blank slate. And the SC upheld my argument. The point I make is, I accept, as I must, that if the decision maker gets the wrong test, like the criminal court gets the wrong test, as a matter of principle, the conviction would be set aside. As a matter of principle. But what's the principle here? There's none. And let's read Makwakwa. Paragraph 40. There are varying degrees of prima facie evidence. Prima facie evidence can consist of incomplete evidence, for example, a single piece of, because remember, this is an answer to the question of the certificate from Lesotho saying they've got prima facie evidence which doesn't satisfy the South African Section 10 test of sufficiency of evidence. And this is what the High Court says, and we submit correctly so. So, what does it say? For prima facie evidence can consist of incomplete evidence, for example, a single piece of circumstantial evidence, a fingerprint, which will easily dissipate in the face of a plausible explanation. On the other hand, it may be a strong prima facie case, e.g. eyewitnesses, forensic evidence, and a confession. Prima facie evidence at its weakest is sufficient evidence to institute a prosecution. Highlighted. Prima facie evidence to warrant a prosecution in all manifestations, weak or strong, will therefore constitute sufficient evidence to warrant a prosecution. End of the story. There's no debate. I want to add to that. All over the world, in these kinds of cases, you have different tests. In the United States, it might be probable cause in some states. In Europe, there's different standards in the criminal prosecution, when you start and when you don't start. And I take Justice Colopin's point, that there's a difference in use of language, and there's the answer, Makwakwa. It's a different type of debate, when the Speaker tick box, and when the panel tick box. So we submit, we only have to come home on one of the four. The further evidence that they're waiting for, not a good reason to strike down the report. Of the other three, all three are bad. The President and the ANC's reasons, all three are bad, but we only have to come home on one of them, on Westinghouse. So we come home. I turn to the rule, because I've made the point that the rule is bad vis-a-vis EFF 2. I have to accept there's a delay problem and a potential mootness problem. I agree with Mr. Premid fully that the court, as we would submit, is obliged to consider at least the rule. The rule can never become moot. The rule's on the books today. It's a new parliament, it's got the same rule. So mootness is a red herring as far as the rule is concerned. In principle, I suppose, in principle, but I don't concede it, in principle an argument could be made that the striking down of the resolution could be moot. But we don't concede it, but that's just an in principle argument. As far as delay is concerned, Any one of the 400 members of parliament today could bring a challenge to the rule. And nobody can accuse that member of parliament of saying there's a delay. It's a rule, it's alive, it's operative. And either it's bad or it's good. It can never be suggested that this court could abdicate its responsibility to avoid looking at that rule now. It's on the books. So why do I say that the rule is bad? Well, we've had debates about what the Assembly can or can't do in order to achieve the result of an ultimate Section 89 impeachment. And I want to turn, well, before I do that, let me turn to EFF 1. I see EFF 1, Justice Matopo had a long debate with my learned friend on the question of the people telling their representatives what to vote or not vote, or the representative issue, separation of powers. Justice Sigurban raised it. Many of the judges have raised it. The court will be minded to consider paragraph 10 of the order in EFF 1, the Nkandla judgment. And this is what this court ruled. Chief Justice Mogoeng, the resolution passed by the National Assembly, so it's a resolution passed by the National Assembly, that's what we're busy with here, absolving the president, it's a different president, it's the same thing, absolving the president from compliance with remedial action taken by the public director, and you could take those words and put them in here, from enjoying the benefits or the disadvantages of an impeachment committee in terms of whatever section it is inconsistent with the Section 42.3, 52.2a and b of the Constitution, invalid and set aside. So this court is well geared toward taking on the separation of powers red herring. It's done so, it did so as long ago as Mohammed, Tak, Grootboom. Separation of powers means this court's got to do what this court's got to do, and if there's an unlawfulness or an unconstitutional behavior by anybody, including the National Assembly, including the President, this court has a constitutional obligation to say so. So separation of powers doesn't come into the picture if the National Assembly acted unlawfully. I've already showed you that it acted unlawfully because it acted for two big reasons, one of which had 3 tributaries, all 4 are bad. On the ANC and the President's version. So we come to why I say this rule, 129I, or 129I in the context of 129 as a whole, is bad. When one looks at the majority in EFF2, one has to compare it with what the minority said, because it doesn't help to just see what the majority said. As we understand it, there was a complaint about the President, former President, and there were no rules set out as to how to get to a final vote on impeachment. And what the majority said, there need to be rules specific, a rule, dealing with impeachment like Mazibuku versus Sisulu in the motion of no conference context. And there wasn't such a rule, therefore you, National Assembly, go and make a rule in order to comply with the Constitution, and they made a rule. But in making that rule, they had to look at what was the rule about. So I'll start off at 192. Because what 192 of EFF2 does is it tells Parliament what it can't do. And what it can't do is have a political majority stymie an impeachment committee hearing if there is prima facie evidence, sufficiency of evidence. That's what it tells Parliament to do. And that's exactly what Parliament has done in this case. It is allowed for the 129 process to be politicized by that vote after the panel reports. That's what JAFTA JA warned against and said, you can't do that. And that's what they've done. So in 192, the rules relevant to the establishment of the committee, those are the ad hoc committees that Parliament can establish, which the minority found were okay. And now he says why they're not okay. Do not determine the size of a committee, nor do they require that all parties be represented. They merely state that the resolution establishing such committee must specify the number of members to be appointed or their names, if more than one party is represented, etc. The majority party would have majority representation. Now we start. This raises the risk of an impeachment complaint not reaching the Assembly, even if the resolution established in the committee were to stipulate that what was before the committee may not be decided by consensus. There, I underline the following sentence. A decision by members of the majority party in the ad hoc committee may prevent an impeachment process proceeding beyond the committee to shield the president who is their party leader. That's what happened here. In recognition of the point that impeachment proceedings are partisan, the acting speaker said, the initiation of such proceedings is inherently partisan. Acting speaker in that case said that. As the aim from the outset is the removal of the president, who will almost always be the leader of a party represented. And then 193, 193 segue into the point that I'm going to finalize my presentation on. In the context of section 102 of the Constitution, this court in Mazibuko, I've indicated the reference, the proposition that the tabling of motions of no confidence envisaged in that section with only the support of a majority was consistent. This court said that was rejected. That proposition was rejected. And I'm asking this court to reject what happened here in the same way. Because what 129I does exactly what was rejected in Mazibuko and in EFF2. It's a repeat. Repeat, repeat. That's what this is. A majority decision, this court said in Mazibuko, a majority decision of the program committee on the scheduling of a motion of no confidence could frustrate the vindication of the right envisaged in 102. This would be so because, again, as in the case of consensus requirements, it would be within the discretion and generosity of the majority within the program committee where the motion of no confidence the president would ever see the light of day. And now the important sentence, which the rule gives absolute violence to. By parity of reasoning, the committee system is not suitable here too. So what the court says is this, what this court says is where you have a committee system where the majority determine whether the thing should go forward. Not a good idea, it's unconstitutional because the majority will stop the inquiry which won't see the light of day. We have it worse here because here's a panel report sent to the National Assembly, which could be another term for an ad hoc committee, because an ad hoc committee is just the embodiment of the National Assembly as a whole. So what one has is Parliament may strike down the report with broad, wide discretion, makes no difference. This rule is bad because it falls foul of what this court determined needs to be done when it comes to a Section 89 rule. I've used 7 minutes, 30 seconds, and I'm happy to waive the extra 2.5 minutes, as it pleases you, Chief Justice.
Thank you, Mr. Coates.
Mr. Katz, just briefly, you've referred to the committee system as being bad in imposing, as it were, the tyranny of the majority over the minority.
Sorry, excuse me, sorry.
In imposing the tyranny of the majority over the minority. Now, it's been said that, democracy is probably the worst form of government, but until we find a better system, it's the best we have. Under those circumstances, are you suggesting that the manner in which the National Assembly conducts its business and votes, and it engages the Constitution, but it's also an intensely political process, that this court should, in your invitation to set aside the rules, reach the conclusion that because rules, which on the face of them may be intended for people acting in good faith, could however be abused, and purely on that basis reach the conclusion that the rule is inconsistent with the Constitution? Would that not be, one, placing the court in a position that I don't imagine the drafters of the Constitution could have ever contemplated, is exercising this sort of superpower that even the Constitution doesn't contemplate? And doesn't that undermine, as it were, the workings of the National Assembly? Because in truth and reality, the National Assembly will take decisions that people may be unhappy with, and there might be an abuse of the system in place, But to fine-tune that, to take away, as it were, the exercise of a democratic will under circumstances where it may not be constitutional could have a chilling effect.
Sorry, just
not in this case, but
I missed the sentence because you asked a very important. You put a particular sentence to me, which was a very important one. Could you just repeat it? I just wanted to be clear.
I put many important. All my sentences were important, Mr. Katz. But what was what do you recall of it that was so important? Then I can try and hone in on it.
Let me try and answer all the important questions in one answer.
Okay, thank you.
I have to accept, not have to, I don't have to accept it, we accept that as a matter of principle, ultimately, it's for the National Assembly to determine whether there should be impeachment or not. Ultimately. And when it does so, it must do so rationally, lawfully. But ultimately, it's their decision. If they are paid, if every one of those members are paid to vote in a particular way, yes or no, that's not a lawful decision. And I don't believe that this court could have any qualm with that. So the real question is this: did the National Assembly, and I want to come to, we're not even at impeachment. We're not even at the impeachment committee yet. We're at a far stage. We're not even getting to what the EFF2 said was frustrate and even debate about the issue. We haven't had a debate about impeachment yet. That's the 89 committee. So now what the majority have said is, we're stopping even a debate on impeachment, even though there are prima facie sufficient evidence, bad faith, all of those things in this case. That effectively. Now, can it be rational for them to do so? And we said, but obviously not. How can they strike down a report, if I use that language, when the basis for them doing so, and you've read what the ANC have said, you've read what the President said, is flawed. So they go to the National Assembly and they say, don't vote for this report because it's bad. And then it turns out the ANC was completely wrong. The President was completely wrong. How can this court allow that decision to stand? That would be, in our view, anti-constitutional. It would be an outrageous violation of the Constitution for Parliament to pass a resolution on any matter in circumstances when they were misinformed. They were told the wrong facts, they were told the wrong law, and they voted. I'm not worried about the party system. We understand that. The EFF do it. My client's only got 2 members of Parliament. It's hard for the leader to...
your client is an important party.
It's important that this court recognizes that when Parliament acts, it acts rationally. And whenever it does so for good reason, not for bad reason. And when it acts for bad reason, and an important matter like this comes around every 10 years, impeachment of the President. And if we stand back, I mean, the elephant in the room, what's the elephant in the room? A couch with $500,000 there, unaccounted for. And we all just turn a face to that. That's what the elephant in the room is. And the President hasn't had his day in court. He hasn't had his inquiry. No tax. Reserve Bank say they've got no record of these money. If it happened to any of us, we wouldn't be sitting with a clean bill of health as it's of today. At least we'd have had our day in court, and we might have won. We might have said, oh, well, it was advice. It was this, it was that. There's the elephant, standing there.
Thank you, Mr. Katz. You've gone considerably way in, beyond answering my question. But just finally, if you say ultimately all that we may need to deal with is the rule, and if there's no application for direct access, then if that's all that we're left with residually, why should this court then deal with that?
Yes, no,
and why would that not be appropriately dealt with by the High Court?
No, I don't say that all you're left with is the rule. I say you've got the rule and the resolution.
No, you said that even if we don't, we are not with you on the resolution, we should at least then deal with the rule.
No, I think the other way around. I think what I said was this: if you're with us on the rule, then we bring both legs, the rule and the resolution. But if you're against us on the rule, then you've got to go to the resolution anyway.
Okay. I'm sorry, Mr. Katz, maybe I sort of misunderstood the important things you said.
I apologize if I didn't make it clear.
Mr. Katz? Mr. Katz?
Oh, sorry, Justice Mashlantra.
Thank you.
No, I saw some.
Okay. I still want to go back to the delay point that you've touched on. And my concern is that the cases that you have referred us to, there the explanation for the delay was provided. And what we have, there is no explanation whatsoever.
Yes.
And normally we get an explanation, we then have to decide whether the delay is undue, whether we should overlook it based on the explanation. What should we do when there is no explanation whatsoever?
I've got two answers.
Okay.
The first is delay is a red herring in this case. It doesn't play a role at all because you can always challenge the rule. You can challenge it today and nobody can accuse me of delay. It's there, it's on the books. For the purpose of the rule. For the resolution, I accept the proposition. The second answer that I give, this is such a serious matter. And yes, I can talk about the elephant in the room and we all know what's going on here. What do the interests of justice say? In this case, excuse the delay, deal with the resolution, and if you find that the resolution was okay, it was rationally passed, then my client has to live with it. He laid the complaint with the Speaker. The Speaker gave him a tick box. Panel gave him a tick box. He hasn't had an impeachment committee hearing. That's serious. It's a very serious constitutional matter. And for this court not to consider the substance of the challenge to the resolution because of delay, we would submit, would not be in the interest of the Constitution. It's as simple as that.
Now, coming back to the rule itself,
yes.
Assuming that the issue of direct access is not a problem,
well,
and then one is able to deal with the challenge. And if we are with you and the EFF on the challenge, the outcome that is sought is that once a report is submitted by the panel, it should not go to the National Assembly. There should be no vote on whatsoever. Is that what?
I do apologize. It was in my 10 minutes, but we submit the following, and I haven't typed this up, and it's not going to be fair on my respondent colleagues, but this is the submission. I had said in my address that 6.1 needs to be tweaked, and this court will decide how to tweak it. Because clearly the rule is, in our view, the rule is clearly unconstitutional. The problem is, and it's a difficult problem, and I haven't got the full answer, how do you tweak 6.1 as the EFF have drafted? How would the ATM suggest that 6.1 should look? And I've got it written down, and it's a simple variation of 6.1. The rule, let's call it Rule 129I, but it's really 129I in context, is unconstitutional to the extent, because that's what 172(1)A tells the court. You declare something, a piece of statute or regulation or a rule, unconstitutional to the extent that, and then you decide what the extent is. It treats, am I right? It treats a determination of whether the president committed a serious violation of the law as a political issue question, and it shouldn't. It's a legal issue. It's a black or white issue. The panel plays no political role, none. And So the real issue is the question that the panel had to look at, the sufficiency of evidence and the Section 89 criteria, should be regarded as purely apolitical. So nothing to do with who the president is, which party he belongs to. Did he elephant in the room the dollars?
So one should look at the substance of the report, and not one should look at the substance of the report, and not a party line or how one should vote. I'm not sure. I missed. No, I'm saying you are saying the issue of party line, how one should vote, should be excluded when it comes to...
Absolutely. When it comes to the question of accepting the validity of the report and to whether to have an impeachment inquiry, there should be no party interference in that decision. It should be, not what I say, it's what this court said in EFF 2. EFF 2 said that. It said, when it comes to whether or not there should be an impeachment inquiry, politics can play no role. I've just read it to you by parity of reasoning. That's what I've read to you. And that's why, when it goes to the National Assembly, and we know, the answer is here, the ANC tell us. The ANC tell us it went along party lines. The ANC looked at the report, didn't like the report, told their members what to do. We haven't got a problem with that, as a matter of principle, for this case.
My understanding of the EFF's case is that, in fact, the referral to the Assembly should be excluded altogether. So from the panel straight to the impeachment committee. That's what they are seeking.
Well, if that's the effect of what I'm saying as well, but that's not for the court to decide. All that the court has to decide what they've actually done. The rule that they've actually made is bad. You don't have to decide how they should fix it, whether it should go straight or whether the National Assembly. That's not for this court to decide. That would be a separation of powers potential problem. All that this court has to do is say it's bad. It doesn't have to say, well, it's bad, this is how you fix it. It's not for this court.
Thank you.
Mr. Katz, you said that the National Assembly decision would fall automatically if your attack on the rule is good. Did I understand you correctly?
This is how I understood my submission. We submit that the National Assembly resolution was bad.
I've heard your argument as to why it's bad on its own, leaving aside whether the rule is good or bad. But I understood you to say in the first instance that if the rule is bad, it automatically vitiates the National Assembly's decision.
The answer, yes. I accept, sorry, Justice Rogers.
Well, my question was going to be that would be true only if the rule were retrospectively invalidated.
I was going to say that. And that goes to section 172, 1B type consideration. I accept that.
And the applicant, at least, I'm not sure if in your client's papers it argued for it differently, but the EFF asked that the declaration be suspended for 12 months. So that's paragraph 7 of its notice of motion.
Yes, Justice Rogers, the answer to that is suspension doesn't mean no retrospectivity.
Yes, but it means that the declaration is not operative at all.
But it becomes operative at the end of the suspension.
Yes, well,
and that's why
that means we can't now take any decision about the National Assembly rule on the strength of that declaration, which has no current effect.
I would submit that they're separate prayers. So that the suspension prayer and the striking down the resolution prayer are different in kind.
No, they are. I mean, they're different numbers. I don't care whether they're A's or B's or 1s or 7s. I'm only concerned just to establish that unless we refrain from suspending the declaration and make it retrospective, which would be the usual position unless we limit retrospectivity, then there is no domino effect on the National Assembly's decision.
So perhaps, yes, Justice Rogers, I have to think about it. I'll come back and reply. But I'd be interested, was my submission that prayer 7 should be granted or not? I just want to remind myself.
My own notes had a question mark against prayer 7.
Okay, yes.
Perhaps you should now say it should be struck
there
out.
should be no prayer 7. That's the answer. Yes, and the reason is, they haven't made out a case for that suspension. My learned colleagues on the right, to speak in the present.
They need to make out a case if the applicant asks for it.
I accept that, but that doesn't mean to say that the applicant has made out a case for it. Justice Rogers, the simple proposition is this. There's no reason on the papers why there should be a suspension. In EFF 2, well, there couldn't be a suspension because there was no rule to suspend. But the proposition... Yes. Well, I suppose... The question, I suppose, is always, if there's no suspension, what chaos would ensue were the declaration to come into operation immediately? And we can't think of any. Well, there's none on the papers. I mean, I know that a couple of weeks ago, I think, Justice Rogers, you weren't in the case, but Justice Madlanga asked me the question that where there's no evidence in a Section 36 limitations inquiry, should the court nevertheless inquire into when it's a rationality challenge? And I answered, I think tentatively yes, and I'll wait for the judgment, but the problem, I don't know what's going to come. But the problem, the issue, I suppose, is that answer in that case would probably be the similar answer here. This court can look and see, would there be chaos were the rule not to be suspended? But I can't think of any. I can't see any new presidents facing an impeachment with a rule that with 129I is bad. Can't see it.
Then my other question has to do with what you read out as to the extent of the invalidity of the rule, the basis of the invalidity that you suggest we might grant. I understood the essence of it to be that it would state that it is invalid to the extent that it treats the determination of the question whether the President has committed impeachable conduct as a political question.
For purpose of determining whether there should be an impeachment committee,
Yes,
that's the essence, yes.
Now, from that, do I understand your submission to be that Rule 29I, as it currently reads, treats that as a political question? In other words, on a proper interpretation of Rule 29I, does it treat that question as a political one, or does it treat it as a question on which members of Parliament must vote according to what they think is right?
Well, we would submit those, the two propositions that you put, the two distinctions are one and the same.
Yes, that's why I put them as I did.
No, but
treating it as a political question is the antithesis of considering what you believe to be right, I would have thought.
It shouldn't go to Parliament because by going to Parliament, it's treated as a political question. Parliament is in the business of politics.
But it has to go to Parliament.
Yeah, well, as the rule stands.
Are you saying that Parliament should not actually be involved at all?
No, what I'm saying, that's what I think I answered Justice Mashlantla by saying that. I'm not giving an answer to the question. I'm just posing what the problem is. When the question goes to Parliament as to whether there should be an impeachment committee at all, it's a political question as to whether there should be an impeachment committee, and EFF2 said that's a bad idea.
Yes, but do you say that by declaring the rule invalid to the extent that it treats it as a political question, do you equate that with saying that Parliament, the mere fact that Parliament can consider that question makes it a political matter?
As it pleases the court.
So what you are saying is that at the stage of the IP report and whether the next step of a referral to the impeachment committee should happen, Parliament must simply not be involved because as soon as Parliament is involved, it is inherently a political matter.
That's what EFF2 says. And we support that.
Well, certain other propositions were put to Mr. Premid by my colleagues to the effect that EFF2 seemed to indicate that Parliament did control the process, and including this question. I might be wrong, but as long as I understand you, you say the first time Parliament must consider the matter is when the impeachment committee has done its work.
Effectively.
Because up to then there'll be a party's motion, a speaker checking that it's in order, an independent panel which does not consist of parliamentarians, then an impeachment committee I assume it consists of, does it consist of parliamentarians?
Only parliamentarians.
Yes. But a small body of parliamentarians, and finally it comes before Parliament to decide do we impeach or not. Do you say then it is a political question?
Yes. Yes.
So at that stage,
yes,
it can be decided politically regardless of the merits.
And one thinks of a classic example. You know, I was trying to think of examples where at the end Parliament could act rationally but reject the impeachment committee's finding that the President had acted in violation of Section 89. Rationally, like emphasized. And one can think of a case where, for example, the President's got a few months to go of his presidency. He's committed a serious violation under 89(1), whatever the sections are, in bad faith. And to impeach him at that point may not be in the interest of the stability and otherwise of the country. And there could be a whole range of, let's call it, extra 89 reasons. It's the best I can give. Because otherwise, we're in dangerous territory of saying that that National Assembly at the end also must be bound by the impeachment committee, and I'm not going to make that submission. Ultimately, it's for Parliament to decide.
Then, if I may say, you may wish to go back and reconsider your formulation of what you're going to ask us to do, because it seems to me not to say directly what you actually intend.
No,
what you actually intend is that the whole of Rule 129I is invalid, because that rule is only concerned with the matter going to the National Assembly. And if that inherently makes every feature of that rule a political question, then you really want, you say the rule as a whole is bad.
As it pleases the court, yes. I did say that I had struggled tweaking it because the way it's formulated currently in 6.1 doesn't give effect to what we really submit should be the answer. I know Mr. Prem has argued for it in the way that I've argued for it.
Yes. You see, my concern was that the way you formulated it would suggest that it could still go to the National Assembly, but the National Assembly and its individual members must not treat it as a political matter.
Yeah, I accept.
Whereas you say it just shouldn't go there at all.
Absolutely. I thank you, Justice Rogers. You've clarified the submission that I wish to have made. Thank you, Chief Justice.
Mr. Katz, I have two issues, but I'd like to start with this one now because it's fresh in your mind. You're an intervening party before the court. Just as a matter of procedure, you seem to want to suggest that we should get rid of paragraph 7 of the notice of motion. Shouldn't you first get a mandate for that, in as much as you're acting for a two-person party then, not the applicant?
I don't say...
I say it tongue-in-cheek only half because I think it's a serious question.
No, it's a serious
whether as an intervening party you can do that.
Well, I'm not sure that we are an intervening party. That's my first answer. We're an applicant. We were a respondent.
Oh yeah, you're an applicant.
What happened here was we were a respondent. And if there's an interesting law, which I've learned, in ATM versus the Speaker of the full bench of the High Court, which is about this very resolution, but whether it should be secret ballot or not. And what happened was the ATM were the applicant, and the respondent included the EFF. And the EFF supported us. And the ANC said, no, they must come in as an applicant if they want to do so, because it's not fair to the respondents. And that's what we recognized in this case. So the ATM joined the EFF.
You also said so in the elections case, that the judgment that I wrote, remember? Oh, you wouldn't remember. But
Which
anyway.
one was that?
But this is the point. You came in as an applicant, but whose notice of motion is this? Is it your notice of motion, or is it the EFF's, or both of you?
Both.
And if it's both of you, is 50% enough to get rid of the paragraph 7? I'm asking it because I think you might take instructions or enter into negotiations with the EFF.
Let me say this. It's actually me talking. I'm also got a responsibility to the court as an advocate. So even if there's what the client might want, I try never to just do the client's bidding. I try to at least make submissions that I believe in. Sometimes I succeed and sometimes one doesn't. But the proposition is, I'm not sure that paragraph 7 of the notice of motion is necessary from a legal perspective, but I'll leave that to the court.
That's the best traditions of the bar, and that's a duty of counsel to the court. You're right.
Thank you.
But here's my problem. If paragraph, I think you have disavowed paragraph 6.1. You see the difficulties there with 6.1.
In its current formulation.
In its current formulation.
I do submit that, as the debate that I had with Justice Rogers, and this court knows from all its cases, Motorclip, Motorfontein, I think it's the Public Protector Gordon case, this court can fashion the remedy even if it's not that which is included technically in the notice of motion. And I've struggled. I'm not saying it's been difficult for me to come up with what would be the perfect formulation of 6.1. But it certainly needs to deal with 129I in a way that I had read, that there should be no political interference before the impeachment committee starts. Whatever you do with 129I, if it achieves that, we are happy.
And my question really is about 6.2. Because if 6.2, if we grant 6.2, what we are saying is this. We say that you have a panel that comes to a decision, and you now bypass the elected members that the electorate put there, and that panel will say there must now be an impeachment committee. In other words, the National Assembly has no say over it. I'm just talking about 6.2.
I haven't asked for 6.2. And that was my answer to Justice Mashlantla. I'm not asking this court to tell Parliament what it must do. What I'm asking this court to do is to tell Parliament that which it's done is unlawful. That's why I stop at 6.1. 6.2 goes that step further.
So one last question from me. I don't know if you have EFF2 open in front of you.
I do.
But you read 193, 194, and 195. I just want to ask you about a remark that Justice Jafta for the majority makes in 195.
Yes.
He says here the applicants did not seek that the rules be declared invalid, that's in EFF2, to the extent that they failed to provide for regulation of impeachment proceedings. But the similarities between Mazibuko and this matter are remarkable. That said, however, and this is the part that I'd like you to consider and tell me if it makes any change to what you've submitted. That said, however, section 102.2 with which the court was concerned in Mazibuko does not require proof of any conditions before a motion of no confidence is tabled, debated and voted on. Here, grounds for impeachment must be established before the motion to remove the president from office is debated and voted on. Does it change any of your submissions, this caveat that is added?
So in Mazibuko, well, I don't have to repeat it, but in Mazibuko, the parliamentarians can decide we don't like this president anymore. Gone. Here, they can't do that for a whole range of reasons. He has to be found, if I may put it that way, jurisdictional fact that he's committed one of the section 89(1) transgressions. That's the difference between Mazibuko and, sorry, the difference between 102.2 and 89. I'm not sure that.
Well, let me put it directly to you. What EFF2 says is that unlike Mazibuko, there must be jurisdictional grounds before you can get to the impeachment.
Yes.
And that is why those jurisdictional grounds must be properly before.
Yes, oh, I see. Yes. That's yes, of course. That's 129. 129 JKMN, all the way through to O. There we have it. We don't have that in Mazibuko. We don't need it in Mazibuko, but we have it for E. That's why there's only a challenge to I. So that's the sifting of the jurisdictional facts.
Thank you, CJ.
Thank you, Mr. Kurtz. We should take the lunch adjournment for 30 minutes. Would you be comfortable with that? Okay. We'll come back at 1:30.
There's one up there.
I just want to explore this with you and interrogate it and see whether it is correct that the President acted in bad faith or not. By virtue of what fact or facts did the panel come to the conclusion that the President acted in bad faith? Because you did not elaborate.
I think what my submission was this, that the rule requires bad faith to be an element of the panel's concern. Not Section 89, the rule. And there might be some argument that the rule goes too far, but that's not before the court. And the question arose as to whether in striking down the report, the panel properly took into account the question of bad faith. So it's not us saying that the President acted in bad faith, it's really a question of whether the panel properly interrogated bad faith. And what the panel did, if we understand it properly, is in the paragraphs that I read, I think it's particularly paragraph 63, the panel said, you can't look at bad faith on the basis of what the President says. So the President didn't. He filed a letter and he said, I wasn't acting in bad faith when I did what I did. He said that. And the criticism by the ANC and the President is, well, the President said he acted in good faith by doing what he did, and therefore the panel was wrong to find that he acted in bad faith. And what the what the true import of the panel's report was this: you can't look at what the President says, you can't look at what General Roder says, you've got to look at all the facts and circumstances, and you draw an inference. And what they did was, they said if you look at all the facts and circumstances, by parity of reasoning, he acted in bad faith. No further than that. And the criticism that they didn't consider bad faith is a bad criticism, because they did consider bad faith. And so the way they dealt with it might not have been the way I would have dealt with it, or the court might have dealt with it, but they dealt with it. Whereas the ANC and the President said they didn't deal with it. That was the high watermark of my submission.
But that is the finding that they made about bad faith.
They were had to.
Yeah. So we have to ascertain the basis of that bad faith by the panel. What would be those facts, the elements of bad faith?
That what the President did once the theft was brought to his attention, you look at what did he do after the theft was brought to his attention, and what did he do before? What was he doing with the dollars in the couch in the first place? What's his explanation? And if one sees that globular picture, the panel says that globular picture points to bad faith. Globular picture, fact by fact by fact. Like in circumstantial evidence. Why is the man guilty? Drip by drip by drip until there's a river. That river is why the man's guilty, not the President. That's how circumstantial evidence becomes evidence to convict a murderer, for example. And what the panel did, drip by drip by drip, why didn't he report it to the proper authority?
But he reported to Rode, his special advisor, or
Special Protection Unit.
Yes.
He's got nothing to do with PRECA or the Prevention of Corruption. He's a security policeman, and he goes to Namibia, Cape Town, and you look at those facts, drip by drip by drip. It's not one fact. And you look at what did the President do, big picture. Why? And the question is, why were the dollars in the couch?
But he wouldn't know why the dollars were in the couch. It's an ex post facto application that he was given why the dollars were in the couch. Whether it's right or wrong, whether it's preposterous, it's something else.
Well,
he was just reporting why the dollars were in the couch. Everybody, you and me, would be astounded to say, why are you keeping the dollars in the couch? But they were there. And they were stolen there as allegedly as we are told.
Well, sorry, with respect, I agree with you, Justice Mantopa, that I would be astounded. I am astounded. I think all of us can be astounded that $500,000 are found in a couch. And there needs to be an explanation for why they were found in the couch, number one. He says, well, I didn't know about it. There were these advisors who put it there. Whatever the explanation might be. But then what does he do? He says to his security guy, go and report it. It's not, oh no, he didn't say to the security guard. He didn't do that. No, he didn't do that. He reported it to the security general. So that's not appropriate. That demonstrates bad faith. With the whole picture, that's the answer. I can't do better than that. But how could, I mean, the question I suppose is this. In a case like this, what would the ATM, what would Mr. Zangulu have to produce by way of evidence to show bad faith? What he produced. And then he says, and then the president goes to the Limpopo ANC, he says, not a problem, I'm a farmer. That's why the dollars are in the couch. That's a violation.
No, that's not what he said. No, that's not what. No, that's not what he said.
Well, that's the debate.
Yeah.
What I'm trying to say is, what was he doing with the dollars in the couch other than business? And Justice Motopo, you put to me, well, there might be explanations for why the dollars were in the couch. There might be, but certainly not one that are consistent with.
There is an extensive explanation given by one of the workers why the money was in the safe, and suddenly the safe is not safe, and they put it in the couch. President doesn't know about it. You and I can look at it and say, with suspicious mind, to say, it's supposed to be safe in the safe. Take the keys with you. But that's not what happened.
Justice Motopo, that's why you have an impeachment committee hearing. You and I think of it. That's what the public are there for. We want to know what happened. You have an impeachment committee hearing by the Committee of Parliament, and at the end of that committee, there might be, the president might come out white as the, well, no, that's, I don't want to be racist, but he would come out as clean as the driven snow. He'd come out clean. No. So the point, that's the truth. He isn't clean at this stage. And the panel fine. He's not clean in bad faith. It's not for, and you shouldn't second guess them, panel. Why should Parliament second guess them? Drip by drip by drip. That's the best I can do. They can't point to a particular thing that he did, which was bad faith. And the question, the real question, leave aside all of the corruption and money laundering, and I'll ask the question rhetorically. What's the president doing business? The Constitution says that when a person becomes a president or a member of cabinet, he must cease doing other business. But that official's got cash in his couch. That's clearly a violation of the constitutional requirement that he doesn't do business.
But is this now your case, or it's something else?
No, it's one of the 4 charges that my client put to the panel, or put to the speaker who put it to the panel. No, they're all there. That's bad faith. There's no explanation for it. So that's why I said it's not, my client put before the speaker 4 charges. I don't need to repeat
Yeah,
that.
no, don't.
All of those might involve ultimately a finding of serious misconduct of the Constitution and the law. But at a prima facie sufficiency of evidence, that certainly meets the standard of bad faith. And the bad faith requirement might even be unconstitutional because that doesn't matter. I shouldn't go there. I don't want to go there. But that's the point. Bad faith was not ignored by the panel. It was dealt with in terms. And for Minister Lamola to say it wasn't dealt with, or the ANC to say it wasn't dealt with, is factually wrong. That's all. I mean, the panel might have got it wrong, but that's not the point. They dealt with it. That's the point. Thank you, Chief Justice.
Mr. Brainbach?
Thank you, Chief Justice, members of the court. In our oral address, we're going to deal with 2 main issues. The first is we will endeavour to explain why the challenge to Rule 129I is ill-founded. And secondly, we will explain why in our submission the challenge to the National Assembly's 13 December 2022 resolution, which was taken in terms of 129I3, has been brought fatally late. Dealing first with then the challenge to the rule. I have to say I was somewhat taken aback by the submissions made by my learned friend Mr. Katz for the ATM on that topic today for the following reason. The ATM applied to intervene as an applicant in the matter. The application was granted by this court on the 29th of August, and this court added that it was granted leave to file written submissions and to make oral submissions. It did file written submissions, and I've checked them again. There is no attack on the rule in those written submissions. The focus is on the resolution of 13 December 2022. My learned friend went further. He argued that some of the relief sought in the notice of motion, specifically paragraph 6.1, should be amended, and that in the absence of an application for amendment. And we heard all of this for the first time today. I act together with my team for the Speaker and for the National Assembly, whose rules are impugned in this matter. And with respect, we contend it is unfair that none of this was raised in the proper way in the written submissions in accordance with the directions of the Chief Justice in this matter. And we will accordingly focus on the cases pleaded in the EFF's papers, to which the ATM joined. Now, they challenge Rule 129I on two grounds, as the court will know. They're advanced as alternatives, and each is coupled with a specific remedy. The first challenge, as we understand it, is that Rule 129I is inconsistent with two main provisions in the Constitution. The first is Section 55(2)(a), and the second, Section 89(1) itself. And more specifically, as those sections were interpreted by the majority of this court in EFF 2. And the reason, as we understand the challenge, is that it's unconstitutional. This is the first challenge, is because it allows the National Assembly to vote against referring an impeachment motion to the impeachment committee in circumstances where the independent panel has found that a prima facie case of impeachable conduct has been made out. And we see that summarized in paragraph 6.1 of the notice of motion. And if that first challenge is upheld, then the EFF, but on what my learned friend Mr. Katz said today, not the ATM, seeks an order directing, and this is paragraph 6.2, that the Speaker of the NA, the National Assembly, amend the rule in such a way that if the panel makes a prima facie finding, the presidential impeachment motion is automatically referred to the impeachment committee. May I just say that, of course, it's not open to the Speaker to amend the rules of the National Assembly. It is a matter for the National Assembly itself, but that is a relatively minor blemish in the case that we are facing today in the greater scheme of things. But as was put to my learned friends this morning, what has essentially been asked is that this court direct the Assembly to take the Assembly itself out of the equation until finally the impeachment committee is reported at the end of an impeachment trial before that committee. That is the remedy that's been sought. But it is, of course, dependent on the underlying proposition that it is unconstitutional for the rules to permit the Assembly to vote against the President's removal, the referral to the impeachment committee in circumstances where the panel has found that a prima facie case of impeachable conduct exists. So the two are inextricably linked, the reason for it and the remedy that are being sought. The second, which is the alternative challenge, second order challenge, is premised on the Assembly having a discretion. The first one, of course, is that there should be no discretion. They must simply be taken out entirely, and there must be this automatic referral. The second attacks the discretion. As we understand it, it is that the rule against vagueness, which is, of course, immanent in the constitutional principle of legality, is infringed because Rule 129I is impermissibly vague, and so the argument goes, it is open to abuse by the National Assembly. And the remedy which has been sought, if that second ground of challenge is upheld, again by the EFF, but not on my learned friend Mr. Katz's showing, the ATM, an order directing the Speaker, again, to amend the rule to include suitable guidelines structuring the exercise of the discretion. Now, before dealing with the merits of those two grounds, and I will deal with the merits and their remedies in one because they really, the one follows from the other. I wish to point to what we respectfully submit is a preliminary difficulty with the first challenge, the one which takes the National Assembly out of the equation. And it is that the challenge doesn't go far enough because it should have been coupled with a challenge to part of Rule 129P sub 2, more specifically the part which provides that a recommendation by the panel isn't binding on the National Assembly. And indeed, there would have to be many other consequential amendments to the rules if the automatic passing of the motion to the impeachment committee were to be ordered. One sees, for instance, in 129J, which establishes the impeachment committee, the rule says it's established to consider motions in terms of a Section 989 inquiry, refer to it in terms of 129I3 above. But I suppose those problems could be dealt with under the general prayer for alternative relief that one finds, further and alternative relief. But we do point out, and this is that there would have to be certain further consequential orders made in order to practically give effect to that. Having cleared the decks with what is now sought in this preliminary niggle, I wish to now deal with what we contend are two fundamental difficulties with the first challenge, the no discretion or automatic transmissibility challenge. The first concerns the principle of separation of powers in the Constitution, and the second concerns the conferral on the National Assembly by Section 57(1)(a) of the Constitution of the authority to determine and control its internal arrangements, and specifically how that has been interpreted and applied by this court in judgments relating to the Assembly's obligations under related provisions, Sections 42(3) and 55(2)(a) of the Constitution, and also obviously EFF 2, Section 89(1) of the Constitution. As the court will have appreciated or will know, that both the ground of attack, this first ground of attack, and the remedy that the applicants are seeking will shift away from the Assembly to the panel the power to decide whether a motion for impeachment of the President should be referred to the impeachment committee. And with the greatest of respect, we submit that if the court orders this shift, that will infringe the constitutional separation of powers of the judicial and legislative branches of the government. Because the result would then be this court, our highest judicial body, dictating to our highest legislative body that the latter must accept the opinion and the decision of outsiders to the NA, in other words, non-members of the NA, on whether the President has a case to answer, in other words, whether there should be an impeachment trial. And that then brings us to what this court, how this court has approached this difficult terrain in its earlier judgments. And we refer in this regard, firstly and in particular, to the approach of the majority of this court in EFF 2. And we stress particularly paragraphs 129 to 131, 179, 180, 196 and 208 of that judgment, as well as obviously the orders that were made to be found in paragraph 222 of the report. And the approach of the majority can be summed up as follows. The National Assembly is the institution which bears the obligation to put in place and to implement mechanisms and processes to hold the President accountable in terms of Section 89(1) of the Constitution. And this is explained in response to, it's explained, by Justice Froneman in his separate concurrence in EFF 2 in response to the Chief Justice Mogoeng's judicial overreach criticism of the majority judgment in that case. And if we refer particularly to paragraphs 283 and 284, in which Justice Froneman, who did concur with Justice Jafta in his judgment, added, according to the second, in other words, the majority judgment, Section 89 requires that before a resolution to remove the President is voted on, an investigation into the existence of the preconditions set out in that subsection must be carried out. The second judgment directs that the National Assembly to make rules for this procedure, and then later on, Justice Froneman said, nowhere does the second judgment prescribe the content of the rules. And that is echoed by this court's approach in the first EFF matter in relation to sections 42 sub 3 and 55 2b of the Constitution. And there this court held that it's the Assembly and not the courts which must determine how best the Assembly should carry out its parliamentary oversight mandate in terms of those two provisions. And we refer in particular to paragraph 93 of the judgment. I won't read all of it. I'll just read a few sentences. It starts by saying, it falls outside the parameters of judicial authority to prescribe to the National Assembly how to scrutinize executive action, what mechanisms to establish, and which mandate to give it for the purposes of holding the executive accountable and fulfilling the oversight role. The mechanics of how to go about fulfilling these constitutional obligations is a discretionary matter, best left to the National Assembly. And towards the end, it is therefore not for this court to prescribe to Parliament what structures or measures to establish or employ respectively in order to fulfill responsibilities primarily entrusted to it. And the last judgment that we wish to, or part of that judgment that we wish to refer to in this connection has to do with the Assembly's duty when presented with important reports or reports of important institutions. Now that case, the so-called Nkanda judgment, dealt with a report by the Public Protector which reached certain findings in relation to the upgrades of the then President's home and held that there be certain remedial steps taken. And this court said in paragraph 87 of that judgment the following of the Public Protector's report. The National Assembly was indeed entitled to seek to satisfy itself about the correctness of the Public Protector's findings and remedial action before it could hold the President accountable in terms of its sections 42.3 and 55.2 obligations. These sections impose responsibilities so important that the National Assembly would be failing in its duty if it were to blindly or unquestioningly implement every important report that comes its way from any institution. Both sections 42.3 and 55.2 do not define the strictures within which the National Assembly is to operate in its endeavour to fulfil its obligations. It has been given the leeway to determine how best to carry out its constitutional mandate. And for all of those reasons, we submit that the first challenge and the relief based on it, the first challenge is with respect bad and the relief based on it should not be granted. Coming to the second challenge, which as will be recalled is that the rule, that's 129I, is impermissibly vague and hence the discretion it confers is open to abuse by the National Assembly. You will recall from our heads of argument that, relying on the case of Van Rooyen, the judgment of this court in Van Rooyen at paragraph 37, we submit that the possibility of abuse has no bearing on the constitutionality of the rule, because should the power be abused, the remedy lies not in invalidating the rule, but in the remedies afforded by our law for abuses of public power. So with respect, we can put that to one side. The real question is whether the, well, perhaps I should just add this. It's only in circumstances, and there will be rare, where an empowering provision is so framed that it will invariably be abused. In other words, it enjoins the repository of the discretion to act in an abusive way, that the Van Rooyen principle won't apply. The real issue here, though, is this rule unconstitutionally vague. And the principle established by this court, one of the principles established by this court in the leading case of Darwood at paragraph 53, is that a rule will not be vague in circumstances where the factors relevant to the exercise of the discretion are clear. Now, if it's of course on its face, Rule 129I doesn't list those factors, but it is now trite that one needs to interpret any provision in a measure like this in its context and with regard to its purpose. The relevant context is provided by the preceding subsections. And the architecture of this rule is essentially this. Once a motion contains allegations which, if established on the evidence, will entail impeachable conduct on the part of the President, that's the screening function that the Speaker undertakes, the so-called prima facie assessment. You look at the document on its face to see if it contains the allegations substantiating impeachment. It must go to the panel. And this is where particularly important to have regard to Rules 129G1B and 129(1)C5. Because what the panel has to do is to look into the information that it is provided with by the sponsor of the motion, by anyone else, that any other members that the panel permits to provide information, as well as the President's response, and then to submit a report containing a recommendation whether sufficient evidence exists to show the President committed whatever the ground of impeachment is, a serious violation of the Constitution or the law, etc., or suffers from an inability to perform the functions of office. And it has to set out in its report the findings and reasons for the findings on which the recommendation is based. We see that from 129G1C5. And we know from Rule 129P, to which I've referred, that this is an advisory report. So the structure is that an independent panel must look into the information and it must produce a report with findings on those matters. And why is that? And the answer is so that the Assembly can decide, aided or assisted by that advice and the analysis of this panel, which have to comprise experts and our legal experts, whether sufficient evidence exists to put the President on trial, an impeachment trial before an impeachment committee. That's the context. And that ties to the purpose. The purpose is of this power conferred on the Assembly by 129I3 is to decide whether the matter must go to an impeachment inquiry or a trial, where the seriousness, where evidence will be heard, and the veracity, and where relevant, the seriousness of the charges will be determined, and that committee will then, in turn, at the end of the trial, submit a report to the Assembly which takes the final decision on whether to impeach or not. So that's the context, and We submit that when Rule 129 I3 is read in context and with reference to its purpose, the factors relevant to the decision-making powers it confers are clear, and it boils down to this. The Assembly must consider and decide whether or not it agrees with the panel's recommendation that sufficient evidence exists or does not exist, as the case may be, to show that the President committed the serious violations of the Constitution or the law alleged in the motion for his removal, or committed the alleged serious misconduct, or suffers from the alleged inability to perform the functions of office, as the case may be. And we respectfully submit, in the light of that, that it cannot be concluded that Rule 129 I3 is impermissibly vague. And for that reason, my clients ask that the relief sought in paragraph 6 of the notice of motion be dismissed. That brings me to the second topic, the challenge to the Assembly's 13 December 2022 decision. You will have seen that my clients do not engage with the merits of the applicant's challenge to that resolution. We've left that to the ANC and to the President to do. What we focus on is why in our submission the challenge has been brought fatally late. I've listened to the debate this morning between the members of the court and my learned friend, Mr. Pramid, for the EFF in particular. And I don't intend to traverse everything in this regard, because in my respectful submission, the issues have been very fully ventilated. I do, however, wish to deal with a couple of points on which we believe we can contribute to this court's adjudication of this difficulty. The first concerns the form of the relief which has been sought and the submissions relevant to the delay issue which you have heard based on the form. The applicants have cast their challenge as a series of declarators, and we submit that despite that, if one looks at the notice of motion as a whole, the relevant paragraphs, the substance as opposed to the form of the relief that they are seeking, or at least that the EFF is seeking at any rate, because my learned friend Mr. Katz said they no longer persist with paragraphs 3, 4 and 5. That's the ATM. But certainly as far as the EFF is concerned, what is the substance? They're asking this court to exercise judicial review of the impugned decision and to grant consequential relief. If one looks at paragraph 5, you will see it's headed pursuant to Pres 1 to 4 above. They want substitution relief, a la Trencon. Alternatively, they want the matter referred back to the Assembly to vote on the panel's report de novo. So they are seeking judicial review and the setting aside of the decision, coupled with either a substitution or a referral back. That's the substance of the case, leaving aside the form. And if you're with us on that, then there is no debate, really, or can be no debate, that the delay rule applies. This court has made it clear in numerous cases that the delay rule applies to proceedings for judicial review. I refer, for example, to Kumalo, the famous Kumalo decision, 2014 5 SA 579, Constitutional Court at paragraphs 49 and following. Yes, that was a so-called state self-review application, but it was an application for judicial review, and the delay rule was clearly articulated and elaborated on and applied to the decisions at question in that case. But even if I'm wrong on the submissions that I've just made about the substance of the relief being judicial review, setting aside, and then one of these two alternatives, we submit firstly that declaratory relief is a discretionary remedy. And in that regard, we would remind the court that the very first authority cited by Justice Conradi in the Naptosa judgment on which the EFF relies, that's 2001 volume 2 essay 112 Cape, and one sees this at 124I. The very first authority is the judgment of this court in JT Publishing, 97.3 essay 514 Constitutional Court, a case concerning a situation where there was a constitutional challenge to an Act of Parliament which had been repealed by another Act of Parliament, although that Act had not yet been put into operation, and what the court should do about that. And paragraph 15 in that early decision really pulls the rug with respect under the EFF's whole argument based on declaratory proceedings and delay. I'm going to couple it with the judgment of the SCA in a case called ConCourt, but the bottom line is this, and perhaps I should just read the relevant portions of paragraph 15. The reversal of the decision reached in the court below brings duly before us the claim for a declaratory order which the applicants wish us to grant on the constitutional issues presented by them. That does not necessarily mean, however, that we are now bound to resolve those issues. Whether we should say anything at all about them must be settled first. I interpose that inquiry because a declaratory order is a discretionary remedy, in the sense that the claim lodged by an interested party for such an order doesn't in itself oblige the court handling the matter to respond to the question which it poses, even when that looks like being capable of a ready answer. A corollary is the judicial policy governing the discretion thus vested in courts, a well-established and uniformly observed policy which directs them not to exercise it in favour of deciding points that are merely abstract, academic or hypothetical. I see no reason why this new court of ours should not adhere to a rule that sounds so sensible. And later on, in connection with section 85 of the interim constitution, which is the equivalent of 172(1)A of the new one, the court continued, a further word or two had better be said on the topic before I leave it. Section 9085 admittedly enjoins us to declare that a law is invalid once we found it to be inconsistent with the Constitution. But the requirement doesn't mean that we're compelled to determine the anterior issue of inconsistency when, owing to its wholly abstract, academic or hypothetical nature, it should have such in a given case, are going into it that it can produce no concrete or tangible result, indeed none whatsoever beyond the bare declaration. And the court will know that our basic problem with the lateness is that the Sixth Parliament came to an end, with it all the business before the Sixth Parliament. The composition of the Seventh Parliament elected on the 29th of May is wholly different to the Sixth Parliament, and there can therefore be no resuscitation of this motion without doing a violence to that very fundamental part of our democracy. Every 5 years we have a general election and a new National Assembly is elected. As Justice Motsopo, I think, pointed out to my learned friend, it's very differently constituted. So we are in a situation of impossibility, mootness. We're in a situation, a Van Wyk and Unitas Hospital situation, as Justice Majid pointed out to my learned friend. The applicants have delayed so long that it is impossible to do anything other than give a declaration in the air in this case. That is not what the jurisprudence of this court tolerates. Both JT Publishing and Van Wyk and Unitas Hospital.
Thank you, Mr. Breitenbach. Questions, colleagues?
Mr. Breitenbach, two issues from my side. The first is that in dealing with the sort of first ground of attack in relation to 129I, you concluded that this court has previously said that it will not prescribe the content of the rules the National Assembly adopts to hold the President accountable, and that the Assembly must determine how best, and that should be left to the National Assembly. But would you accept that there's a caveat to that proposition, that ultimately it must enable the National Assembly to hold the President accountable? Because if those rules fall short, then a court is entitled to say these rules don't do what they purport to do or what they're required to do constitutionally. Do you accept that?
Unreservedly.
Now, in the light of that, you've suggested that Rule 129I, which deals with the consideration and the referral of the panel report, and in particular subsection 3 thereof, must be read to incorporate certain factors that the National Assembly must take into account. But when you read the rule, on the face of it, it simply says, in the event the Assembly resolves that an inquiry be proceeded with. Yes. So it's silent on what factors the Assembly may consider. And anybody reading that may justifiably conclude that the Assembly has a wide, unfettered discretion to do with the report as it pleases. And your suggestion that the Assembly is entitled to question the report or obliged to question and to critique the report on a reasonable basis may not find accommodation in the rule as it stands. And does that not lead to some credence in the argument that it is left really to the total discretion of the Assembly, which could undermine, as it were, any attempt to hold the President accountable in the absence of fettering that discretion?
The answer that I've given to that, and in summary, is that one must, of course, read the rule in its context, and specifically in the sequence of the steps that have to be taken. And we know from the preceding rules, 129G in particular, that the relevant context is there must be consideration of the motion, the information in support of the motion by a specialist independent panel who must advise the committee on whether or not there is sufficient evidence to show or to substantiate the allegations in the motion. And I could only add to this by posing the following rhetorical question. If it were not to direct the Assembly's mind to what we consider to be the, and have submitted is the relevant question, for the Assembly to decide whether there is sufficient evidence, why would the rule have required an independent panel to conduct the preliminary inquiry and to give the advice on that question to the Assembly? And the answer with respect to that is because a decision to refer to the impeachment committee is essentially one to initiate a process, a trial type process on the charges in the motion. And that's the link between what goes before and what goes after. And the seriousness of the matter, as was pointed out to my colleagues this morning, but more importantly, the deep seriousness for the country as a whole of having their president on trial, while the president is also the president of the country with all of the onerous responsibilities that come with that office, require, as the rule the set of rules read as a whole indicate, that only be done where there is sufficient evidence of, for example, serious misconduct.
Sure, I accept that, and the rule is quite detailed in setting out how the panel must go about its work and at what level of sufficiency it must arrive at to render its conclusion sustainable. but it's worryingly silent on what the responsibility of the National Assembly is. And as, if I may say so, reasonable people, we seek to read into Sub-Rule 3 this requirement, but it's not there. And I want to establish from you, are you saying that if the panel produces a flawless report, a report that can't be faulted, that is in full compliance with 129, the Assembly would be obliged to accept the recommendation? Or are you saying that even in the face of such a report, the Assembly still has a wider discretion not to, for other reasons? Let's assume that the report is flawless, but the impeachment of the President will result in the collapse of democracy and anarchy in the country. Will that be relevant?
On my approach, the approach which I've indicated, and I'm just going to break your question into two portions if you don't mind. The first is that the decisional reference do not include the other factors which bear on, let's say, the body politic and the health of South Africa Inc. If I could corporatize this for a moment. But how the rule deals with that is to require us as a country to run that risk only if there is sufficient evidence that the President may be guilty of the charges proffered against him or her. So the decisional referent remains sufficiency of evidence, and one does not take those other factors into account. And as painful as it may be and disruptive as it may be, if that is the Assembly's judgment at that juncture, then there must be a trial. The second component of your question goes to whether the Assembly is bound to accept the recommendation in what you've styled a flawless report. And the answer to that is the Assembly, exercising public power, must act rationally. So it is bound to take a rational decision. And if it engages with the question, the ultimate question, is there sufficient evidence to put the President on trial, and reaches a different conclusion to the panel, in other words, does not accept the advice, but it, in a rational manner deals with that, then that will pass muster. Because, as this court has repeatedly emphasized, it is the National Assembly which ultimately controls this process. And with the greatest respect, the standard cannot be higher than that. But of course, where one is acting irrationally or for ulterior purposes, which would be a species of bad faith, or mala fides, arbitrarily, then of course the courts would be entitled to intervene, and the ordinary remedies, or perhaps not even say the ordinary, the full panoply of remedies which are at the disposal of this court as the ultimate arbiter of these matters in instances of abuse of power, because that is what we would really be talking about, would be available. I may just make one last point in response to your line of questioning, Justice Colopin. This case, of course, this aspect of the case is not subject to the delay objection that we have raised. And so this court is going to have to engage with these difficult matters. And of course, the court can, in its judgment, if it accepts these submissions that I've made, can say authoritatively what the decisional referents are under section for a Rule 129I3 decision, and can also warn against abuses of power and the fact that abuses of the power will fall foul of the requirements of rational, non-arbitrary and good faith decision making which our Constitution imposes in all instances where public power is exercised. So to the extent that you and others on the bench may be concerned about the lack of enumeration of the relevant factors in the discretion conferring provision itself, that may be dealt with in the judgment.
Thank you, Mr. Breitbach. And finally, if we go in that direction, you don't make any submissions on the merits, not so?
I do not.
Thank you.
Mr. Breitenbach, and I think some of this follows from the questions from Brother Justice Colopin. The rules that we're dealing with, does it permit the National Assembly to exercise an unfettered discretion to vote down a panel report for any reason that the Assembly feels strong enough or compelling enough?
In short, no. Now, for all of the reasons that I've given, no. It has to consider the sufficiency of evidence.
And isn't that the nub of the question before this court?
Yes.
And that's the applicant's argument that in this instance, there should have been a further step. And if the rules don't provide for that, is there not a difficulty with the rules? And do the rules then comply with what this court said in EFF 2?
If the court accepts my submission that what the Assembly has to consider is whether there is or whether there is not sufficient evidence to put the President on trial, guided by but not bound by the panel's report, then with respect there isn't a problem, because that's what the rules properly interpreted require. I know that the architecture of the debate between the applicants on the one hand and the President and the ANC on the other hand is such that they cross swords on that question. I know also that criticism has been directed in this court to the panel's report. It asked and answered the wrong question. We've heard a discussion about that today as one of the points of criticism. But coming back to what Justice Coleman asked me, even assuming an impeccable report, something where no such criticisms could be levelled, there aren't difficulties with the nomenclature perhaps indicative of errors of law made by those compiling it. Ultimately, in this important matter, as this court has held, it is for the Assembly to craft for itself a process which includes this initial sifting mechanism. There are actually two of them, as we know.
But if the process that's been crafted by the Assembly does not meet the objective and does not meet the standard and the criteria that this court set out in EFF 2, is there not a problem?
Yes, I undoubtedly and unreservedly accept that. But the if is not satisfied in this case. These rules are fit for purpose. The President will only be put on trial if the Assembly decides that there is sufficient evidence to warrant that.
Isn't it problematic that the rules give the Assembly an unfettered discretion in that regard and to determine that question? And shouldn't the rules be tempered or the discretion be tempered?
That's such a difficult question, because ultimately the reason for the difficulty is this, is that the rules are made by the Assembly. So the Assembly, what the suggestion is that the Assembly should specify in advance, enumerate, somehow elaborate in a way that will assist decision making on a case-by-case basis. And that's beyond the definitions of serious misconduct, etc., that are already there. So it must specify that in advance. And the difficulty that I'm pointing to, Justice Turon, is that, and I suppose this is what the court's going to have to grapple with, having left it at the sufficient evidence criterion, and then allowing the Assembly on a case-by-case basis to relate the sufficient evidence to the grounds as defined in the opening part of this new section of the rules, serious misconduct, serious violation of the Constitution of the law. Whether the Assembly in advance has gone far enough of saying to the Assembly how in the future it should deal with the screening function. And it's really a question of when the Assembly speaks, and I suppose it boils down to this. Does EFF2 require that the Assembly must say more, elaborate on the sufficient evidence inquiry criterion in advance? I would submit it doesn't, and one of the reasons why is that it's not very different from the standard which prosecutors have to interpret and apply in deciding whether or not to prosecute. And it's never been suggested that we need that.
I don't mean to cut you short, but I am very aware of time. If this court finds that the discretion that the National Assembly has given to itself in terms of the rules is too wide or it's unfettered, what would your suggestion be on how to temper that discretion?
I must honestly say, I suppose one would have to, I would say that one would have to, in order to respect the separation of powers, and also to the fact that I'm not the National Assembly, although I represent them in this case, what I would say is that the court would have to identify the respect in which...
I'm asking for the views of the party that you represent.
No, I understand that.
To assist this court.
I understand that. I respectfully submit that the proper approach would be for the court to identify the problems and then to leave it to the Assembly to consider and craft a remedial rule which would address those problems. I do, and I say this with the utmost respect, believe that, that in cases of this kind where the apex court is in a dialogue with the Assembly, not here in this court but in your judgment, that one has to be mindful of the separation of powers constraints, and for that reason, with respect to my learned friends, the sort of substitution type relief is really a non-starter in a case of this kind.
I made a note of one of your earlier responses to my questions, and I can't read my own writing now. It says, I think you said we must be guarded. We were talking about the report. On the one hand, we must be guarded by the report, and on the other, Parliament is not bound to accept the report. I think you said something along those lines. So what is the status of the report then? What is the value of the report?
It is advice by an expert body, people who, if one looks at 129E1, the requirements for the composition of the panel, 3 fit and proper, competent, experienced and respected South Africans, which may include a judge, and who collectively possess the necessary legal competence and experience. So one has a report by a committee of legal experts, which must consider the information which is submitted together with the motion, which may afford any member to place other relevant written material before it, which must provide the President with everything and get the President's response, and must then weigh it and make findings as to whether there is sufficient evidence, and make a recommendation and give reasons therefore. And so it is a quite detailed set of terms.
I'm sorry to interrupt you once again, but surely it has to be more than advice, because the Speaker could well have gone to legal counsel, could well have gone to attorneys, and officials employed in the department, the National Assembly can do the same for advice. It should
It is,
be a little bit more than an advisory opinion.
in the,
Don't you think?
in the answer that I'll give to that is, it's undoubtedly clear from the rules read as a whole that it is an advisory body. Otherwise, one could not explain Rule 129P2. The surely in your question goes to something else, and that is whether it should be more than advice. But of course, I've made my submissions on that. If the panel's findings and recommendation are binding on the Assembly, then you will be taking, if that is the finding of this court, you'll be taking out of the hands of the Assembly the assessment of whether there is sufficient evidence for the President to go on trial, and we submit that is inconsistent with Section 55(2) of the Constitution. We submit it is any such order with respect would entail an infringement of the principle of separation of powers.
Now, you accepted earlier in our discussion, Mr. Breitenbach, that the National Assembly's discretion should not be unfettered.
Sorry, would you mind repeating?
The National Assembly's discretion should not be unfettered. You accepted that.
It is not unfettered as a matter of interpretation.
And if this court were to say so, that would not be a breach of the separation of powers doctrine.
It would not, because the court would be interpreting a document and applying the ordinary rules of interpretation as developed in Cool Ideas and Hubbard and the cases following it, saying this is what it means. You, the Assembly, have written this document, and it means that you have to consider the sufficiency of evidence.
Yes, my last question relates to sufficiency of evidence, and I apologize if this has been asked of you or of your colleagues before. What is the appropriate standard that the panel should have used? Sufficiency of evidence, prima facie case, or is it either one of those two? Is there a distinction between the two? If there is, what is the distinction?
So it's best to, although this falls more properly in the province of my colleagues, Mr. Budlander and Mr. Nkuko Toby, I would obviously draw the court's attention to the precise wording of the relevant rules, which is 129(1)A and 129, so that's 129A, 1A, and 129G1B. 129(1)A refers to a clearly formulated and substantiated charge on grounds specified in Section 89, which must prima facie show. And my understanding of that and my submission is that one reads the charge and you ask yourself if all of the factual allegations on which it is based are correct. Does this show serious misconduct, serious violation of the law, etc.? And one can liken it to the scrutiny that we do every day as lawyers, where you look at a set of statement of claim or particulars of claim or a plea, and you read it and you ask yourself, do the facts alleged by the pleader prima facie, in other words, established on its face, but if established by the evidence supporting it, lead to the legal conclusion and the relief sought. It's an exception type assessment. So that's what's required of the speaker. Very different as a line of questioning this morning from the court to my learned friend, Mr. Premed. The wording here is a and this is now 129G1B, a recommendation to the speaker whether sufficient evidence exists. Now one looks at the underlying information, the information attached to the motion, any information which the panel in its discretion has sought from members, the President's reasons, and you ask yourself two questions. Does this point to the existence of evidence? Not information, but evidence. In other words, oral testimony or documentary evidence which can be adduced as proof. And the second issue, which is one on which evaluate, and it's an evaluative question, not an admissibility issue, is the sufficiency of that evidence. And it is, and my reticence, perhaps you would say egg dancing, around elaborating on that, is that it is something which requires a case-by-case and fact-specific assessment in any case. My learned colleagues will address whether Mr. Lamola and others got that wrong in their assessment of this particular matter.
Thank you, Mr. Breitenbach. Thank you, Chief Justice.
Mr. Breitenbach, just two quick questions. Just apropos what you've just said to Justice Theron, surely this panel is just a little more than an advisory body. It is surely, as the rules itself say, it's an initial inquiry, but it's non-binding on Parliament, on the Assembly.
Certainly accept that to the extent that its inquiry entails information gathering in its discretion from members, it does determine the record, and it goes beyond that. In other words, the mechanism is, it's not a committee of Parliament or the NA itself which must undertake the screening function. It's left to senior people with the necessary legal competence and experience to do that. I accept that. But when it comes to its findings and the reasons for its findings and its recommendation, the rule is clear. It must substantiate what it says and recommends. But it is up to the Assembly to decide whether or not to do what is recommended. Let's assume for counterfactual that the recommendation was not to proceed to an impeachment inquiry, whether or not to follow that. And it's in that sense that I refer to it as an advisory body. It doesn't have decision-making power, and specifically the power to take the decision in question here, namely, there shall or shall not be an impeachment Section 89 inquiry.
And then just lastly, just a quick question. As I understand it, you don't quibble with exclusive jurisdiction on this matter. Thank you. Thank you, CJ.
Mr. Breitenbach, I have one niggling issue. I hope you'll help me. Is it correct to say, for as long as you have the majority in Parliament or in National Assembly, it doesn't matter whether the report is prima facie or the report mentioned prima facie or sufficient evidence? Put it differently, if the report that we have now had stated that it's based on sufficient evidence, it could still have been defeated on the basis of the majority vote. If that is the case, then there is a problem with the rule. Am I right to make that assumption?
With respect, I do not think you are correct for this reason.
Where am I wrong?
This court has said in EFF 1 and elsewhere that when voting on matters like these, it is what prevails is the responsibilities that members have as members of Parliament to the constitutional project. And specifically in this instance, they must show fidelity to the rules which they themselves have crafted, following the judgment in EFF 2, which require a decision on our submission as to whether there is sufficient evidence or not. It does not follow from that in our system of constitutional democracy, where one votes for political parties who determine who represents them in the National Assembly, that parties may not caucus and that they may not have this debate, let's call it the sufficiency of evidence debate, behind closed doors before they have debate in open Parliament. It is a matter which they are entitled as political parties, particularly the majority political party, but equally it goes for parties which are in the minority, to assess this question and to see whether there is agreement among them. Where it becomes difficult is if the whip is applied to members, and the sense that members are told that they must go with the decision of the majority of the caucus on pain of being expelled from the party. If that has the result that members who dissent on that question do not vote with the party simply because of the whip, in other words, they do what this court has said they mustn't do, which is show fidelity to the party and not to the Constitution when dealing with important matters such as these, then that would be a problem. The question in this case, which my colleagues for the President and particularly the ANC will be dealing with, because it is a challenge frontally or squarely raised, is whether the evidence in this case shows that to be the case.
My second question is, does the issue relating to the sufficiency of evidence falls within your brief, or should it be left to Mr. Badlander and Mr. Ngugetobi?
On the facts?
Yeah.
My client is not engaged with the merits. They've left it to the political party and to the President, the ANC and the President, to deal with. So I'm unprepared to deal with that, and if you don't mind, I'll pass that hot potato to my left and to my right.
Perhaps before you do that, maybe they can eavesdrop into my question. If the test, as we have come to know, and there's a debate around it, it's sufficiency of evidence. And we know that the panel does not conduct oral hearings. Let's try and step into the shoes or the boots of the panel as to how can they make a determination as to whether this evidence is prima facie and this evidence is sufficient.
So
it's looking at the papers, statements and whatever.
Yes.
Is it something that you are prepared to answer, or I can leave it for your colleagues?
All that I would say, and my colleagues can correct me if they think I'm wrong, is the following.
I don't want you to muddy the waters.
No, I won't. If the question which is put to you, does sufficient evidence exist to show that the President has committed serious violation of the Constitution X? The first thing you ask yourself as you look at all of this information, you ask yourself, does it point to the existence of evidence? Is there a statement from Mr. Jones, for instance, a signed statement from a particular person who was an eyewitness, or can give relevant evidence to this impeachment committee in due course? Is there a document, the contents of which, if it's authentic, tend to show that, and which, if it's admitted, provide evidence? So that is why you have people who have to be experienced lawyers to look at this, because it is an assessment. It's a much more difficult assessment that needs to be done at a screening level, but not that different from what prosecutors have to do before they decide whether or not to prosecute. Is you look at the information that you have, you ask yourself, firstly, as I've said, does it point to the existence of evidence that can be adduced? And secondly, then the harder part oftentimes is the evaluation of the sufficiency of that evidence. Is it sufficient to run a case, to prove a case, which will show that?
Thank you, CJ.
Mr. Breitenbach, just one question. Seeing the purpose of these rules, that is to hold the executive, whoever that may be, accountable, how will it encroach on the separation of powers if this court gives some guidance to factors that the National Assembly should take into consideration when considering the process?
Let me make it plain that the separation of powers concern which I have raised derives from a series of judgments by this court, particularly the EFF 1 and EFF 2, in which the court has pointed out the problems with an existing, in the first case it was with what happened in relation to the Public Protector's report, or what didn't happen more specifically, and in the second one it was with the existing rules, the gap in the existing rule. I do not submit that a judgment by this court in which it elaborates on what's relevant and what would not be relevant when exercising the power under 129 I3 would necessarily entail an infringement of the separation of powers. Where one runs into difficulty is when this court starts prescribing the details of the mechanism. And the thrust of the submissions that I've made today is that the rules say enough. I do take the point which Justice Colopin has made, that the rule on its face doesn't indicate, and one has to look at contextual factors and its purpose in order to arrive at the point that I've done in my submissions. But if your question is, if the court were to say that, and to say, well, that's relevant and that's what must be considered, and what you cannot do is take into account factors which do not go to the sufficiency of evidence, would that be an infringement of separation of powers? I don't believe that would be.
Well, one can go even further. This court can give guidance and then refer it back to the National Assembly to take those principles into consideration. I think then we've got a clear, then this court would have executed its duty and also respected the separation of powers.
Possible, but unfortunately, when this court speaks, its guidance, and understandably, is taken and must be taken as the law of the Medes and Persians, and it must be implemented because of the comity between the branches of government. And all that I would say in response to your question is that when one starts giving guidance as to matters of detail, one must bear in mind the Section 55(2) of the Constitution.
Thank you, Mr. Brayton.
Thank you very much, Mr. Bredenbach. Mr. Padlender.
Justice, would you give us a minute to just move sideways so that my colleague...
May it please the Court, I'm going to deal with 6 matters, which are the following. Firstly, the question of delay. Secondly, exclusive jurisdiction. Thirdly, the fundamental error of the panel. Fourthly, sufficient evidence, or rather evidence. Fifthly, bad faith. And sixthly, the reasons given by Minister Lamola. If I have time, I want to briefly respond to what I submit is an underlying flaw in the approach of our learned friend Mr. Katz. So to start with delay, in an attempt to avoid the obvious problem of delay, the EFF says this is not a review, it's an application for a declaration. As Justice Majid pointed out, that doesn't actually get them off the hook. But in any event, it's wrong. It is a review, and it's a review for three reasons. Firstly, a declaration is one of the forms of review, forms of remedy in judicial review. It's well accepted, it has been forever. A declaration is a remedy for a judicial review. That's, if you look at Baxter's book on administrative law, you see, look at the remedies that he lists, you'll find declarations there. Look at DeSmith's book on judicial review, you'll find declarations there. Look at Wade and Forsyth's book on administrative law, and you'll find they too, when they discuss remedies on a review, explain why a declaration is often a particularly effective remedy. It's at page 484 of the 11th edition. So the fact that a declaration is sought doesn't make it the challenge, not a review. Secondly, the relief sought makes it clear that what is sought is the setting aside of the decision of the National Assembly. If one goes to the notice of motion, which is at paragraph 5 of the notice of motion, at page 2 of the papers, one sees they ask for an order substituting the National Assembly's decision, alternatively referring the matter back to the National Assembly. In other words, they want it reviewed and set aside. Thirdly, Mr. Malema himself says in terms that the EFF seeks an order reviewing and setting aside the decision of the National Assembly. At page 51, paragraph 181, he says, for this reason, the EFF seeks an order from this court declaring that decision unlawful and setting the resolution aside. So it's a review. And we all know the consequence of that. It may not be unreasonably delayed. And we make the submission that the EFF has disabled the court from deciding the application because there has been a patently unreasonable delay. There has been no attempt to explain the delay, and there has been no attempt to produce facts which show why the delay should be overlooked. Then on exclusive jurisdiction, the core complaint of the EFF is that the decision of the Assembly was irrational. Rationality is an obligation which rests on all who exercise public power. It's not an obligation which is specific to the National Assembly. The analogy is this: if the President takes administrative action and he breaches Paja, that doesn't bring the matter within the exclusive jurisdiction of the court, because the obligation to take lawful administrative action rests on all administrators. It's not an obligation that is specific to the President. Similarly, a challenge based on alleged irrationality doesn't trigger the exclusive jurisdiction of this court. The EFF does attempt to show that the application rests on a failure of the NA to hold the executive accountable, and that is a specific obligation of the National Assembly. But we say that the National Assembly has held the President to account. Firstly, the Speaker considered the motion, found it compliant with the rule, and referred it to an independent panel. The Assembly, through the Speaker, established an independent panel to investigate the matter. The panel conducted an investigation. The President was required to explain and justify his conduct in what became a public forum, effectively. The panel recommended that a Section 89(1) impeachment inquiry be proceeded with, and the National Assembly considered the recommendation and didn't accept it. So the procedures to give effect to Section 89 of the Constitution were operationalized, and the President was called to account. The EFF's complaint, real complaint, is that it doesn't like the result or the outcome of the process. It doesn't say the process wasn't followed. It says we don't like the outcome of the project, of the process, because the majority of the NA, by means of a vote, made a decision which it did not like. We say make the submission that that's not a failure to hold the President to account. We refer to what Chief Justice Zondo said in EFF 2 at paragraph 93, where he said, whether the National Assembly has held the President to account through a motion of no confidence in him or not cannot depend upon the result of the vote. You've held him accountable or you haven't held him accountable. The process was followed. The NA did hold the President to account in accordance with the rules. As to the exclusive jurisdiction of the court, we submit that the complaint of irrationality doesn't trigger the exclusive jurisdiction, and if the complaint of a failure to hold the President to account could trigger the exclusive jurisdiction, as a matter of fact and as a matter of law, the National Assembly did hold the President to account in accordance with the rules and the process designed for that purpose. That brings me then to the fundamental error committed by the panel. We submit that the rules create a multi-phase decision-making process. At each phase, there's a distinct question to be decided by a different decision-maker. Phase 1, the Speaker. The question the Speaker must answer is the motion compliant with the criteria set out in Rule 129A? Does it prima facie show that the President committed the impeachable conduct? That requires some consideration of credibility. It's not just enough to say, is it acceptable? Because, for example, if the complaint says the President, if a political opponent of the President died recently, and a complaint is laid that the President murdered his opponent, that would be an impeachable offense. But you've got to go further and produce some evidence to show prima facie there's something behind it. There must be something that will pass muster. That's the first phase. Second phase, the panel must conduct an inquiry. It invites further information from members, gives the President Audi, and it must answer its question. It must recommend whether sufficient evidence exists to show that the President committed the conduct. Then the third decision maker is the NA. It must decide whether to approve the recommendation and send the matter to the impeachment committee. The matters the NA must consider are not specified in the rule, and its questions will be whether it is persuaded by the panel's recommendation, and if so, whether it should consider that the impeachment process should be initiated. It's a large and far-reaching decision. It involves more than rubber stamping what the panel has recommended, even if the panel's report is flawless. The fourth decision maker is the impeachment committee. It must conduct an inquiry to establish the veracity of the complaint, and if veracity is established, the seriousness of the charges. So there we are now into veracity and seriousness, and must make a recommendation to the NA. And the final decision maker, of course, is the NA. Its question is, should the President be impeached? And so each time there's a different decision maker with a different decision. And the mistake that the panel made was to consider that it had to answer the same question as the Speaker. The panel did this despite the fact that the question the rules require it to answer is different from the question that the Speaker has to answer. The Speaker must answer whether the motion and the evidence, not just the motion and the evidence, prima facie show that the President committed the impeachable conduct, and the panel must consider whether there's sufficient evidence that the President committed the conduct. And the obvious questions are these, two questions. Firstly, why would the rules require two different actors to answer exactly the same question? What would the purpose be of that? Secondly, if Parliament did intend to require that these two bodies should answer the same question, then why did it use different language for each of them? It's a basic rule of interpretation that the use of different words demonstrates a different intention. It's got nothing to do with the situation referred to by Mr. Katz, where you have different countries having different standards for criteria for extradition, and a court has to decide whether they're equivalent. This is the use of different words in the same statutory instrument, the rules. And it's trite that a court will hold that this difference signifies a different intention. And so we submit that the panel ignored the careful step-by-step process and ignored the fact that the rules require different actors to answer different questions. The sufficient evidence test, the prima facie test, is a screening or filtering mechanism, prima facie impeachable conduct. In contrast, sufficient evidence is materially weightier because now you've got more evidence in front of you and because it's the trigger for a possible impeachment inquiry. And we say with due respect to the panel that it asked itself the wrong question, and you don't get the right answer if you ask the wrong question. Certainly, we submit the Assembly was fully entitled to take the view that for this reason, amongst others, it would not approve the recommendation of the panel. There was nothing irrational or impermissible about that decision. The NA was performing its function as the third decision maker in a multi-stage process. And that brings me to a core submission which I need to emphasize. Ultimately, the question before this court is with respect not whether the panel's recommendation was right or wrong. This is not a review of the panel's decision. The question is whether it was lawful for the Assembly, after a debate and a vote, to decide not to approve the panel's recommendation and not to send the matter to the impeachment committee. Incidentally, in the end, the Assembly didn't strike down the report of the panel, it declined to follow the panel's recommendations. And the EFF has failed to show what was unlawful about this decision of the committee, of the Assembly. Then the question of evidence. The panel was required to consider whether sufficient evidence exists. Sufficient enough evidence, actual evidence exists, is in existence, not might be found if you conduct a further inquiry. The panel went beyond the evidence. It received and considered and reached conclusions based on, amongst other things, suggestions made, for example, by Mr. Fraser, allegations made by Mr. Fraser where he produced no evidence to support them, speculation and suspicions as to what the position might or might not be, statements by Mr. Fraser as to where there might be other evidence, and hearsay evidence which the panel considered without applying the well-known tests for when the rule against hearsay evidence may be deviated from. The panel relied on all of this material in reaching its conclusions. Again, the question before this court we submit is not whether the conclusions which the panel reached could be justified. The question is a fundamentally different one. It is, was the Assembly entitled to decide not to approve the panel's recommendation for this and for other reasons? The NA exercised its power as the third decision maker to decide not to refer the matter to an impeachment committee. We submit it was entitled to make that decision, and there was nothing unlawful about the decision. Then fourthly, bad faith. The prohibited conduct requires dolus. It is deliberate conduct by the President himself in bad faith. Again, in this context, we submit it's important to get the question right. The question is not whether the President acted correctly in all respects. It is whether, if he got it wrong in some respects, this is shown to have been deliberate and in bad faith. And that is most simply demonstrated by the debate in the report about the correct interpretation of paid work. The panel analyzed the question and it came to a conclusion about what the correct interpretation is. But even if one assumes for the sake of argument that its interpretation is the correct one, that doesn't answer the question whether the President deliberately and in bad faith adopted a wrong interpretation of the term paid work. The President's farming activities have never been a secret. He's published a book of photographs of the particular breed of cattle in which he has a particular interest. It seems very unlikely that he deliberately and in bad faith ignored the law and then publicized his activities. Perhaps more likely is that he genuinely thought that he was entitled to act as he did, and he lacked dolus and bad faith. Again, the question is not whether the President's interpretation was right or wrong, it is whether his interpretation was in bad faith. And again, the critical question is whether the Assembly was entitled after debate to decide for this reason, amongst others, that the matter should not be sent to the impeachment committee. That brings me finally to the reasons Minister Lamola gave for opposing approval of the panel's recommendation. And the EFF asserts over and over again that in assessing the rationality of the NA decision, one can have reference only to what Minister Lamola said in his speech. The first thing I note is that the EFF has caricatured what Minister Lamola said. What he actually said is summarized in the ANC's answering affidavit, supplementary volume 3, pages 862 to 868, paragraphs 68 to 70. Volume 3, pages 862 to 868, paragraphs 68 to 70. But the EFF, with respect, gets the point wrong. The test for rationality is objective, not subjective. It's not whether an individual, Minister Lamola, subjectively asserts a rational connection. It's whether objectively there was a rational connection between what was done and the power. And in the Motau case, Justice Kampepe said this on behalf of this court at paragraph 69. She said, "The principle of rationality requires that every exercise of public power, including every executive act, be rational. For the exercise of public power to meet the standard, it must be rationally related to the purpose for which the power was given. It is also well established that the test for rationality is objective and distinct from reasonableness." Close quote. So the question is whether there is an objectively rational basis for the decision, not what the subjective view was of a particular decision maker, 1 out of 400, Minister Lamola. In any event, in this case, 214 members of Parliament voted against accepting the recommendation of the panel. One could never apply a subjective test to 214 people, find out what the subjective intention and reason was of each one of those. Each of them would have had their own subjective reasons and their own subjective views about the reasons for the decision. The speech of Minister Lamola was not an affidavit subscribed to by 214 members of Parliament, each of them saying, "These are my reasons and these are my only reasons." And so the attempt by the EFF to straitjacket the defense to this application into one part of what Minister Lamola said is simply wrong in law and wrong in logic. I need to make a key underlying proposition to all of this, which I wouldn't like to be lost, and that is when the National Assembly makes its decision, it has a residual discretion. This is addressed in our heads of argument in paragraphs 61 to 62. The sorts of matters that the NA may consider in the exercise of its discretion are set out in paragraph 61. So then I do have time, to my surprise, to respond to what Mr. Katz said. I'm not going to respond to it in detail, to the new, what is actually a new case, which is attempted to make out in oral argument, and which it seems he's still trying to work out. I will make only one observation. His submissions with regard to the assemblies, his submissions deal with the National Assembly's carrying out of its functions, deal with them as if they were administrative action. For example, if political considerations enter their decision making, the decision is invalid. Or for another example, if there are a number of possible reasons for the National Assembly's decision, one bad reason will invalidate the decision. Those are administrative law doctrines. This was not an administrative decision. This is not administrative action. It's also not executive or legislative action. This is the exercise of a sui generis constitutional power. It's a power conferred by the Constitution, which is neither administrative nor executive nor legislative. And you can't just import administrative law doctrines into this decision and say, because you have breached a rule in Paja, you fail to have regard to relevant considerations. You've made a bad decision. You've had a bad decision mixed up, bad reason mixed up with the good ones. Political considerations have affected you. We say this is administrative action, and it it's not administrative action. It is a sui generis power, constitutional power. And then I need to deal briefly with this bogey that is raised of politicians making the decisions. The National Assembly consists of politicians, only politicians. The Constitution says that the politicians, these politicians, must decide on impeachment. The Constitution makers knew, as we all know, that they were conferring this power on politicians, not on judges or courts. They knew, as we all know, that when politicians make decisions, inevitably political considerations do weigh on those decisions. They are normal human beings. Political considerations weigh on decisions like impeachment, certainly, just like they weigh on a number of other things that they have to do. And they know that inevitably, we see it all over the world, impeachment has a political dimension. And that is why it is appropriate for the National Assembly and not the courts to decide whether the president should be impeached. And that is why the constitution makers made that choice. They conferred the power on the National Assembly, a body composed of politicians. Now, there's a fine line to be drawn here. On the one hand, we know, and this court has told us, that if the politicians simply act on the dictates of their party leaders without applying their minds to their constitutional obligations, then they're not acting lawfully. We know if it can be shown that all that is happening is they're saying, what does the party say? Well, that's what I have to do, full stop. We know that that would be impermissible. But we also know at the other end of the spectrum that it is impossible when you're deciding on impeachment and when politicians are deciding on impeachment for political considerations not to carry some weight. And the power is conferred by the Constitution on the politicians. Now, where that dividing line comes is a very difficult one to find. And it does come, one's assisted with it. Justice told me if there's some criteria, I accept that. But the criteria are terribly difficult to define because you're at high risk, and the court is with respect at high risk of being overly prescriptive and then prescribing, doing things which are really the job of the Assembly under the Constitution, but on the other hand being so vague that no one knows what's intended and how to do it. And it's with respect, a very difficult question as to how one would draw that line. But we do say this, that if criteria are to be determined, they have to be broad, and we say that it would be wrong to prescribe that political considerations are irrelevant. It would be unrealistic, and it would be wrong, and it would be inconsistent with what the Constitution does, which is give the power to politicians. If the Constitution makers had wanted this to be a decision made on cold legal facts and cold legal decision making, it would have given the decision to the judges. But it didn't do that because impeachment is not just a legal process, it is also a political process, and there's no getting away from it, and we have to be realistic about that. And so the question was asked of our learned friend, Mr. Breitenbach. Well, let me put it this way. So what does the Assembly have to do when it considers the report of the panel? We say the question will be whether it's persuaded by the panel's recommendation, if so, whether it considers that impeachment process should be initiated. It's more than rubber stamping what the panel has recommended, even if the panel's recommendations and report are brilliant and unimpeachable and impeccable. Because if it was rubber stamping, then there would be no point in requiring a decision by the National Assembly. You could just give that power to the panel. but that would be inconsistent with what the Constitution requires. The Constitution requires the Assembly to decide whether there is impeachable conduct, or whether there should be an inquiry into impeachable conduct. And so, for example, let me give a simple example of this. Let's assume that the panel finds that the President's committed conduct which is impeachable. The Assembly may take the view that even though sufficient evidence has been found of that conduct, the conduct is not so serious that it should result in impeachment. And that's not a legal question, that's a political question. The conduct, a finding is made by the panel that the President has behaved improperly in some fashion. That's a matter on which lawyers, using well-known techniques, can decide and decide well. The question whether that misconduct, if proved, should result in impeachment is not a matter on which three very learned lawyers sitting in a panel have either the knowledge or the skills or the training to decide. It's a political question. And that's why the power to make the decision about impeachment is given to the politicians. And we say that, so even at the first stage, even when the National Assembly reviews the panel report, one of the things it may say is we see the President has behaved very badly, and we see that it's been shown. But for this, impeachment is such a serious consequence for the nation as a whole that this is not the sort of conduct that justifies impeachment. That's a judgment you have to make, and we say, I make the submission that there is no basis for saying that that's something which is solely in the hands of the panel. It is a decision which is not purely a legal question, it is a policy or political decision. And that's why the power is given to the Assembly to decide impeachment, and that's why, as this court has held, it's the Assembly that must decide whether the matter should proceed to an impeachment committee. Because that, having an impeachment committee putting the President on trial is a far-reaching action with unpredictable consequences. And the politicians must take responsibility for those consequences. They must make a decision and they must take responsibility. And so for all those reasons, we respectfully submit that the application, the challenge to the decision of the National Assembly must fail. It is too late. It doesn't trigger the exclusive jurisdiction of the court. It's based on a fundamental error committed by the panel. It would be. It's based on evidence which is not evidence. It's based on allegations, bad faith, etc. And we submit that the application, insofar as it deals with the decision of the National Assembly, should be dismissed. Can I just say one more thing about delay? The question strikes one obviously. The decision was made in December of the National Assembly, was in December 2022. The review application was brought in February 2024. What happened? What happened, we know, is that an election was about to happen. And this was part of the EFF strategy. It's a legitimate strategy, and to advance its political cause. That's why there's such a delay, and that's why the application was brought when it was. It was brought not because of the December decision, it was brought because an election was about to happen, and this was an opportunity to make hay. Chief Justice, those are my submissions.
Thank you, Mr. Butler.
Mr. Butler, let us assume that the panel refers to prima facie or prima facie evidence, but in its definition of that concept, it defines it exactly as you would define sufficient evidence. As a matter of principle, would you have any problems with that?
No, we would have problems, Justice Madlanga, because in the context of this rule, prima facie and sufficient evidence plainly have a different meaning. And so the moment you say they're the same, you're setting off on the wrong footing. And so if you want to read the rule in its context, those phrases, those terms in their context, we say it's clear that they have a different meaning. And so it can't be done to say, well, I think they're the same. If you say, I think they're the same, and I deal with them as if they're the same, then you make an error.
I'm not just saying the panel would merely be saying they are the same. I'm going further and saying, in their definition of prima facie evidence, they go on to define it exactly the same way as you would define sufficient evidence. If you still have a problem with that, would that not be engaging in form over substance?
If the test they applied was sufficient evidence, properly understood, properly interpreted in the context of this rule, then there could be, I wouldn't have that complaint. But I would have a complaint, the complaint I have is that they say these two are the same. And the test applied by the speaker and the test applied by the panel are the same, and we say that can't be so.
Let us look at paragraph 75 at page 90 of volume 1, where the panel says this. In the
page
90. 90, as they would say at the bar, which I never understood.
I think that's what you do when you're throwing darts. Yes. Page 90.
Yes. There, the following appears: in the context of the scheme for the removal of the president from office, we therefore construe the phrase "whether sufficient evidence exists" to mean whether, based on the information received, the president has a case to answer. What problem do you have with that part of the formulation?
The problem is the next sentence. Put differently, we construe the phrase to require the panel to determine whether there's a prima facie case against the president. That's not correct. That's not what the phrase requires the panel to do. It requires a weightier decision, because we've had a prima facie case. Now the other members of parliament have been invited to put in evidence. The president has been invited to respond. There's a high-level panel required. It's given a month to try and do the job. It's a higher range activity than what the speaker is doing.
I'm sure you would agree, though, that what the panel says should be read cumulatively. Not so. Everything that it says in this context should be read cumulatively. Of course, it's something else altogether, whether you will then agree that even if read cumulatively, their reading of the rule is correct. But you agree that it should be read cumulatively nonetheless.
I'm not sure, Justice Madlanga,
let me just continue. Let me leave out the theoretical question, as it were. Let's go to 76, same page. We think the purpose in interposing the panel in the scheme of the impeachment process and entrusting it with the power to conduct a preliminary inquiry into the motion was intended to ensure that the president is not required to undergo a full-scale Section 89 impeachment inquiry in circumstances where the president has no case to answer. That step must never be taken lightly. It is a momentous act justified, and I emphasize what follows, only when sufficient evidence, your preferred phrasing, of course it's in the rule, not just yours.
Yes.
Only when sufficient evidence exists to show that the president has a case to answer for his conduct, and I stop my emphasis. The panel, therefore, functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. Why does a cumulative reading of all that the panel says, why does this not satisfy what the rule provides for?
Well, the test in the rule is whether sufficient evidence exists to show that the president committed impeachable conduct. That's the test. Not that he has a case to answer. Sufficient evidence exists to show that the president committed a serious violation of the Constitution or law, etc., etc.
But the case to answer relates exactly to what you referred to. Well, that is the itemized bases for impeachment, serious misconduct, and the other two. That's the case to meet, is it not?
Well, Justice Madlanga, the difficulty is that, with due respect to the panel, it mixes the two concepts up, which are quite distinct. Read the last sentence of paragraph 76. The conduct functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. 75, the panel to determine whether there's a prima facie case. We say that a prima facie case is something less than sufficient evidence to prove. Something less than that.
Let me move on to something else altogether. The question of the actual nature of the evidence.
Yes.
That is where your client complains, amongst others, about hearsay evidence and other forms of evidence that would, as I understand the argument, ordinarily not be acceptable in a court of law. As a matter of principle, must evidence that is admissible in a panel of this nature be the sort of evidence that is admissible in court and nothing less?
No, I wouldn't go that far. For example, if there was a signed statement, not on oath, the panel could surely have regard to it. If there was a document which on the face of it appeared to be genuine, the panel could surely have regard to it, even though there wasn't yet a chain of possession shown. So I don't submit that the panel is sitting as a court. It's not submitting as a court, and it's not applying the court's criteria, but it is having regard to evidence, and the evidence is broader than in an affidavit or sworn testimony, but it is narrower than suggestions were made by Mr. Fraser that what really happened was the following. With due respect to the panel, they had no business considering suggestions by Mr. Fraser as to what happened when Mr. Fraser had no knowledge and didn't claim any knowledge of what had happened. No, the panel had regard to allegations made by Mr. Fraser when he produced no evidence to support them and didn't say there was a witness who would support them and this is who the person was. The panel, with due respect, had no business having regard to those sorts of things. It went beyond, and it went beyond the extended notion of evidence, which I say was permissible, Justice Madlanga.
Would you say the type of evidence admissible in, for example, commissions of inquiry would be the sort of evidence admissible before the panel, or
Justice
not?
Madlanga, I don't like thinking about commissions of inquiry. Once bitten, twice shy. But yes, that sort of thing.
Would be admissible.
I would think so. I mean, I wouldn't like to tie myself to that precise definition because the courts have sometimes gone very far. The commissions of inquiry have regard to hearsay evidence very cheerfully.
Yes.
I don't.
That was exactly my next point.
I don't think a panel deciding whether there's evidence,
Yes.
sufficient evidence, can permissibly have regard to hearsay. I submit that comment.
I will make the point regardless. With regard to the nature of evidence in commissions of inquiry, this is what Jafta AJP, who later became our colleague here, said in the matter of Bongoza, B-O-N-G-O-Z-A.
I seem to remember counsel quoting that case.
I'm very sorry, I'm very sorry. In that matter, here's what Justice Jafta says, relying on a submission by counsel, and this is paragraph 17 of the judgment. It says it was entitled to adopt its own procedure, that is a commission, including the receipt of evidence or information relevant to the issues before it. In fact, he contended further that the commission was responsible for collecting evidence and obtaining statements from witnesses. It could consider information of any nature, including hearsay evidence, newspaper reports, or submissions made without sworn evidence. For these submissions, counsel relied on Bell versus Van Rensburg, S versus Mulder, S versus Sparks, and so on. Yes. And then in the paragraph that follows, Jafta AJP, having accepted the submissions, goes on to further strengthen the point himself.
Yes.
Why would that not apply to a panel of this nature?
I submit that the term sufficient evidence needs to be interpreted in the light of the context of the rule and what the rule is doing. The rule is about a possible impeachment trial of the president. And it's not like a commission philosophizing about its theory of the world. Some of them do that as well. It's a panel established effectively under the Constitution to consider the most serious matter, or a most serious matter. And I submit that the bar is set fairly high. It doesn't go so far as saying evidence admissible in a court. And a newspaper report, for example, something has been reported, you may be able to rely on it, I don't know. But whereas it seems from the authorities that a commission has pretty well carte blanche as far as hearsay is concerned, I submit that wouldn't apply to a panel of this
The
kind.
panel is somewhere in between.
Somewhere in between.
The court is up there, then panel, and then commission way below.
Precisely so, Justice Madlanga.
Thank you very much, Mr. Badlender.
Mr. Badlender, just on exclusive jurisdiction, you have submitted that we don't have that jurisdiction.
I beg your pardon?
You have submitted that we don't have exclusive jurisdiction. Yes. And it is because you are saying that what the EF case boils down to is that it doesn't like the decision that was taken by the National Assembly. And my question then is whether we should look, when we determine the jurisdiction, whether we have exclusive jurisdiction or not, we should look at the pleadings of the EFF. Yes. And if we look at the pleadings of the EFF, I'm referring you to 14.2, page 10 of the founding affidavit.
Yes.
14.2 says that, in essence, the National Assembly has failed to properly consider the content of the report. So they are not saying that they are not happy with the outcome. They are saying that the National Assembly failed to properly consider the content of the report. If you can comment on that and say why the fact that they've made that allegation does not clothe us with jurisdiction.
Justice Chiki, I read that phrase as being a sort of administrative law ground, failure to have regard to relevant considerations, failed to properly consider the content of the report by effectively setting aside the panel's conclusions without establishing a factual or legal basis upon which to do so. That reads to me like a review challenge, that you made a decision without a legal or factual basis to do so. But I do accept that if the complaint is that you failed to hold the President to account, that triggers the exclusive jurisdiction, because it is the specific obligation of the Assembly to hold the President to account. We say that they did in fact hold him to account, but that's another question. But I don't, with respect, read this as making an allegation which falls within the exclusive jurisdiction of the court. It's not the exclusive jurisdiction of the court to decide whether bodies failed to do something without establishing a factual or legal basis upon which to do so. That doesn't fall within the exclusive jurisdiction of the court. Every day, cases are brought in the High Court in which the applicant's complaint is that the respondent failed properly to consider a report, didn't have a factual or legal basis on which to do what it did. That doesn't trigger the exclusive jurisdiction of the court. And if the complaint is that a president failed to properly consider a matter and didn't establish a factual or legal basis, that wouldn't trigger the exclusive jurisdiction of the court. It's only when the matter relates to a function which is specifically allocated to that decision maker, the Assembly or the President. That's what the jurisdiction of the court says, as I understand it.
I'm asking this question because we know that report, which the EFF alleges was not considered by the National Assembly, dealt with the impeachment of the President. And this is why I then, struggle with finding that. And on your submission, this does not revolve around the issue of the President.
If it was formulated like this, then it might trigger the exclusive jurisdiction. If the complaint was that the National Assembly did not hold the President to account because it failed to properly consider the content of the report, then that might trigger the exclusive jurisdiction. This is more narrowly described. If the complaint must relate to a specific constitutional obligation of the Assembly, then this is not a specific constitutional obligation of the Assembly.
Perhaps then it's because I'm looking at it holistically, because I'm looking at the fact that the real complaint is that as a result of them not considering the report, they failed to hold the President into account.
Yes.
And this is why I then thought that then we have exclusive jurisdiction, yes, because the real complaint is that had you considered the report, you would have held the President.
Yes, I understand that, Justice Chiki. I understand with respect to the point that you're making. And if it is formulated that way, then it may trigger the exclusive jurisdiction. But as you say, we have to have regard to the pleadings as they stand, and the pleadings as they stand don't make that case. They make a different case, which is that the Assembly failed to hold the President to account. They make that elsewhere in their founding affidavit. That triggers your jurisdiction. But the fact that the allegation that the National Assembly didn't properly consider the matter before it doesn't trigger, I submit, the exclusive jurisdiction of this court.
Mr. Butler, we've heard wide and varied submissions, quite critical of the panel. both during oral argument this morning, and one can find much more evidence of that in your client's affidavit. And most of it, there's a basis for it. But it seems to me that looking into the future, it might always be quite easy to impugn a report of an independent panel for reasons not associated with the expertise of the panel, their diligence, or their industry, simply because of the convoluted manner in which the rules have been devised. So what the rule says is that the panel must conclude that there's sufficient evidence to show that the President has committed a serious misconduct, a serious violation of the law, etc. But then, having charged the panel with producing a report that contains sufficient evidence, it then restricts the panel considerably, because what the panel will receive only is information. Only information from members. It may not conduct an oral hearing, and it's limited to the written and recorded information placed before it. So it can't undertake what it's criticized for not doing, which is the proper evaluation of this information and to convert that information to evidence. Because ultimately, it cannot rely only on information. That information has to be elevated to evidence. And that would require some verification of that information. And so one almost senses the anguish of the panel. If you look at paragraph 94
Yes.
in volume 2, and that's at page 98. And while the panel is referring to Mr. Fraser's statements, I think they may well be a reflection of its general frustration. It says, while Mr. Fraser's statements provide information that may help to verify the truthfulness or otherwise of his allegations, the present process does not permit the panel to investigate these matters. So it has this information, but it may not investigate them. This, of course, does not mean that we must blindly accept the information contained in Mr. Fraser's statements in the hope that it may and probably will be verified. Nor does it mean these allegations must be ignored. So it sets up the two positions that it finds itself in. And then finally, it says, fairness dictates otherwise. But sadly, that otherwise is not to be found in the report. And so this may be a reflection of a structural difficulty.
Yes.
That panel, bring us evidence,
Yes.
but you're confined to information. And the panel tries to grapple with this at 94, but doesn't seem to provide an answer to it, except to suggest that the answer lies somewhere else.
Yes. So
would you agree that that's
I
a systemic
do agree
issue?
I do respectfully agree with that approach, Justice Colopin. It seems to me the panel is given a difficult job because it's required to make findings about sufficient evidence when it's not really given all the tools which are necessary to find sufficient evidence, and then it has a finding which can have far-reaching and cataclysmic consequences. And so it's the panel's job is a very difficult one. And when we criticize it, we do it recognizing that. But the criticisms really don't go to the question of whether the panel did the best it could under the circumstances. That's not the issue. Or even whether what the panel found was right or was wrong. The question is whether the Assembly, when it decided not to accept the recommendation and said, well, I see all these problems in this report, was entitled to do so. And we say it was entitled to do so. It was not for the Assembly to say, well, the panel's job was a very difficult one, so I will overlook the many criticisms you could make of its report. That's not what the Assembly was required to do. The Assembly is making a decision about whether the President will go on trial. And it has to say to itself, is there a basis for that, a sufficient basis for that? And it's not, and the question is not whether the panel was right in what it said, and not even whether the Assembly was right in the decision it made. It's whether it was the decision that the Assembly was entitled to make. It had to exercise a judgment, a discretion. Did the decision it made fall within the reasonable range of what an assembly could do? And we say yes, because there were these criticisms. Not a question of blame and pointing fingers. It's just there's a reality. The panel has to deal with the reality that the structure's awkward. The assembly has to deal with the reality that there are problems with the report as a consequence. And it's entitled to say, well, I'm afraid this is not enough.
I accept that, Mr. Butler, and perhaps even in the context of this case,
Yes.
that may well be an outcome that is almost unavoidable, perhaps.
Yes.
But does it not raise the problem that the Assembly is entitled to say that this report is flawed in these respects, but in truth and reality, the origin of those flaws are the rules that the very same Assembly.
Yes, that's true.
So, you know, it's almost like, well, you can't have both your cakes and eat them. But what is your suggestion in terms of addressing that? Because you'll never have an impeachment. I mean, I might be just generalizing.
Well,
but if these
you'll
are the
have an
inherent-
impeachment when there is clear evidence of the offences.
But if the panel is hamstrung in coming to the conclusion that there's such evidence, because...
Well, sometimes you will. Sometimes there will be such evidence.
Sure.
Sometimes the complainant will produce such evidence, and sometimes the other members of Parliament will produce such evidence. It's quite conceivable. But one has to deal with the reality of the situation as it stands. I understand and with respect accept the point that you're making, Justice Colopin. But at the end of the day, the question that is before the court is, was the Assembly entitled to say, in the light of the defects and problems in the report, whatever the cause may have been, should we refer this matter to follow the recommendation to refer this to the impeachment committee and trigger something very consequential?
And our curiosity should not extend beyond that.
Okay. That is so, Justice. Well, we can be curious, but we can't all answer all questions, Justice Colopin.
Thank you, Mr. Butler.
Just one follow-up question, if I may. Mr. Button, you said yes, there might be an impeachment if there's clear evidence. My question is, clear evidence determined by whom?
By the panel.
Sorry?
By the panel. Well, first by the panel and then by the impeachment committee. But if the panel has before it clear evidence of an impeachable offence, then there will be a referral to the impeachment committee, or there should be.
Is that the test?
No, I'm speaking colloquially about clear evidence, sufficient evidence.
So what if the panel says there is sufficient evidence? Should an impeachment, should it be referred to the impeachment committee?
No, the Assembly has to exercise its own judgment. It has to say, are there problems with this conclusion which the panel has reached?
See,
and secondly...
I'm just sorry to interrupt you. I'm just following up on the answer that you gave to Justice Colopin.
Yes.
Justice Colopin said that if that is the situation, there might never be an impeachment. And I just wanted to interrogate that because it seems to me there's merit in what he is saying. If we get, your answer was, yes, there may be, it might be referred to the impeachment committee when there's clear evidence. Now, who determines when there's clear evidence? Isn't that the nub of the problem that we're facing in this matter?
The panel makes a finding as to whether there's clear evidence, to use the colloquialism, and the Assembly must consider whether it's satisfied with that. But it has to apply its mind.
So,
it's not a rubber stamp.
So your answer to Justice Colopin should be adjusted. Even where there might be clear evidence,
yes,
in the opinion of the nationalist, of the report or of the panel, in terms of these rules, doesn't follow when there is clear evidence that there will always be referral to the impeachment committee.
And that is because...
And isn't that the difficulty with the rules?
That is the difficulty with the rules, but that's the difficulty with placing in the hands of the Assembly the decision whether there should be an impeachment inquiry.
And that's why this court must exercise an oversight function. to determine whether the rules that are in place comply with what this court said in EFF 2 must be done?
Certainly, the court should consider whether the rules comply with what's in EFF 2. But what EFF 2 said in the passage referred to by a number of the justices this morning is that the Assembly must decide whether the impeachment process should proceed. The Assembly must decide whether there's a case which must be taken on impeachment. And if that's what the Constitution requires, then we are in a situation where the Assembly is entitled to second guess.
And is it the submission of the party that you represent that the Assembly should have an unfettered discretion in that regard?
Justice Strong, I don't have an instruction on that. I have my own opinions, but I don't think they will be helpful to you. I don't have an instruction on that.
Thank you, Mr. Butler. Thank you, Chief Justice.
Mr. Butler, just two questions. Firstly, assuming we were to find that on a fair reading, the panel's report addressed itself to the right question and found that there was sufficient evidence of impeachable conduct.
Yes.
But assume also that the MPs who voted to not adopt the report did so in the genuine but mistaken belief that the independent panel had not addressed the right question. Would it follow that the vote was irrational? You've told us that rationality is an objective test. So if a vote is based on the view that the panel has not addressed the legally relevant question, whereas it has, does it follow as a matter of course that the vote is irrational?
I'd like to think about that, Justice Rogers. If I can take it step by step, the Assembly, positing the Assembly forms the view that the state of affairs exists, but actually it's wrong. And is its decision then irrational?
Yes. If you wish to think about it and come, and if the Chief Justice gives you an opportunity, unless you wish to answer it now.
I'd like to think about that, Justice Rogers.
My second question is this. Assuming the majority of the MPs in the National Assembly believed that the panel had addressed the wrong question, and assuming for the moment that perhaps the panel had got the test wrong, is it the right way for Parliament to proceed simply to reject the report? Let me give you a couple of hypothetical examples. Say that an impeachment motion alleging really serious conduct is referred to a panel, but the panel just doesn't report. It's delinquent.
Yes.
Presumably the answer would be, well, that can't be the end of it. You must then establish another panel. Here's another hypothetical example. There are 4 charges against the President that are referred to the panel, as they were here, but the panel only brings out a report on 2 of them. The answer would surely be, it must go back to the panel and they must give a report on those 2,
Yes.
the other 2. In this case, if the MPs thought that the panel had applied a lower standard of prima facie evidence, assuming that in the context of the report that was truly a lower standard than sufficient evidence, isn't the answer that the panel must then be required to answer the question, do they find that there was sufficient evidence? And for example, one of your criticisms, I think it is perhaps a fair criticism on the first charge, the earning of, assuming that one knows what the panel thinks on the interpretation, it takes a wide view that it includes being in a business where you are taking some decisions every now and again. Tell us why you think that rises to the level of seriousness. Speaking for myself, I quite understand the panel's thinking on charges 2 to 4. But say on that one, they say, send it back because you haven't addressed the question of seriousness. Why was it legitimate for Parliament simply to put an end to this because the panel had apparently not asked the right question? Now, I appreciate perhaps that's not the way the relief has been framed.
Yes.
It's not the way the case has been advanced. But we may need to consider what happens in this type of situation, whether it's in this specific case or the future. It seems to me completely contrary to the notion of holding the President to the account that the panel's report becomes a game of forfeits, that if you can trawl through the report and find something where it's misdirected itself, that's the end of it.
Yes. I accept that, Justice Rogers. As you say, this, of course, is not the case that was brought and the case we've come here to answer. The case we've come to answer is a case that says the decision of the Assembly was irrational. If the case had been brought saying you should refer back, ask the panel to have another shot, answer the following questions, give us the following information, that would be a very different case, and one would have to think about the facts quite carefully. But and perhaps it would be helpful in relation to future matters if the court were to indicate that the consideration by the Assembly doesn't have to be an all or nothing business. It's not either in or out. You can refer back, engage almost in a dialogue with the panel. It would be helpful to say that, and that might facilitate the resolution of future disputes about impeachment. But it doesn't arise in this case, because that's not the case which we are brought here to meet.
All right, we'll take a 10-minute comfort break until 4:30, and that will give you time to mull over
Try and find an
his
answer
first
to
question.
Justice Rogers in 10 minutes. That's
Yeah.
very optimistic.
Sorry, what did I say? I'm looking at that.
Thank you. Thank you, Chief Justice.
4:10.
What time? It's now 4 o'clock. 4:10. Thank you, Chief Justice.
There were these other reports that are
to toe the party line. Question 1. Question 2, were the reasons that were given by Mr. Lamula rational, and were those the reasons that influenced the vote of the majority? Those are the 2 questions we need to answer. On the first question, which is there any admissible evidence of political party instruction or intimidation or threats? The EFF has produced no evidence whatsoever in support of threats, intimidation that resulted in this vote taking place in this particular way. They have referred to a statement that was published in the Sunday World, quoting Mr. Mantashe, where he states that the ANC has particular rules and that people should ask what happened to Ms. Makosi Khoza. But no evidence that this was ever communicated to members of parliament whatsoever. No evidence that he even went to the caucus, and if he went to the caucus, what he said at the caucus. So no connection has been drawn between the members of parliament who voted and the statement. And when you actually read the statement, it's actually useful to go through the statement. What you will find, and you will find that statement at page 146 to 147, you will actually find that it's not even a threat. What he says is that the NEC, which is the National Executive Committee, had given guidance. Those are his words, guidance. What you will also find is that that report also quotes other members of the ANC who say that they will vote contrary to a preferred party position. In fact, it says they were unfazed at the statements that he was making. So Minister Mantashe's statement does not come close to establishing an instruction or a threat. And then what was quoted today is a statement made by MP Phala, who tried to correct the record about how she voted and said, I want to vote in accordance with the party line. But there is again no explanation, no instruction, no evidence whatsoever about why she thought the party line is the correct line. What are the facts then? The facts are what the ANC has produced, and you have to admit those facts on Plascon Evans. These are contained at page 853 to 857 of the record. What we know is that there were 3 bodies that made the decisions. One is the National Working Committee. The second is the National Executive Committee. Both in the National Working Committee and in the National Executive Committee, the president recused himself. And then the third is the ANC Parliamentary Caucus, which consists of members of the ANC in Parliament. Secondly, we know that the NWC met on the 4th of December, 2022, after the report had been published on the 30th of November, 2022. And in that meeting, the resolution that was taken was that the report would be voted against because of an intention by the president to review it. No politics. It's a pragmatic decision based on prematurity. We also know that the ANC obtained advice from senior counsel on the 5th of December 2022. Senior counsel concluded that the conclusions in the Section 89 panel report could not be used in their current form. After that opinion was submitted, there was an NEC meeting of the 5th of December 2022. That NEC also concluded that the report would not be supported because of pending judicial review proceedings. Again, a legal reason, not a political reason. In the morning of the 13th of December 2022, we know that the ANC Parliamentary Caucus convened in order to discuss its own position. Now, there are two things that are crucial in that meeting. Firstly, as pleaded by the ANC, there were dissenters. There were some members who said that they would dissent from the position of the from the position of the NEC. And those dissenting voices were merely noted at that meeting. We also know from the statement made by Mr. Philip Modise, who refuted as false the allegations of threats. We also know another member of parliament, Mr. Qubudile Janji, who said that the decision of the ANC was based on the balance of evidence, and specifically said that the members of the ANC would vote according to their oath of office and constitutional obligations. And so what emerges then from this narrative that is at 8:53 to 8:57 is the following. The NEC and NWC debated the report in the absence of the president, who recused himself. Their decision to reject the report was based on prematurity because it was at that stage subject to judicial review. Senior counsel advised the ANC that it would be premature to make use of the report in its current form. The Parliamentary Caucus considered the balance of evidence and noted the dissenting view of some of the members. So we ask you, Chief Justice and members of the court, to reject the allegations of threats as unfounded on the evidence. There were no threats, no unlawful acts of intimidation. Party discipline was indeed upheld, but personal conscience was respected, which is what this court requires. Then we must address the second question, which is, what is the substantive justification for the position taken by the ANC in particular? Now, we don't admit that one can come to court and challenge the ANC as such. It is only the National Assembly that can be challenged. But because much of the allegations in the founding affidavit relate to the ANC has decided to put the correct facts before the court. The position of the ANC is that it voted to reject the report in order to safeguard the impeachment procedure under the Constitution as such. It did so because it took the view that Parliament itself had to act lawfully. It could not merely rubber stamp the report of the Section 89 panel. And it is informed and inspired in that by the Nkandla judgment that I quoted at the beginning. That means that the National Assembly had the duty to satisfy itself of the lawfulness and the correctness of the report of the panel. What it did find was that the report was neither lawful nor correct. Why? Firstly, a debate has been held here about the distinction between sufficient evidence and prima facie evidence. But the consequences of this are much more severe than has been appreciated. We actually deal with them at paragraph 4.5 of our heads of argument. The panel is not a court of law, and so it's unhelpful to make references to standards in civil proceedings or in criminal proceedings. The panel is a tribunal, a subcommittee of Parliament, a committee established by Parliament. But this is why it's important. There are three stages that are crucial here. And at each stage, as Mr. Badland has suggested, there is a different evidentiary standard that must be met. At stage one, which is the charge sheet, actually the rule 129 capital A1A refers to the word charge sheet. The charge sheet must disclose a prima facie violation. If the charge sheet does not disclose a prima facie violation, the Speaker has no jurisdiction to refer the matter to the Assembly. To refer the matter to the independent panel, to constitute the panel. And then at the second stage, once the panel has done its work under 129G1B, sufficient evidence must then be established. And then the final stage, which is the stage of the impeachment committee, what they must do there is not to establish prima facie, not to establish sufficient evidence, but they must establish the veracity and the seriousness of the evidence. Veracity and seriousness of the evidence. So, when one was listening to the debate, one could easily make examples from civil proceedings. A pleading must disclose an action so that it is not excipiable. So one could think about a charge sheet which must disclose a violation so that it is not excipiable. But the evidence itself is a different matter, which the rule 129G1B seeks to import. And so, if the panel came to the committee, came to the National Assembly without making a finding of sufficient evidence, it fails to make a finding of sufficient evidence. What it is doing is that it is not discharging its mandate. It is not doing what is referred to in paragraph 4.5 of our heads of argument. We refer to this as a jurisdictional requirement. The correct language is jurisdictional fact. So for the Speaker to establish a panel, the jurisdictional fact is a charge sheet that discloses a prima facie violation. But for the independent panel to be established by the Assembly, the jurisdictional fact that is required is sufficient evidence. This court is familiar with this distinction from the judgment of Corbett J. in South African Defense and Aid Fund versus Minister of Justice. It's a long paragraph, but in the last sentence, he says, if the jurisdictional fact does not exist, then the power may not be exercised, and any purported exercise of the power would be invalid. So if we are correct, and we submit that we are, that there was an obligation on the part of the panel to establish a jurisdictional fact of sufficient evidence, and it failed to make that positive finding, then the Assembly had no power to constitute an impeachment panel. And this is why we have characterized this as a jurisdictional error. But it did not stop there, Justices. It went beyond, because it also did not consider the question of evidence, confining itself to information. You are right, Justice Colopen, that the panel must receive information, but it must process the information so that it casts aside what is not evidence, and then it leaves for the impeachment committee only evidence. So firstly, we have the wrong standard leading to a jurisdictional error, and secondly, we have the wrong standard leading to the failure to discharge a function that is assigned to the committee. This is why Minister Lamula, Mr. Badlander said Minister Lamula has been misquoted. He has been quoted correctly, but misinterpreted. The actual statement is at page 956A to 956F, where he outlines the problems. He says, this is not a mere terminological problem that I am concerned with. It's not a mere terminological problem. I am concerned because as soon as they failed to recognize that they had to collect evidence, they did basic things. If you look at 956C, they reversed the onus of proof and placed it on the president. They relied on inadmissible evidence and media reports. And they were found to have been wrong in at least one. They concluded that Mr. Hazim is probably a fictitious person. And a day later, Mr. Hazim, a day after the report was published, Mr. Hazim surfaced with a very basic inquiry by Sky News. And they were not saying that this must be referred to the public protector. What they were saying is that, and you'll see this at 956D to 956E, they were saying the evidence is incomplete, it is premature, and there are other institutions that have powers to investigate, and they may unearth additional information. And then, insofar as the PRECA issue, they said the problem there is that you did not make a finding of bad faith. It was interesting to listen to the ATM referring to bad faith, not in relation to PRECA, because Mr. Lamula was quite clear about where the bad faith issue arises. It is in relation to PRECA. But in addition to that, there is a dense critique of the report that shows simply how bad it was. And it is given in the President's answering affidavit at page 351, 352, and 353. I just want to make 3 observations from that, and they correlate with what Mr. Lamula was concerned about. They say, firstly, the panel sources, and you'll find this at paragraph 77, there were 2 statements from the police and their annexures. And then there was also a confidential report by the Namibian police pertaining to a Mr. Emanuela David. There were also audio clips of interviews with either suspects, one suspect, or suspects. But these were incomplete. Get a statement which is supposed to be 20 pages, but it is 11 pages. And the clips themselves were incomplete. So you get a portion, and you don't know what came before and what came after. And then you also get the sense that all of this came from a single source, Mr. Fraser. And you also get the sense that there was access to Namibian reports which are marked confidential, and you have no explanation whether these were stolen from the Namibian police or not, because the custodians of those reports were not before the court. And you have no sense when you get the statements what else was available in the context where those statements were pulled out of the Namibian police. So in these circumstances that the ANC said, let's put a bit of caution. Impeachment is serious business. If we are going to subject the head of state to this process, let us do at the very least 2 things. One, we need some comfort about the source, reliability, credibility of the information that we have in front of us. And 2, we also need to make sure that the panel has acted lawfully and constitutionally. Those are the fundamental justifications given in the answering affidavit. So you will see I've referred to Mr. Lamula's speech, and the court will take that into account. In summary, therefore, we say the ANC took the view that subjecting the president to a process of impeachment is a serious business. It is so because necessarily there is interference with the democratic choice of the voters. The voters have asked the man to run the country, but for weeks and perhaps months, he will now be cross-examined in an impeachment hearing. And at the outset, you must have jurisdiction to impeach. You cannot fix an alleged violation of the law by breaking the law yourself as Parliament. And therefore, a president should not be subjected to an impeachment on a whim, nor should an impeachment be used as a fishing expedition. Thank you, Chief Justice.
Mr. Declaratory, colleagues.
Mr. Nunkatobi,
Are you suggesting that the panel's report, despite the criticisms that may be legitimately leveled against it, would fall into either the category of a whim or a fishing expedition?
Yes, especially because the evidence is incomplete. And when Minister Lamula says, you are asking the president to hang himself because you've inverted the onus of proof, you said it's up to you to explain. That is a fishing expedition. And that is what he said in Parliament.
Could I just ask this, because I've been battling with this as well. The panel concluded that the president had a case to answer, correct?
Indeed.
The president takes issue with that because it says that's not the correct process to follow. That here's evidence and you, Mr. President, must rebut it. The president says the panel must look at the totality of all the information before it and come to the conclusion that indeed there is sufficient evidence of serious misconduct.
Yes.
And therefore it misdirected itself in terms of the process that it followed.
Yes.
So in that regard, are you saying that the question of whether the president had a case to answer is not the question?
That is an irrelevant question. It is part and parcel of the misdirections of law that were committed by the panel.
And then just finally, you heard the exchange between myself and Mr. Butlander with regard to the perhaps inherent and structural problems that the panel may have faced. Not all of the criticism could be ascribed to that. But is that something that this court should be concerned about, whatever its decision may be on the merits of this application?
Not in relation to the resolution. Because the structure of these rules, they make perfect sense, despite their attempts to undermine their structure. The panel is not to be restricted in what it can collect. It needs to collect information. But
it's restricted from who it can collect it, not so?
Yes.
Only from members?
Yes. Well, it got information in this case from Minister Zungula, MP Zungula, who had attached a lot of non-member information.
Sure.
Yes, so it did take that into account as well.
But then you run into the problems of hearsay, not so?
Yes. Yes, then it runs into problems because there's no limitation on the quality. It must be information, not evidence. So at the point at which it gets it, there is no requirement. But it goes through a process of sifting it and taking out what is not evidence and then leaving only what is evidence. What it cannot do, it cannot collect everything and then say, oh, well, here it is. When it does that, it's acting in error of its mandate.
Can I just test, and this relates really to charges 2 to 4. I won't try to distinguish between them too carefully. What point you say, and for what reason you say there is not sufficient evidence? Can we accept that General Roeder was in the Presidential Protection Unit?
Yes. No, let me just go back to Justice Rogers, to the actual report, because in fact I did want to deal with this.
Well, perhaps I can just ask my questions and then you can go back to the report.
Yes, yes.
If he was, could the panel also accept that it was no function of the Presidential Protection Unit to investigate the theft of money that Mr. Ramaphosa or his corporation may have suffered in its private capacity?
Well, let me go back to the report.
Sorry, it's a straightforward question.
Yes, yes, I am going to answer the question, but I do need to explain precisely the submission I'm making. So you go to page 137, well, 10 to 138. And you will find this everywhere, actually. 137, paragraph 238, and you will see there that the conclusion they reach is prima facie. You go to 138, 239, prima facie, and then you go to the charge 2, and you will find there the conclusion at 145, also prima facie.
But prima facie evidence. In other words, evidence which, if it is not answered, may establish the charge.
Yes. Well, it says in paragraph 264 where the actual conclusion is that this information discloses prima facie. So it's prima facie information, not prima facie evidence. So
If all the panel can receive is information.
Yes, but...
Can I ask you, I'm breaking away from my sequences of propositions, but
Yes.
you question the information about Namibia. Would you say that that would amount to evidence if the whole transcript and the whole audio clip was there as opposed to only part of it?
Well, there are two criticisms that were actually put by Minister Lamula. Number one is this criticism that unless you know the full chain, because you have, that's the one. The second one is distortion. In other words, it's information that is misleading. Even if it's evidence that is misleading.
Well, one doesn't know it's misleading. You say it may be misleading if you had everything else. All I'm saying is if you had a full transcript and a full audio clip as to part of it, as opposed to part of it, would you say that that would then be evidence?
Yes, if it was clear that it would meet some standard of admissibility, that's why they call it evidence. And no, it's not a court, it is a panel. But firstly, it must meet some threshold of admissibility. And secondly, it must not be cherry-picked. And those were the two criticisms.
Well, of course, we don't know it was cherry-picked. All we know is that perhaps it was what Mr. Fraser had.
Well, what we know is, if you can go to page 351 and 352, which is the analysis by the President of the information. (77.1, 77.2, 78, and 79. So you will see there that there is a problem about the incomplete nature. There is also a problem about the reliability.
But we must also take into account the, and it's been raised with you and your other colleagues by Justice Collipin and others, the panel is to some extent shoehorned into a process which must be finished within 30 days. It has no proactive powers to seek information. It simply evaluates information that has been given to it. But let's leave that to one side. I accept your proposition is that maybe the full transcript and audio clip would be evidence, but not just part of it. But anyway, if we can just continue. So,
well, Justice Rogers, no, I don't say that they should have got the full transcript. I say that if the panel wants to make a recommendation that there is a prima facie, there is sufficient evidence, it can disregard information that suffers from these defects and then only take forward that information that it would be satisfied would constitute sufficient evidence.
Or it may say, well, I've read what I've read in the transcript and I've heard what I've heard in the transcript. It may not be complete, but on what I have, it constitutes part of the evidence. But let me just carry on. So General Roeder was in the Presidential Protection Unit. It was no function of that unit to investigate the theft of President Ramaphosa's private money. And I assume you would accept it would be a serious abuse of power for the President to allow the PPU,
sorry, Justice
as it
Rogers,
were,
I'm not waving at you. There is just a fly that is
Yes,
refusing. That is just refusing to.
I'm sure you're not trying to
refusing to disappear.
It would clearly be an abuse for a president to allow the presidential unit, protection unit, to, as it were, on the clock, use its to go and investigate a private theft. I mean, there could be no doubt about that, surely.
If you did so mala fide, as required under the rules, and what also there could be no doubt about, whatever quibbles we may have as lawyers about the correctness or incorrectness of the Section 89 panel, the true question is members of Parliament acting rationally with the information at their disposal.
Yes, now I just want to find out for what there was and wasn't evidence. The next thing is, it seems to me to be common cause that no case of theft was ever opened in respect of this amount, which totaled in rands about 8.7 million.
Well, what we know is that he says, the president, I'm not acting for him, he says that he reported it to his head of security.
Yes.
And it was up to the head of security to open the case.
The head of the head of a unit which is there to protect the security of the president, that has nothing to do with the loss of the president's personal money. That I think we must be, or at least the panel could assume that President Ramaphosa was aware of that distinction.
Well, I'm not sure I want to accept that he should be assumed to have been aware that if he reported to his head of security, it will not end up with the police. I don't think that is a fair assumption.
Well, it was common cause several years after the event that there was no case opened.
Yes, that is true.
Just put yourself in the position of the panel, or you yourself. Perhaps 8.7 million rand is not so much money to council these days, but imagine, I'm sure I'm being facetious. Imagine you had lost 8.7 million rand.
Let me not respond. No, Justice Rogers, I mean, this is unfair, actually. I know that it's not, but it's really unfair in a matter of this public importance to make a joke like that and then to pass it on.
Let me then continue. 8.7 million rand, if, just as a matter of common sense, if a person loses 8.7 million rand, they would want to know who the investigating officer is and has it been reported to the police. Is there a case pending? And it's common cause that there wasn't.
Yes. But what is the question then for the issue that I'm dealing with?
No, I'm trying to
I see. We're getting
just see the totality of circumstances.
Yes.
Then we have, and the panel paid a lot of attention to this, the source of the foreign currency, because it did, in regard to charges 2 to 4, it was not merely the fact that there wasn't a report to the under the Prevention of Corrupt Activities Act. It was the finding of seriousness was that that was a deliberate decision because the president was wanting to keep secret the source of the money. That's the background to where the panel was coming from. Now, in that context, it seems to me it was the president's version, based on what Mr. Ndlovu told him, that an unknown person, who is then identified as Mr. Hamaz, comes to the farm on Christmas Day, just happened to be carrying in cash $580 million, $580,000.
Yes.
Yes.
Yes, and then?
And then he concludes the transaction not with the farm manager, not with the man who runs the buffaloes, Mr. von Willich. He strikes a deal to buy 20 buffalo from the lodge manager.
Yes.
And hands over $580,000 and gets this receipt that we've seen. And then the buffaloes stay on the farm and are never taken.
Yes, I'm still trying to work out where, in relation to the members of the National Assembly, the criticism is.
Well, if there was sufficient evidence of the various matters I'm putting to you, then one might say that the independent panel could legitimately come to the view that in relation to charges 2 to 4, there was sufficient evidence of serious misconduct, sufficient in context to be tested for veracity, not sufficient to convict, but sufficient to go to an impeachment committee. That's what their function is.
No, I submit no, because they did not actually make that finding. What would actually happen if we got where you are, Justice Rogers, is you would have to fundamentally rewrite the conclusions of the panel. That's why I was asking the court to have regard to page, there are actually several pages, 128, paragraph 204, 137, paragraph 238, 138, paragraph 239, 145, paragraph 264. It's so clear in those paragraphs that what they thought they were doing is to establish prima facie evidence based on information?
Well, we will read the whole report. You'll recall, I think, the acting Deputy Chief Justice put to, I think it might have been to Mr. Budland, certain earlier paragraphs which appeared to indicate what the panel understood. But I accept, bear in mind, the panel here says, even after hearing the President's version, taking into account what he says, this is not just yet unanswered evidence. Together with his evidence, we take it that there is prima facie evidence. But if you say that that was the wrong test...
Yes. So, in fact, I think we are together, the criticism. If you want me to comment, let me know, Justice Rogers, if you don't want me to comment on the 2 paragraphs that Justice Madlanga referred to.
Perhaps let me just finish and then you can come back and comment on those 2 paragraphs. Yes. We then find that the $580,000 is not put into a safe, and I would have thought more importantly, it is not put into a bank where it would have earned interest at about 2,300 Rand per day. The first thing anybody who receives 8.7 million Rand wants to do is to make sure it goes into their money market account. You don't leave that much money, sorry, I'm now speaking as a matter of common sense. You don't just leave that money either in a safe or under a sofa. I'm not talking about, it's common cause that it wasn't banked and it was hidden in a sofa.
Yes, well, the question is, what is the role of the members of Parliament in relation to what the President knew at the time?
Well, if they read the whole report, because the structure of the report is before the committee starts dealing with the individual charges, which starts at paragraph 181,
yes,
where it starts with charge 1. It's had what seems, in the context of its report as a whole, to be a very important chapter 12 that runs from page 89 through to 173, including the conclusion in paragraph 171. And that's all to do with the source of the money. And it is clear from the panel at least believed on the information that had been submitted to it that it did not accept that the money had come from the sale of buffalo.
Yes. Just now,
sorry. And then, having considered the individual charges, it then in chapter 15 deals with the seriousness of the violation and the misconduct. And it is at that point that it ties in chapter 12 with charges 2, 3, and 4. To reach a conclusion, call it a prima facie conclusion, yes, that the reason why there wasn't a report to the DPCI and the reason why a case wasn't opened and the reason why General Roeder, as it were, off books, conducted an investigation and into the theft was because the source of the money was not legitimate. There was an attempt being made to conceal that was the case.
Yes.
Now, I assume you accept that if there was, let's just say, prima facie evidence of that, that would be prima facie evidence of extremely serious misconduct.
Yes, I have no difficulty accepting that at all.
And do you say that there was prima facie evidence of that, but not sufficient evidence?
Yes, no. Yes, I think this is where you and I, Justice Rogers, do not seem to be getting what I'm trying to say. I am saying the finding that must be made by the panel is sufficient evidence. If the panel erroneously fails to make that finding, that is sufficient to vitiate its report. And that is why I've taken the court to where the panel makes that finding. So my primary point is from the perspective of the MPs that were voting on the report, what they needed to look at, which is what was debated, did the panel act in accordance with its terms of reference? Its terms of reference required it to conclude sufficient evidence. Did they do that or not? They came to the conclusion that it didn't. And on that basis, they said we could not correct an illegality with another illegality. We would vote down the report. Now, it may be that one day, in a criminal case, the president will have a case to answer. It may be that one day, in a different case that comes before the National Assembly, the ANC will take a different position. But on this report, in these findings, the National Assembly was perfectly rational in arriving at the decision that it did.
Now, the expression prima facie evidence does still refer to evidence, but you say the fact that it is prima facie stands on a different footing from its being sufficient.
Indeed.
Now, in the context of the report as a whole, if one reads what the panel regarded as the evidence, and you say, but it formulated it as being merely prima facie, but if you look at that evidence and you say that although it called it prima facie, it was within the context of its function under Rule 129I sufficient, bearing in mind that it's not, as you have said, a veracity exercise. The context is it enough to go to an impeachment committee? What would you understand the precise difference to be between, let's assume for the moment it amounts to evidence. It amounts to prima facie evidence as opposed to sufficient. What do you say is the lower test which has been impermissibly slipped in?
The distinction is better explained by reference to the rules themselves. If you go to page 631, at Rule 129A, and 129A 1 sub A.
Sorry, 1?
129 capital A, brackets 1 small a.
Yes.
So the rule itself tells you that when the Speaker decides whether or not to constitute a Section 89 panel, she must already apply her mind to whether the charge sheet contains prima facie, discloses a prima facie case against the President. But that changes fundamentally when you go to 633. Sorry, no, it should be 630.
Where the sufficient evidence exists.
Yes, whether there's sufficient evidence that exists.
Yes,
Now,
sorry.
Yes. Now, what that means is that it is not up to the court, and it is not up to the assembly. It is up to the panel to come to the conclusion that sufficient evidence exists. That's number one. Number two, we know here, we don't speculate, we know precisely here that they did not intend to do what you are suggesting, Justice Rogers, because they specifically debated the difference, and they ultimately came to the conclusion that there is no difference.
There is no difference.
There is no difference. That is the conclusion.
Yes, but that was my question. What is actually the difference? Bear in mind what the Speaker does when she or he vets the motion is only looking at the evidence put up by the party moving the motion. That's the only evidence at that stage.
Yes.
That's one side.
Yes.
By the time it gets to the independent panel and it reaches its conclusion after it's gone through all the processes it must go through, it has also heard the President's version.
Well, we can...
And now the question is, in the light of all, and bear in mind, it is no longer the Speaker who is, as it were, doing a first cut, and the Speaker may, with due respect to her or him, not have any legal qualifications.
Yes. No,
that same evidence, plus any additional evidence that has now been placed before the committee, plus the President's response to it, all of that, is there sufficient evidence? Now, all of that has been considered. Now, in the context where you have not now only heard one side, but you've received additional information supporting the motion, and you've received additional motion against it from the President. Yes. Now you say, in the light of all of that, the formulated test is sufficient evidence. But what I want to know is, what is a lawyer conveying when they assess all of that evidence and they describe it as prima facie evidence rather than sufficient? What is the qualitative difference that you would then understand between those two formulations?
Well, the first thing we would know for sure is that they did not do what they were asked to do, which is to consider whether there is sufficient evidence. We know that as a fact. They specifically disregarded their terms of reference. And in fact, Justice Rogers, you're reminding me of something else. We found the actual terms of reference. They are in the SLA. We tried to submit them. There is an objection from the EFF. But it's important for the court to know the actual terms of reference that the panel had. If the court is interested, we would be happy to circulate those, but we've now got them. So we know for a fact that they disregarded their mandate. They were told they must find, positively find, not hide it in another language, positively find. And that is because, and this is important, that's why it's not a terminological problem. It's important because you are going to send this to lay persons, 400 of them, and you are going to ask of them to make a decision. And what they will have in front of them is they will have the terms of reference they gave you and your report. The first thing that will be glaring is that you disregarded what they asked you to do. And so when you are going to vote on it, about whether you need to proceed with this or not, the first thing that will strike you is that they disregarded the instruction that we gave to them. There is a different question, an analytical question among lawyers, which is, what is the legal distinction between the two? Now, the answer to that is that that distinction is foreshadowed by Parliament itself by making sure that the Speaker and the panel do not ask the same question. They ask different questions. And on the evidence, the question is, what did the parliamentarians understand the difference to be? What did the parliamentarians understand the difference to be? Now, on that, we have two sources. One, we have Minister Lamula's statement, which is 956A to 956F. What he says are the problems which distinguish information from the evidence. He says, number one, and you can, it's 956C. He says the first problem is the so-called conflation of information and evidence. And he explains that evidence and information in law are two different things. Information is knowledge obtained from investigation, study, or instruction. Evidence is what is legally submitted to a tribunal to ascertain the truth of a matter, and it must have passed the admissibility test. Furthermore, there is no analysis in the report which shows how the information which was provided to the panel was converted into evidence. He goes further.
Sorry, but if I can just pause there. At least Mr. Badneder understood to not embrace the notion that sufficient evidence has any connotation with what's presented in a form that's admissible judicially.
Well, we would submit that it must at least pass some standard. I mean, if, for instance, as I'm making the example of an incomplete statement, it's an incomplete statement. You have no idea what is the name of the witness. You have no idea where was it signed, where was it obtained. It is information, and it may contain crucial information.
See, I did a search of the phrase sufficient evidence in the statutes. It's used many times, and it's very frequently used completely unrelated to what might be admissible in a court of law. For example, in regard to BEE status and qualifications, has the person submitted sufficient evidence of this or that? There's even a reference to, is there sufficient evidence to make out a prima facie case? That also appears in the statute. An auditor must audit to establish sufficient evidence of something. You must submit a bank statement to the master or some other sufficient evidence. We're not talking necessarily about anything that's admissible in a court of law.
Yes.
So a document might be, even if it's not proved through the author of it, might be sufficient evidence or part of the evidence.
Yes, or it may be so unreliable that it should be disregarded because it would not even pass the threshold of evidence prior to its sufficiency. And this is what Minister Lamula said at the time in the meeting, because that is the true test, is what did they understand the difference to be, and can you impugn their understanding of that difference? So it goes further because it shows that there is a qualitative consequence. It was not just about text. Then he says, firstly, on the burden of proof. And it goes to your question, well, they had regard to the president's statement, but what did they make of it? The panel decided to evaluate which version is more probable instead of evaluating whether there is sufficient evidence for a committee to be constituted as per Section 89 of the Constitution. The panel effectively reversed the onus of proof and put the president in a position where he must disprove a version placed before the panel. Then it goes further, hearsay and media reports. The panel did not justify the use of hearsay evidence without the panel itself warning us about hearsay evidence. In paragraph 84, the panel tells us we are mindful of the dangers of relying on hearsay evidence and the caution to be applied in approaching such evidence. The panel failed to lay a proper basis for admitting hearsay evidence. The paradox played itself out in relation to information which related to Mustafa Hazim. It goes on and on and on. Remember, they said he doesn't exist. It turns out he, in fact, does exist.
So there's potentially incompleteness of some documents. There's a complaint about hearsay. Can I just ask you, what, in the context of this rule, what evidence do you say meets the test of sufficiency? Not in the facts of this case. How would you formulate a test that meets the standard of sufficient evidence? What is the level of sufficiency? Bearing in mind that it's not veracity, bearing in mind the limits on the panel's investigative powers, can't receive oral evidence, and bearing in mind that it's a precursor to, let us call it, a full-blown trial before an impeachment committee. So what is sufficient?
No, thank you, Justice Rogers. That is a helpful question. So firstly, we know what is outside. It's what would meet a prima facie, because that has already been done by, the Speaker.
I'm not yet clear of that, because I don't yet know. Maybe I haven't fully understood everything you've said to me, but I don't yet understand. Now let's talk as lawyers. I know the 400 MPs are not lawyers, but
Yes.
let's talk as lawyers.
Yes.
In the context of a panel that has heard the input, including the person against whom the charge is made, and then said, we believe this constitutes prima facie evidence of serious misconduct, instead of saying we regard this as sufficient evidence of serious misconduct to justify going to an impeachment committee. What do you understand the difference to be? So, and I think it would be helpful to address that question by first answering the point, what is sufficient?
Yes. Well, Justice Rogers, perhaps just give me 1 second to just follow the pattern I was following to answer you. I'll definitely come to that question. The first point, it goes to prima facie evidence. Now, the distinction I draw between the two, because that's the crucial distinction here in the context of the panel, is it's the sufficiency of the charge itself. In other words, if the allegations contained in the charge were to be established by evidence at a trial, would they constitute an impeachable offense? So that answers the first question, which is what the Speaker has to decide. Then it goes to the second phase. At the second phase, the evidence itself has not been tested for veracity.
The second stage being at the panel stage?
No, I'm saying at the sufficient evidence stage, because there are 3 stages.
Yes. Yeah,
So stage 1 is the charge sheet stage.
Well, the motion, yes.
Yes. Stage 2 is the evidence stage, the sufficient evidence stage. And then stage 3 is the trial stage.
Where something presumably has to be proved at least on a balance
Precisely.
of probability.
Now, on the second phase, and we know this because, as you say, we must talk as lawyers, we know this because it happens a lot in civil trials. At the second stage, what the panel must be satisfied with is that the documents or the information it has would constitute evidence. Secondly, firstly, it must be evidence proper. In other words, it must not suffer from all of the problems that I've been alluding to. Incompleteness, clearly inadmissible, clearly misleading, cherry-picked, and all of those. That's the first question. The second question it must be satisfied with is the question of sufficiency. Now, on that issue of sufficiency, it must at least be satisfied that if this were to be put to a trial, if this were to be tested on a trial, it would be sufficient, there would be enough to take it to a trial, sufficient to to find the president guilty. So it's information we can take to a trial. So it's evidence that does not suffer from the defects I've spoken about, but it is evidence that would establish a breach of Section 89 of the Constitution. The third stage, which is the stage of veracity, is now testing the truthfulness of the evidence and not establishing its existence, factual existence, which is stage 2.
If the panel, independent panel, considers that there is evidence which, if nothing more is said, is sufficient to establish guilt, would that be sufficient evidence?
Well, it depends whether it is firstly evidence. If it is evidence...
Yeah, I'm now just... step aside from this, but I'm trying to explore what the concepts mean. If a panel, talk abstractly, considers that there is sufficient, that there is evidence that if nothing more is said, if it is not disturbed, it will show serious misconduct, then is that sufficient evidence?
Yes, it would be sufficient evidence.
Now, at least on my understanding of prima facie evidence, it means the same thing. Evidence which, if not answered, will establish the charge.
No, but not on these rules, Justice Rogers. Not on these rules.
Well, I'm not talking about the rules. I'm talking about the way a panel reasons. It reasons not on the strength of what it read in the ATM's original motion, which the Speaker looked at. It reasons with reference to all the information it had, which included additional information in support of the charges and responses from the President and some of his people against it. Now, on all of that, if by prima facie evidence, the panel is saying evidence which, if it is not disturbed, will establish the guilt, it seems to me that it's perhaps gone further than sufficient evidence. Because sufficient evidence means, is there enough to justify putting the President through this process? It doesn't seem to me that that necessarily entails evidence which, if nothing more is said, would actually result in a conviction.
Well,
so prima facie evidence, in the sense you and I perhaps understand it, which in the absence of an answer becomes enough evidence, that might actually be more evidence than sufficient evidence.
No, Justice Rogers, the only distinction I'm making, and I think it's important to keep that distinction because we are dealing with the rules. On the rules, the charge sheet must contain sufficient information on the charge that if there was evidence to substantiate it, there would be a finding of guilt. But the evidence itself, which is the second stage, is not the same thing as a prima facie. What they must then do is this evidence? And if the evidence were to be established at a trial, I suppose sometimes there might be a response, maybe there would be no response. If it is established at a trial, it would be enough to convict, to establish the offense. Beyond that, not just conviction, but seriousness to justify an impeachment. So it's not helpful, with the greatest of respect, to say in criminal law, this is how I understand the standard. In civil practice, this is how I understand the standard. What is helpful is to look at the rule.
Just finally, since you said, did I want you to comment on the passages that the acting Deputy Chief Justice put to Mr. Budlinder, a particular paragraph I would extract from paragraph 76, which is at page 90 of volume 1.
Yes, it is 75 and 76.
Yes, but in 76, the President shouldn't be required to undergo a full-scale impeachment inquiry where the President has no case to answer. That step may never be taken lightly. It is a momentous act justified only when sufficient evidence exists to show that the President has a case to answer for his conduct.
No, that's what I wanted to answer.
And do you say that that is itself a wrong statement?
Yes, exactly. This is itself a misdirection. That very statement is a misdirection. And the following statement is also a misdirection.
So if, including in the light of what the President himself and his witnesses have told the panel, and the assessment of all of that, the panel says, we have heard enough that we consider there to be sufficient evidence that there is a case to answer now in a veracity inquiry. You say that's the wrong inquiry.
Yes, well, this is not what they are required to ask, because look at the following sentence. The panel therefore functions as a filter to ensure that only a motion which establishes prima facie that the president has a case to answer is considered by the impeachment committee. That we say is the wrong standard. Even the earlier statement is a wrong standard because it is not a case whether the president has a case to answer. It is a case whether or not, as the rule states, whether or not there is sufficient evidence that there is a violation under Section 89 of the Constitution.
I would have thought, given that the panel has recognized the momentous nature of impeachment proceedings and the fact that its interposition between the motion and an impeachment committee is to ensure that that is not embarked upon lightly, that when the panel talks about whether there is sufficient evidence that the president has a case to answer, it means sufficient evidence to justify the president being required to answer it in an impeachment committee. And I would have thought that that is exactly what sufficient evidence must mean. It doesn't mean sufficient evidence to convict. It doesn't mean it needs to have the same quality of admissibility that might be insisted upon by those who conduct the impeachment inquiry. It means sufficient evidence to expect the president of our country to answer it in an impeachment committee. Now, did you find that formulation objectionable?
Justice Majid said that he was not trying to argue a case against counsel earlier, but Justice Rogers, I think you've heard my submissions.
Well, I won't take offense to that if you don't take offense to my
yes. So, no, I've forgotten about that episode. So it's not going to happen again. But Justice Rogers, you've got my submissions on this, and I hear you. I won't say you're making submissions to me, but I hear the counter view.
Well, let me just put it to you, and this is my final proposition. And forgive me if you think I'm arguing, but I'm genuinely trying to understand what sufficient evidence means in the context of this rule and in the way that the panel used it, because that's central to the reasons why the majority of the MPs rejected it. And what I would want to know is whether, as a matter of law, in the context of these rules, does the panel act rightly or wrongly if it sets itself the test? Is there sufficient evidence to warrant the president having to face these charges in an impeachment committee? Is that an acceptable test?
No, the argument we make is that that is not what the panel did if one reads the report of the panel.
You say it's not what this panel said?
Yes, that this panel specifically found that its inquiry was about prima facie information.
But if we are to determine what is the difference between sufficient evidence and prima facie, if we are just to understand as a court what sufficient evidence means in the context of this rule, you would not quibble with the proposition that it means sufficient evidence to warrant putting the president through the momentous event of an impeachment committee hearing.
Yes, that I thought that is how I articulated the definition.
And your submission is that that's not
Yes.
the question that the panel asked itself.
Yes, they misconstrued their role because they didn't ask that question.
Thank you.
Okay, let me keep quiet.
Thank you very much.
I think Justice Matopo's...
Not that too fast. Mr. Ngugai-Toby, I've been following the debate between you and my brother Rogers. I want to take you to certain references in the report itself.
Yes, I need to just get... Yes, I'm listening, Justice Matopo. I just need to get the full report in front of me.
Well, just find it because I want to draw your attention to certain paragraphs in the report and go through them.
Yes, I've got it now.
Firstly, I kick off with paragraph 72. This is where the panel says, we have compared the terms of reference for this panel to those of the panel established for the removal of public protector. The powers and functions of those panels are substantially the same, save for one noticeable difference. the wording of the terms of reference, the terms of reference for the removal of the public protector require the panel to conduct and finalize a preliminary assessment relating to the motion proposing a Section 194 inquiry to determine whether there is prima facie evidence to underline it to show that the holder of a public office is guilty of any offense listed in Section 174. And they say, by contrast, this panel is required to make a recommendation whether sufficient evidence exists to show that the president committed one of those grounds for the removal from the office.
Yes.
But when it goes further, it conflates this test. It talks about prima facie evidence. If you look at paragraph 75,
Yes.
That's where the prima facie evidence comes into the fore. Paragraph 75, paragraph 76, that follows. Now, one is left with a misapprehension as to exactly what test is the panel following and applying. Because clearly sufficient evidence, as far as I understand it, is not prima facie evidence. And in the context in which it has been used, the panel specifically made that distinction in paragraph 74 to say, we are now dealing with two distinct concepts.
Yes.
But when you read paragraph 75 and paragraph 72, there is a conflation.
Yes.
What are we to make of that?
Well, there are two ways of reading this report, maybe three if you listen to Justice Rogers. But I submit that there are two ways of reading the report. The first one is a fundamental misapprehension of the terms of reference. Right? It's told, go and find sufficient evidence. Then it decides it's not going to do that. It will do something different. And that's a misapprehension as to power, and therefore, on the jurisdictional facts standard, Panama is entitled to say, we're not going to follow an error of law. The second one is that there is a fundamental confusion in the analysis of the report, because firstly, it recognizes what it is required to do, and throughout the balance of the report, keeps conflating the two as opposed to separating them. On either of them, whether or not what I have tried to suggest to the court is illustrative of a misapprehension as to the correct legal test, or it is illustrative of deep-seated confusion. On either of those two, the Parliament was entitled to refuse to go along with it. The third possibility is what I've been discussing with Justice Rogers, if I understand him correctly, which is forget the nomenclature that is apparent in the report, do an analysis on your own. And what conclusion do you arrive at if you do your own analysis? Now, that is a very, very dangerous thing to do, because it is not your function to recast the report on behalf of the panel. It is not your function to place yourselves in the position of members of parliament. You have to accept the report as it is, accept the members of parliament as they are, not to rewrite it for them. I don't know how many other reports you'll do this for.
Is it correct that the panel's information, I use the word guardedly,
yes,
information regarding the report, the compilation of the report, the information was scanty, or it did not have sufficient information? I'll read to you paragraph 80. Just look at paragraph 80 of the report. It says, we are concerned that we have not been given all the information that is presently available on the Phala Phala issue. Just stop there.
Yes.
And this and it lists a various institutions that are investigating the case. In other words, they are saying we are hamstrung in our investigations. We are unable to come to a proper and justiciable finding because we don't have information. It's that
Yes.
assumption correct?
Yes, no, it is correct, and in fact, it's stronger, Justice Matopa, because it's precisely what Minister Lamola says. Remember that he was criticized by the ATM for taking into account this fact, because he also says, look, you have told us you don't have enough information to come to the conclusions, but nevertheless, you've come to the conclusions. And these inquiries, are pertinent. We now know with the benefit of hindsight. At the time that Mr. Lamola spoke, he only knew of one, which was this Mr. Hazem Mustafa that was said to not exist, in fact does exist. And then he said it's very, very dangerous to put the president through this on the basis of scanty information, because what that really does is that this becomes a fishing expedition. So it's correct that they themselves admitted that they did not have sufficient information.
In the bigger scheme of things, a panel confronted with a report or an investigation of that nature, I don't understand why they didn't ask for an extension.
Yes, in fact,
they make the point somewhere in the report that they are operating under serious time constraints. I will look for the reference.
Yes, in fact, I think it's one of the criticisms by Minister Lamola, who says he doesn't understand. He doesn't understand why they. Oh yes, it's at 956E. So if you look at 956E, 1, 2, 3, 4. 956E. So he says. Two, the panel could have requested an extension of the time period to finalize this report, which it only did once. The Zondo Commission requested extensions till we got tired. All right, anyway, the point is made.
Well, the last paragraph that I want to draw your attention to and ask your comment is paragraph 82 of the same report. There they said, that said, we believe the truth of what really happened lies beneath the unanswered questions that are foreshadowed by what we are told from the information placed before us. We neither have the tools nor the power to excavate beneath the information that we have been provided with to uncover the answer to the unanswered questions. However, based on what we have been told by the information placed before us, the information that is either common cause or undisputed, as well as inherent probabilities, we are able to make our finding and provide reasons therefore and make our recommendation.
Yes. It's illustrative of the bigger problem that although the panel claims to appreciate the momentous nature of the function before it, it didn't actually carry through that concern. Because if it claims, firstly, not to have enough information, and secondly, not to have the tools to get enough information, not to even ask for Parliament's assistance, because it would have been entitled to ask for Parliament's assistance, not to even ask for an extension, and then to simply say, no, we'll just make do with what we have. So that we would say is itself, as Minister Lamola pointed out, evidence of a misdirection.
Thank you, Chief Justice.
Thank you, Mr. Ngaitobi.
Thank you, Chief Justice. I'm indebted to the court and to Justice Rogers.
A reply, Mr. Remedies.
Madam Chief Justice, members of the court, I don't have the graveyard shift. That's Mr. Katz's responsibility, but I'm going to try and make 6 simple propositions in reply in this matter, which should evidence why the relief sought by the EFF should be granted. The first one is this. The panel made a finding on the evidence presented in front of it, and the ultimate conclusion that it reached is that there is a case for the President to answer. Now, our learned friends for the respondents tied themselves up in knots in trying to rebut that, because every time, like in the debate between Mr. Mukaitobi and Mr. Justice Rogers, when the supposition was made, well, let's read, for example, sufficient evidence every time prima facie is used, would you object? And there was no cognizable answer to that, because what our learned friend Mr. Mukaitobi couldn't distinguish is what's the qualitative and what we would say is the substantive difference between sufficient evidence as relied upon in the rule and prima facie evidence as relied upon by the panel, but not as some free-flowing and free-floating concept, prima facie evidence as they understood to mean the same as the sufficient evidence which they discussed in paragraphs 75 and 76 of their report. And the panel knew, with all due respect, that they were subject to certain constraints. Shouldn't surprise you to know that, because when the panel does its job as the panel, it's acting as what we know in public law language as a creature of statute, or as a delegee that's constrained by the delegation of the superior power to it. And so the panel at various times acknowledges those limitations, and it acknowledges those defects in the rule which constrain its ability to perform its function. And every time it's aware of that, it uses language to tell you exactly the case. And Justice Matopo referred to paragraph 82 of the report. I would say look at paragraph 83 with all due respect at page 92. Because the panel says this: the President has rightly criticized the evidence contained in Mr. Fraser's statements as full of hearsay, in particular information from undisclosed sources. But on that specific point, the hearsay contained in Mr. Fraser's statement, they go on to conclude as follows: we are mindful of the dangers relying on hearsay and the caution to be applied in approaching such evidence. However, we are only concerned here with the preliminary inquiry and not the inquiry itself. So the panel gets dealt an imperfect hand, because in the course of the debate today, both the applicants, the EFF and the ATM, and some of the respondents have criticized the rule as containing anomalies or defects or whatever the case might be. But the panel doesn't have the ability to act outside that rule. And so when it does what it does, it reaches the conclusion it does fully cognizant of those limitations on it, but nonetheless reaches the conclusion that there's a case to answer. So if you remove all of the semantic quibbling between the respondents and ourselves about whether there's an appreciable distinction between prima facie evidence and sufficient evidence in the way the panel applied it when they considered the evidence, not the same as when the speaker considered the motion, but when the panel itself considered the evidence, both for and against the contents of the motion, the unanswerable question is that there's a case to answer. That's proposition number 1. Proposition number 2 is this: when the National Assembly came to reject that report, which says that there is a case to answer, they did not say that the panel did not find any of this evidence. They said it was a threshold dispute, and that the panel effectively committed an error of law in applying one threshold as against the other. But for all the reasons I addressed in opening, dealing with Magwakwa, and I'm not going there again, and having regard to the fact that the panel itself tells you how it reasons these two things, that demonstrates to you, with all due respect, that the National Assembly's decision that there is some difference doesn't even get out of the starting blocks, with all due respect. Because that reason, as we've submitted in written argument and in oral argument, is a distinction without a difference. What the National Assembly did is it latched onto some or other difference that it identified and elevated that to an error of law in circumstances where it is not that at all. And you know what we say about the difference in respect of those things and why they're not different at all. Proposition number 3 is that to the extent that the panel did, the National Assembly did disagree with the panel, and it did so on a political line of reasoning, which may or may not have been correct legally, but nonetheless emanated from political discussions, or whatever the case might be. We'd remind the court of what this court said in UDM 2017 volume 5 SA 300cc, and particularly paragraph 79. Members are required to swear or affirm faithfulness to the Republic. Nowhere does the supreme law provide for them to swear allegiance to their political parties, important players though they are in our constitutional scheme. Meaning, in the event of conflict between upholding constitutional values and party loyalty, their irrevocable undertaking to in effect serve the people and only do what is in their best interests must prevail. This is not only so because they were elected through their parties to represent the people, but also to enable the people to govern through them in terms of the Constitution. So we repeat that because we say there may be some world in which a political reason passes legal muster and a political party can rely on that to vote down a report. But we're saying that's not the case here. Because even if this distinction was engaged in bona fide by the ANC, it doesn't matter. Because when the reason is scrutinized as to why the report was voted down, there's no cognizable reason as to why that reason should be sustained. Insofar as proposition number 4 is concerned, and this is on the subject of delay, we would say that the question of delay has concerned the court significantly throughout today's proceedings. We would give 2 references, if we may. The first one is Notiyawa versus Makana Municipality and others, 2019 ZACC 43 at para 49. And what the court says there is that the delay and the extent of the illegality raised in respect of the impugned decision constitutes a weighty factor in favoring overlooking a delay, where, as in Gijima and Tasima 1, the illegality stems from a serious breach of the Constitution. A court may overlook the delay in order to uphold the Constitution, provided that the breach is clearly established on the facts before it. And we would say we're exactly in that territory here, having regard to what's happening. And the court went on to say there, this flows from the obligation imposed by section 172(1)(a) of the Constitution, which requires every competent court to declare invalid law or conduct that is inconsistent with the Constitution. We ask you to do no more. So to the extent that delay might stand in my way, it's, as I was debating with Justice Matopo earlier, it might be relevant as to remedy, but not as to the merits finding in the way that the court has understood it in Notiyawa. That's proposition number 4, I think. Proposition number 5 is this. Is the debate that we're having here is one about the structure and the competency of the structure to vindicate the principles set down in EFF 2. And the reference I gave earlier was to Glenister 2 at paragraph 234. It's actually paragraph 247. And what the court says there, and we say that that logic applies here as well, is that when they were discussing the powers of the investigating judge and the NDPP and determining policy, the court said this: the NDPP may on reasonable grounds refuse to accede to a request. This is a request of the investigating judge. That may place a considerable hurdle in the way of the retired judge's investigation. In short, an ex post facto review, rather than insisting on a structure that ab initio prevents interference, has, in our view, serious and obvious limitations. So insofar as our debate on the rule is concerned, we say that's what we're asking you to do, a la what the court did in Glenister. Make sure that the structure limits political interference. And I don't know whether that's time out or whether the court is going to ask me questions.
It means your protected time is over.
Okay,
And
so
you-
I've got a last proposition then, subject to any questions being asked.
Make it
on the
very
court.
quickly.
Yes, thank you, Chief Justice. The last one is this, is that insofar as those reasons are concerned that were advanced by the National Assembly, what we know is that those reasons, well, the ANC as the controlling mind of the National Assembly constituting the majority at the time, what we know is that those reasons can qualify for unlawfulness both as a rationality challenge, that's the absence of the connection to the outcome, and reasonableness, because reasonableness was raised by, I think, our learned friend, Mr. Badland, or Mr. Ngukhaitobi, I speak subject to correction, that there's a distinction between the two. We say here that where the artificial distinction is as it is, there can be no reasonable outcome in the circumstances because of the reasons we've already addressed in Magwakwa and the other discussion we've had on evidence. May I take an instruction? I seem to be let off the hooks behind me. I don't know about in front of me.
In front of you as well, it seems.
Thank you, Chief Justice.
Mr. Katz?
Yes, this is truly the graveyard shift. And I'd like to make 4 points. The first is, if I understood Mr. Banda's response to Justice Rogers' question on the issue as to whether the administrative law type issues such as Westinghouse, etc., apply to a decision of the National Assembly, his response was, look at Scalabrini SCA 2013. If I understood his answer correctly as to rationality. I'm going to ask the court, when it considers that answer, to consider this court's decision 5 years later in Saripa, where this court, we would submit, qualified the Scalabrini test to say that arbitrariness occurs when there are no reasons. And when there are reasons, then one looks at how the reasons fit in with the notion of the purpose of the action. So Scalabrini, for the purposes of the debate with Justice Rogers and my learned friend, doesn't assist. It's proposition number one. Proposition number two, and the proposition number two is, even though when the National Assembly passes the resolution it does, in this case, it might not be PUJA, it might not be executive action, but there's no reason in principle why the Westinghouse idea doesn't apply to it. So if the National Assembly, or however one categorizes what it was doing, has 3 reasons why it does so, and one of them turns out to be rotten, it taints the whole decision. Like admin action, the same principle applies. The third proposition that I wish to make is, I've listened to my learned friends on my right carefully, 4 hours, however long, and I didn't hear a word, not a peep, about the question of paragraphs 192 to paragraphs 194 of EFF2, and the question that there should be no political, well, this court said in EFF2, there should be no political interference in that gap between the complaint coming in, the charge coming in, to the impeachment committee. Not a word in answer. And there are 2 possibilities. Either my point is so bad that they don't have to deal with it, or it's so good that they can't deal with it. and I submitted the latter. Just on that point, we're very attracted to Justice Colopin's questioning on the issue of 129I not being as clear as it could be and it should be. And I think Justice Theron picked up on that, and we would add that to our basket on the question as to why 129I should go together with 192, 194 of EFF 2. The last point that I wish to make, the fourth point, is this. And here I'm not freestyling, I'm going to freeload from Justice Rogers' debate with my learned friend for the ASC, and it's a serious point. All of the respondents have spoken and presented argument as if the decision that the National Assembly was taking in December 2022 was the impeachment decision, and it wasn't. It was a decision, as Justice Rogers put to my learned friend for the ANC, a decision in that debate where the sufficient evidence exists not to impeach. That's a different test. Forget about prima facie, forget about all these issues. It was a question of sufficient evidence as to whether there should be a trial. And all of the kinds of arguments and the references to EFF2, all the paragraphs that you've heard of references, all related to that last question, to the last step in this big process of impeachment. We don't even get there in our case because of the two problems, the rule being bad and because of the resolution being bad. So we would submit that that which I'd argued before lunch and the kinds of relief that we speak of should be granted. As far as delay is concerned, this is not one of the 4 points. That's the kind of issue which, and I have no instructions, so my client is sitting behind and I can ask him, but it's the kind of point that perhaps, at worst, for my client, I can't speak for the EFF, it could be dealt with how you deal with costs. Some kind of balm against the notion of success. Let's say we win, we succeed in something or other, but you're disappointed with the delay. You might say something about that in how you do. You might. It's wholly within the court's discretion. Say whatever you want. So that's how we would articulate our replying oral submissions. Thank you, Chief Justice.
Mr. Katz, there's something I must correct. It's not that your argument was very bad or it was very good. It was you missed the argument.
Excuse me, I missed it.
Missed the argument about the political interference. Mr. Nukatobi took some time arguing that it wasn't political interference. His argument was that it was based on legal reasons. When he spoke about, let's just, I see you shaking your head, let's just talk about it. You say that those paragraphs 192 to 194 of EFF2 says there mustn't be political interference in those phases, right?
No, sorry, perhaps that was my third point. And
yes, I'm on the third point.
But the ANC only dealt with, if I understood it correctly, and correct me if I'm wrong, the question of the resolution. Didn't deal with the constitutionality of the rule.
Oh, I see.
So I only use
dealing with the constitutionality
I'm only talking about 129 to 194 as far as the rule is concerned.
Okay.
So it's got nothing, I didn't hear a word about one.
All right. No, I must urge you. It's been a long day.
Okay. All right. Looks like we've reached the end of the long day. Thank you, Mr. Katz.
Thank you.
Court is indebted to all counsel for the submissions. Judgment is reserved. Court adjourns.